Good afternoon. Good afternoon, everyone. Welcome to Senate Finance. Today is Thursday, February 16th, 2023. We have 9 bills for consideration by the committee today, and they will be heard in the following order. Senate Bill 337, 352, 284, 367, 258, 299, 298, 247, and 259. And committee members, we have 130 witnesses signed up to testify on bills today. So for the audience, please pay attention to the time clock when you come up to speak. We'll try to keep to the time limits today so that we can be respectful of those who have later bills coming up. We're going to start with Senate Bill 337, which is utility contractors, employment and licensure requirements applications. As Senator Guile brings her panel forward, please everyone understand that our committee members are presenting bills in other committees. So if you see members leave throughout the briefing, it is no disrespect to your bill. It is that they are likely presenting bills in other committees. Thank you all for being here. Senator Guile, you can begin when you're ready.
Thank you, Madam Chair and fellow members of the Senate Finance Committee. For the record, Senator Dawn Guile, District 33, here to present SB 337. At the outset, I would note that if this bill seems vaguely familiar, it is because it is very, very similar to SB 170 that we are voting on later today. Both bills set labor standards for utility workers. The difference is that Chair Feldman's focus on his bill is on those working on the generation of power, whereas the bill I'm presenting here today, SB 337, is focused on those working on the distribution of power. So line workers, essentially. So with that said, colleagues, the lights that illuminate this room and the energy that allows us to broadcast this hearing to the public is made possible by the electricity grid that distributes energy from generation sources to homes, businesses, and other end users around our state. The grid refers to the lines, poles. Oh, sorry, I'm being broadcast behind me, I guess. That's the line work. Okay. The grid refers to the lines, poles, transformers, circuits, substations, underground and overhead power lines, and more. The reliability and resilience of our grid not only hinges on strong physical infrastructure, but also well-supported human infrastructure. Last year, we passed the Climate Solutions Now Act, and to meet ambitious climate goals, the law provides a framework for historic investments in our electricity distribution grid. The clean energy transition and projected increases in electrification of buildings and the transportation sector cannot happen without significant investments in the electrical grid over the next several decades. Electrical line workers will be the people implementing these crucial improvements, updates, and maintenance projects. These are the men and women that are out during severe weather and its aftermath to get electricity services back on for residents. This bill would ensure that as we make the necessary investments in the grid, we are also investing in those women and men as well as their families. Indeed, this bill supports family-sustaining jobs by expanding the following requirements to all electric distribution grid projects, regardless of whether the project is funded with federal resources, including pay the area prevailing wage, offer healthcare and employment benefits, participate in apprenticeship programs registered with the state or U.S. Department of Labor, and develop a plan to recruit and retain state residents, including returning citizens, minority individuals, women, and veterans, and comply with federal, state, and local wage and hour laws for the previous 3 years. Prevailing wage not only provides immediate financial benefits to working families, but they have several secondary benefits, including decreasing government spending on social safety net services, stimulating the local economy and increasing state and local tax revenue, reducing occupational injuries and fatalities, lowering future maintenance and repair costs, and increasing the pool of skilled workers. To sum up, this bill strengthens Maryland's ability to meet its climate goals, brings parity to the labor market for investor-owned utilities, while doing right for working families and the state's broader economy. And therefore, I respectfully request a favorable report on SB 337. Madam Chair, do you want me to go ahead with my panel? Thank you.
Thank you, Senator Guile. Good afternoon, Chair Griffith, Vice Chair Klausmeyer. My name is Mike McHale. I'm the business manager of IBW Local 24 in Baltimore. I'm an inside wireman. I'm not a lineman, but I work with linemen a lot out in the field. Big part of this bill for us is the apprenticeship and training. It's a very dangerous industry, and there is currently no required apprenticeship in that industry. The IBW folks get their training, 3-year program, but people can show up on a job and within a month be up in a bucket truck with their hands on 15,000 volt conductors, 33,000 volt conductors, all the way up to 119,000 volts. When our union was founded 100 years ago, the reason why it was founded was 50% of the workforce was killed on the job. And my part of the industry really didn't exist at that time. So this is a good bill. Prevailing wage, retirement, health insurance, and apprenticeship training will move the citizens of Maryland forward. And I respectfully ask you to report out favorably. Thank you.
Thank you, Madam Chair, Vice Chair, committee members. My name is Jeff Guido. I'm here on behalf of the Baltimore DC Building Trades Council. We also support Senate Bill 337, obvious reasons for the apprenticeship training with the increased wages and benefits as health insurance and pension plans. We also support the reach out to underserved communities, the returning citizens, veterans, women, and minorities. Former Congressman in Oakland of California, Mayor Roy Dellums did a study entitled The Way Out, and it was to find out why there was generational welfare within the inner city and the younger people weren't getting a way out, and it was a lack of opportunity. All of our construction contracts include that language to reach out to those individuals, usually in targeted zip codes, to provide them an opportunity and create a career path to the middle class. And we support the bill for those reasons. Maryland's the highest median income of any state in the country, and consequently the lowest percentage of persons living in poverty. And that has to do with your wages and your income. And we ask for favorable report. Thank you.
Thank you. Senator Hershey.
Thank you, Madam Chair. Just to make sure I understand the bill. Currently, this law only applies if a investor-owned utility project is receiving federal funds. Is that right?
That's correct. So this would expand to all projects.
So all projects. So anything that an investor owned utility, any type of work that they do would now have to go under prevailing wage law?
Right. This law specifically, this bill would specifically relate to the distribution of power, but that's
Right.
correct. Yeah.
Right, correct. And those, then those types of projects are able to be billed back to ratepayers through their fees, right?
So if you look under the fiscal note, it says DLS believes the cost for the affected projects going forward may increase by 2 to 5%. That does not mean that utility rates will likewise increase by 2 to 5%, because rates are also based on the sum total of underappreciated utility, of which labor costs for construction are only one component. So it's not to say that that's definite outcome.
Right, but
Right.
I don't see the utilities here in support of the bill. Have you spoken with them?
And I have not, Senator Hershey.
Obviously, this bill is geared toward union labor, right? I mean, Jeffrey, that's why you're here. This is very specific that is it the feeling that only unions can provide prevailing wage, or why do we not see anybody else here in favor of
The
this?
state determines the prevailing wage,
Right.
Senator. There's a survey that's sent out annually, and it's the same survey for everybody. You know, there's no one for unions and one for non-union. It's the same survey, and those that respond, the majority sets that prevailing wage.
Right, so any whether it's a union shop or a merit shop, anybody can pay, any contractor can pay prevailing wage, right?
That's correct.
So it's not just for union shop, but there is a potential, as the fiscal note says, and Senator, as you mentioned, costs can go up on these projects as a result of having to pay a prevailing wage, or maybe not being able to be as competitive for the investor-owned utilities, that they are now having to adhere to a certain pay scale.
Is that question for me?
Yes, ma'am.
Senator?
Yes, sir.
There is a certain amount of extra cost involved, and some of that is due to the paperwork and filing prevailing wage reports back to the state. But there's also been many studies done that prevailing wage does not increase costs. And we presented that report when we had a hearing several years ago. We did a summer study with former Senator Mac Middleton, and it was determined that prevailing wage did not increase construction costs.
Okay, well, again, I'd certainly like to hear from the investor-owned utilities on their thoughts on what the requirement then would be on them then to require prevailing wage and see if they thought that this would potentially increase ratepayer cost. So maybe we can get some information from them.
Okay, thank you, Senator.
Thank you. Thank you, Madam Chair.
Thank you. Senator Beidle.
Thank you, Madam Chair. And I have a question for Mr. McHale. Would the bill include the wind turbine technicians that are going to be doing the work on the wind turbine?
No, Senator Beidle. This is just overhead transmission and distribution work.
Thank you.
Thank you. Are there any additional questions for the sponsor or her witnesses? Seeing none, thank you very much. That concludes the hearing on Senate Bill 337.
Thank you, Madam Chair.
Thank you. We're going to turn to Senate Bill 352, Senator King. And let me just say to the committee, we want to welcome visiting us from E33E committee. We have Senator Washington, who's representing that committee and will be here for the next three bills. So Senator King is going to present 352. If you have any panelists, you can feel free to bring them forward.
Okay, thank you, Madam Chair. And I hate to have to read my testimony and run, but I have a subcommittee waiting to start across the hall. So I'm going to, but I did feel strongly enough about this legislation that I wanted to present it myself. So I will be here and then let my panel take over, okay?
Sure. And we'll pause after you speak in case there are any specific questions for you. And then we want you on that budget. So we'll let you. All right.
Thank you.
thanks.
Madam Chair and members of the committee, despite working in the public sector, the majority of library workers across the state do not have the same rights as other public sector employees to collectively bargain. Senate Bill 352 grants collective bargaining rights to library workers across the state and establishes an equitable process for library workers to select exclusive representatives that can bargain with employers over conditions of employment. And while Senate Bill 352 will establish the right to collectively bargain, it will also establish the choice of entering into a collective bargaining agreement. Under this enabling legislation, library employees can make the choice of whether they want to enter into a collective bargaining agreement. Our library workers are dedicated professionals who provide a great service to our communities, and they deserve the same equal treatment and representation on the job that is afforded to other public sector employees. And I ask for a favorable report.
Thanks. Any questions specific to the sponsor? Looks like you can go. Thank you,
Thank
Madam
you.
Chair. All right. We can hear from the witnesses. Whoever's closest to the mic, you can get started. Just identify yourself if you would before you speak. Thanks.
Thank you so much. My name is Laura Ewan. I'm the Associate General Counsel with the International Association of Machinists and Aerospace Workers, and I'm honored to be here today to speak to you about SB 352. As you know, in Maryland, each county library system exists as a creature of state statute. State law allows for operations and structure to be dedicated to the Board of Trustees or the county government to run the library system as is appropriate for their county. But those state laws do not automatically grant them the authority to enter into a binding collective bargaining agreement if their employees were to unionize. And that's what this bill would do. It would grant that authority to each employer, whether it be the Board of Trustees or the county, that would then allow them to enter into a binding collective bargaining agreement. Some counties across the state have already gone through this process. They've come before you and they've asked for this grant of authority. But having to do it on a county by county by county basis is ineffective, inefficient, and it ultimately asks for inconsistencies in how these employees get access to the right to unionize should they choose to do so. After the success of passing the Baltimore County Public Library System legislation, we heard from library employees across the state who wanted to see the same thing happen in their counties. And it makes sense for your busy schedules, as well as for these employees, to address it in a statewide bill. And that's what this bill does. Before drafting this bill, we carefully examined existing collective bargaining laws across Maryland counties, ones that specifically apply to state library systems, and as well as longstanding labor standards. The most common components are what you see before you in this bill, because my years of experience as a labor law attorney and having drafted multiple pieces of legislation to address workers' wages, hours, and working conditions across this country, it's taught me that the best practice is to be as consistent and straightforward as possible. And that's what this bill does. It ultimately strikes a balance between protecting workers' constitutional right to freedom of association with the library administration's obligations to run the library system effectively. So we ask for your favorable report on this bill. Thank you.
Good afternoon, Chairman Griffith, Chairwoman Griffith, Vice Chair Klausmeyer, distinguished members of the Finance Committee, as well as Chairman Feldman, Vice Chair Kagan, and distinguished members of the Education, Energy, and Environment Committee. My name is Anita Bass. I had the pleasure of testifying before many of you during the 2021 session when I spoke in favor of the collective bargaining legislation for Baltimore County Public Library. I come before you as the first local lodge president of BCPL I Am United. In our first contract, we negotiated wage increases, improved benefits for our part-time staff, and created a labor management committee to address all issues in the workplace. Having a union isn't a promise of perfection, but it is an avenue for staff to have a voice and participate in the process. Now we are in the midst of negotiating our second contract. It has been a learning process for both the union and management, but we are committed to working together for the best library system possible. Senate Bill 352 will provide a uniform and consistent process for my colleagues in other county library systems to organize for collective bargaining rights if they choose so. Library workers without an interest in organizing a union will not be affected. Unionizing may not be what every library system wants. That's fine. Senate Bill 352 doesn't make libraries unions unless and until they choose to organize and win an election. For those systems who want to become unions, Senate Bill 352 removes the need to repeat this legislative process piece by piece, county by county, session after session, over and over again. On behalf of library workers across Maryland, I ask that you vote favorable on Senate Bill 352. Thank you for your consideration and time.
Good afternoon, Chairwoman Griffith, Vice Chair Klausmeyer, distinguished members of the Finance Committee, as well as Chairman Feldman, Vice Chair Kagan, and distinguished members of the Education, Energy, and Environment Committee. I am here today to urge your support of Senate Bill 352 as it was introduced. My name is Morgan Michael, and I have worked in an unorganized system for almost 16 years. I'm proud of the work I do and the communities I serve. But honestly, my system is not the stellar system it used to be. Changes have been made to our structure that leave voids in our service models, lower staff morale, and result in the very best people leaving. These issues existed before the pandemic. Last session, my coworkers and I worked with Delegate Steve Johnson and the IAM to pass enabling legislation. Our own county delegation urged us to work directly with the board and our administrators. We tried. Imagine our disappointment when our board easily dismissed our concerns and the chairman stated they did not want to become a suggestion box. We did not feel heard. My system is broken, but we're hopeful that it can be fixed. And I know mine is not the only broken system. I am not the only hopeful librarian. To protect and preserve libraries across the state of Maryland, workers need a seat at their table, a voice in the room. We need to be regarded and respected as experts in our fields alongside our administrators. The passing of SB 352 will do just that for the systems that need it, be it right now or even in the far future. I call on you to assist our library workers by issuing a favorable report for this collective bargaining bill, and I thank you for letting me be here to speak today.
Thank you. Senator Ellis.
Thank you, Madam Chair, and thank you, ladies, for your testimony. I think I have a question for Ms. Bass. You speak about your library system, and it sounds like you said in your system, you're unionized already.
Yes.
And so tell me which system, which county you're in, and how does that happen? And,
Baltimore County,
okay,
and we actually went through the process. I'm sorry.
Sorry.
Baltimore County, and we actually went through the process of creating a bill and passing a law, passing a bill and creating the law.
so a local bill went through Annapolis, the Maryland General Assembly to
Yes.
authorize Baltimore County
Yes, we had to do
it.
that.
Yeah, so do you know how many other localities have that kind of legislation authorizing them? And
Yeah, I'd be happy to. Yes, actually. So Prince George's County and Montgomery County went through this process in the 80s. So they've had enabling legislation since then. Howard County passed one in the early 2010s, I want to say 2013. And then there's Baltimore County, which happened in 2021, and the Enoch Pratt Library System recently enacted theirs as well.
okay. So this bill would then, thank you for that answer, ladies. So this bill would then allow each jurisdiction not to have or have to go through individual local authorization. This will be statewide.
It would be for all the rest of the localities who do not currently have existing collective bargaining statutes. So the rest of the state, yes.
Okay, all right. Well, thank you. Thank you, Madam Chair.
Thank you. Senator Beidle.
Thank you, Madam Chair. I think my questions are for the attorney. Ms. Ewan, is that right?
Ewan, yes, thank you.
Ewan, thank you. So would you then be the representative, your union would be the representative for all of the libraries statewide?
Well, as much as we'd love to organize that, the bill itself does not actually predetermine that. That's up to the workers themselves to determine. So workers typically reach out to a union. They've done their homework, they've done their research. They might ask us, they might ask another union. But in this bill, there's no predetermination of that.
And are you currently representing all these other counties, Prince George's, Montgomery, Howard, Baltimore County, and Pratt?
No, there's actually several unions who do. We are representing Baltimore County. AFSCME and UFCW represent some of the other systems.
And does each county make the decision who their union representative will be, or?
The employees do. So the
Of
workers
each
do.
county, there could be all different ones.
It could be all different ones. Absolutely.
Okay, thank you.
Sure.
Thank you. Any other questions for this panel? Seeing none, thank you very much for your testimony.
Thank you.
We're going to invite up Donna Edwards, Chris Apple, Morgan Miller.
It's all right. We're gonna pull them out anyway. Right?
Good afternoon.
Good afternoon. This is my inaugural testimony for this committee. So I love it. I'm Donna Edwards. I'm president of the Maryland State and District of Columbia AFL-CIO. Thank you, Madam Chair and Madam Vice Chair. It's lovely to be able to say that. And thank you, committee. And I think that the panel before me did an excellent job of laying this out. What this does is take a disjointed approach that we have from county to county, and it makes it an equitable process for how workers in all the other libraries can go about joining a union, seeking a union, having representation. And all of our unions would follow the same process, the same law. So it really provides equality across the state, equitability to the workers. And at this point, we have several locations that are very interested, but some of the local laws moving forward are kind of murky. And this also prevents management interference with workers who are trying to organize. It is mirrored after the law that you passed last year. I mean, for Baltimore County, I think 2 years ago. It's been well vetted out by lawyers and looked at all of the ordinance in the county so that it doesn't, disagree with what's already on the books. And in fact, makes it much stronger to allow workers, if they so choose, if they want to proceed having a union, it will be a union of their choice. It will be one that they reach out to. It'll be one that they work for, and nobody has cornered the market to help this committee, which is our finance committee, understand it. So with that, I really do we strongly support the bill, and I ask for a favorable report for Senate Bill 352.
Madam Chair, thank you. Committee members, I am Chris Apple. I live in Columbia. I'm here today because I believe that our library employees are an extraordinary resource for our state and for our children. and I believe they deserve a chance to organize. Libraries are so much more than just a place where we borrow books. They serve as community centers. They offer internet to people who don't have it. They offer public meeting spaces, and they offer children's programs and teens programs after school. I hear that some teens have never felt more understood or accepted than when they're attending one of those programs. And the library, the building itself, has nothing to do with it. It takes an extraordinary library staff who wants to get out of bed every day and really make a difference in their communities. It requires great skill and dedication and passion to make an impact like that. And we already recognize the need for teachers and state employees to organize. They have demanding jobs with unique difficulties, and organizing gives them a way to highlight the good that they do and to ask for safe and fair working conditions while they continue to develop our children. But it's important to remember that library employees are educators too. They are mentors and role models and public servants. They too have demanding positions, and they make personal sacrifices to serve their communities. They deserve that same chance to organize, to ask for those safe and fair working conditions so they can keep serving the public that they love. Maryland is said to have some of the best library systems in the country. If that's true, it's only because we have the best library employees in the country. With such an incredible resource, let's show them we appreciate it. Let's pass this bill. Thank you very much.
Good afternoon, Chairwoman Griffith, Vice Chairwoman Klausmeier, members of the Senate Finance Committee, and my own Senator, Steve Hershey. My name is Morgan Miller, and I serve as the Executive Director of the Cecil County Public Library System, which is, I will add, one of the best library systems in the country because we won the national medal a few years ago. I'm also the chair of the Intergovernmental Relations Group for the Maryland Association of Public Library Administrators, which represents the leadership of all 24 public library systems across the state. And I'm testifying on their behalf today. I certainly will acknowledge that librarians and library workers are probably the best people on the planet, having worked with them for 18 years, and you all celebrated that fact with us yesterday during Legislative Day. But today I'm really here to ask for your support of this bill with amendments to make sure that it's most effective when it's enacted. Statewide enabling legislation that addresses the process of collective bargaining has been needed for some time. For the past several years, the process to enable collective bargaining legislation in public libraries has been handled on a county by county basis. And this approach ends up resulting in a lot of extra time, expense, and effort for the county libraries governing boards, for the county government, as well as for the General Assembly. At the end of the last session, the Maryland Association of Public Libraries Administrators was encouraged by leadership within the General Assembly to draft enabling legislation for collective bargaining for introduction this session. Prior to filing our bill, Delegate Johnson pre-filed House Bill 65, this cross-file, which attempts to correct the problems that I've outlined. The bill that we proposed was recently filed by Senator Beidel. That's 680, and I'll probably be back to talk about that soon. We've sought the opportunity to collaborate with Delegate Johnson and members of the House Appropriations Committee to offer important input and amendments that improve and increase the effectiveness of the bill, most notably to bring it into compliance with existing library statute, governance, and operational environment. And so far, we're optimistic we're able to do so. So we ask for your support of this bill with amendments. Thank you.
Thank you. Senator Hayes.
Thank you, Madam Chair. I think Ms. Miller, you testified with favorable amendments. I didn't catch what the amendments was, and we don't have the written amendments.
Sure, we have a list of the amendments I'm happy to supply for you that the subcommittee is working on. The majority of those look at things like that there needs to be 2 bargaining units based on the nature of how a library works. Right now, the way that libraries are governed in the library statute, which is somewhat unique, HB 65, SB 352 doesn't quite reflect that. The boards of trustees, which are the governing bodies of the library system need to be more involved in the mediation and processes before things like that go on to county governments for negotiation. There's some timeframes in there. The director only has 7 days to turn around a petition to a bill, and some other things that we just want to work to align with the operating environment. I'm happy to supply you with the list. Our conversations so far with Delegate Johnson and the House Appropriations Subcommittee have been very productive.
No, I appreciate that. If you could just get that to the committee, we greatly.
Sure.
Thank you, Madam Chair.
Thank you. Senator Washington.
Thank you, Madam Chair. Thank you all for testifying, and thank you for this bill. You made reference to teachers, so I just want to draw some parallels or help. So generally, if workers want to form a union, they can go through the NLRB, right? Is it the case that that public employees are exempted from that? So they're not allowed that right just right out. Is that correct?
That's correct.
Right. So therefore, in order for a state to allow that, to have an exemption, so to allow that, then the state has to authorize, I guess, classifications of employees. So is that
Yeah.
correct? Or how does it work?
Library workers are in a predicament because they are not state employees. And so under the state collective bargaining bill, yes, the state defined what each of those bargaining units are.
Okay.
But these are public employees.
No,
And so they have, and they do, there's some governance from trustees, but the bulk of the money is coming out of the county government, and it's coming from you all. Even in this year's budget in House Bill 200, you have $96 million for the library system. In addition, you have 3 more bills coming forward asking for more money to go in to the library system. So there's a tremendous amount of state dollars that goes in. And unlike what the amendments, we have not been in favor of any of the amendments coming forward. And so there's not been a discussion of what those amendments are going to be. There's a list of things that the libraries would like to see, but quite frankly, timing when unions can develop cards and giving cards to management of workers that are interested just flies in the face of real, true collective bargaining without interference from management. So, but yeah, they're in this.
So they're in this space. So we
Yes,
need
they're
to, so
in
we
this
need
space.
we need to make a decision, basically.
Yes.
Okay. So teachers are state employees, or is it similar that teachers are the employees of each of the local?
Senator
So
Washington, I
teachers
have
and-
great respect for you, but you're asking me to go into the weeds. And
Well, I
I'm
mean,
not
I need
quite
to-
sure
Okay,
about,
I'll ask-
yes,
Then
teachers.
I'll ask someone.
Please,
It's just
thank
that
you.
you drew the parallel.
Well,
And so if
excellent.
it's something that we've done already in a sector, which
Oh.
are teachers, which also have 24 different, entities, and you're making a similar argument that there are 24 separate entities that all provide a service to the state, then so that's why I was trying to understand the parallel.
I think the parallel's equal because it is that they are county to county, but there's still a state administration of education. And it is the similar all across the state, county to county, how the workers collectively bargain.
Okay,
Correct.
And do we have a state entity that coordinates libraries across the state? That's the mayor, maybe one of the.
Sure. Our governance structure is that the Maryland Library Statute gives authority to a governing board of trustees in each county, which are nominated and appointed by the county executive or the county leadership. And they have the fiduciary, the legal, all of that responsibility for the library system. So we are actually employees of the boards of trustees. And that piece is missing their important authoritative role in that from this current legislation.
I see somebody shaking their head. Maybe you can answer afterward. All right,
Sure.
thank you. I probably should have asked the first panel. Thank you. Thank you very much, Madam Chair.
Thank you. I don't see any additional questions for this panel, so thank you very much for your testimony. We do have one virtual witness on this bill, and so we'll hear from Brianna January. Good afternoon.
Good afternoon, esteemed committee. Brianna January with Mako in respectful opposition to SB 352. Committee, I promise that county opposition is in no way related to the merit of collective bargaining and is completely budgetary. In fact, committee, as you've just heard, there is another library collective bargaining bill, SB 680, brought to you by your own colleague, Senator Bidel, that counties are completely fine with. And you've already heard that that bill includes an important clause mirroring current law for collective bargaining for our K through 12 systems, as well as community colleges, where counties can send the two parties back to the bargaining table if financial constraints prevent us from filling a contract. The bill before you, unfortunately, SB 352, does not have that, that reasonable critical guardrail. Committee, counties pride themselves in supporting our public libraries. In fact, all 23 counties and Baltimore City, all of your counties, are currently funding our library systems above and beyond statutory requirements. Unfortunately, state funding has lagged for years, and with no additional state support offered in SB 352 and no financial guardrails like SB 680 does offer, counties would ultimately be left with an unfair, hefty bill to pay, and the fiscal note for this bill does agree. Committee, unfortunately, this could come at the expense of the no and low cost services that libraries provide our mutual constituents, and neither of us want to see that. For this reason, Mako opposes SB 352 and does urge an unfavorable report. Thank you.
Thank you very much. Senator Kramer.
Thank you, Madam Chair. Yeah, quick question. So you're saying it's the position of Mako that they are just opposing a bill that would provide these hardworking individuals with the option of availing themselves of collective bargaining rights. Am I understanding that correctly?
Senator, thank you for the question. As I noted, counties have no opposition to the merits of collective bargaining. In fact, we are perfectly fine with—
that wasn't my question. I appreciate that, but if you'd answer my question, I'd be most appreciative.
Sure, counties are in opposition to SB 352 because it does not include that guardrail that you've heard other folks mention as well that we currently have for K through 12 bargaining as well as community colleges. We just feel that library systems should have the same if we're going to go ahead and collectively bargain.
So is it your assertion that these are employees who are so very happy with the working conditions that they have right now that Mako believes, why do you need this? You know, everybody's going to be very happy and content right now. And if that's the case, then they won't avail themselves of the opportunity to have a bargaining unit. Would that not be an accurate statement?
Senator, respectfully, that is in no way what Mako is urging here or is assuming. We value our employees greatly. We have several counties that have already established bargaining units. Again, we do not have an issue with the establishment of bargaining units. We want to provide the absolute highest services for our constituents, and the staff, as you heard, are key to that, and we take care of our staff as best as we can. That said, this is missing a critical piece of law that we have for other bargaining units for other sectors, and we're just hoping that we can have that added on, and in that manner, we again have no problem with Senator Bidel's bill that actually has that piece.
Well, we're not discussing that bill at the moment. We're discussing this one. And
sure,
so
just making comparatives.
I will just wrap it up. If I understand correctly, Mako's position is that they want to embrace the employees, that it's a hug fest, but when it comes to giving them the opportunity to have collective bargaining, if they so choose, that's as far as the hug fest goes. It ends at that point, and Mako says, no, it's enough hugging. But thank you for that. Thank you, Madam Chair.
Thank you, Senator. I don't see any additional questions for this witness. Thank you very much for your testimony. And that will conclude the hearing on Senate Bill 352. Colleagues, we're going to turn to Senate Bill 284, which is the Trustees of Walters Art Gallery Collective Bargaining. Senator Carter, I think I saw her. I saw her a moment ago. Hmm. Looks like her panel's here, but we'd love to have the sponsor up. Oh, there she is. All right. Good afternoon, Senator. You can proceed when you're ready.
Thank you, Madam Chair and members of the committee. I do have one add to my sponsor panel that you may not have and that may not be up here, which is Mr. Willie Flowers from the Maryland State Conference NAACP. I just saw him in the hallway, but he might not have realized the bill was up, but if he comes, please allow him to join. Thank you. I'm proud to sponsor this bill, Senate Bill 284. It has already passed the House Delegation Committee, and it'll be heard in our Senate delegation tomorrow morning at 8 o'clock. And so it's well on its way forward. This legislation is simple and straightforward. It creates a clear and fair process for workers at the Walters Art Museum to gain recognition of their union and enables their collective bargaining rights. Workers have been pushing for upwards of 2 years to gain these rights. We've seen these workers organize together and remain clear in their conviction that they want a union at the Walters and a fair and inclusive process to get there. We have met with many of these workers and we have heard their stories of employees going for decades without meaningful promotions and increases in pay that are needed to support them and their families. Stories of employees whose accommodation requests have been refused by their employer, forcing them to work in untenable conditions. And stories of employees who were sent home sick from unsafe workplace conditions with no recourse or acknowledgement from the management until they came together and demanded their leadership address basic workplace safety issues. Workers at the Walters are organizing for the same basic workplace conditions that we all deserve. Fair and family supporting pay, clear paths to promotion, transparency across the museum, health and safety protections, parental leave, and equitable retirement system. The Walters Art Museum is a state-created entity born as a result of a 1933 statute of the Maryland General Assembly. The General Assembly has often acted to enable collective bargaining rights for public workers, from the Baltimore County Public Library to the public defenders across the state of Maryland to even the Baltimore Police Department. I am urging a favorable report. One way I believe that we save and promote the Walters is by protecting its workers. Thank you. I'd love for you to hear from my panel, and I will stay for questions.
Thank you. Good afternoon. My name is Denise Gilmore, and I'm a legislative director with AFSCME Council 3. We thank the senator very much for bringing this legislation forward. In the spring of 2021, employees at the Walters Art Museum in Baltimore announced that they were forming a union. SB 284 is important to do two big things. One, because of gaps in Maryland labor law, Walters employees currently have no process to have their union recognized. This legislation would correct this oversight. A similar gap existed for the Baltimore County Library workers in 2021, as you just heard, when collective bargaining legislation was passed to correct it there. And again in 1982, when the General Assembly passed legislation to create a union recognition and collective bargaining process for the employees at the Baltimore City Police Department. Attempts to get management at the museum to enter a voluntary election agreement, which would also achieve union recognition, similar to what was done with the Baltimore Museum of Art and Enoch Pratt Free Library, have been unsuccessful so far. This is where both parties agree that a neutral third party will conduct a process to recognize their union. That is either through card check, which is where a majority of employees are on signed card, or an election to verify that the union has majority support. If the employees choose a union, the voluntary agreement also stipulates that the parties will bargain in good faith. The second major reason why SB 284 is necessary is that once the union is recognized at the Walters and collective bargaining is enabled for these public employees, those collective bargaining rights need to be placed somewhere. And this bill places those collective bargaining rights under the authority of the Baltimore City Labor Commissioner. That is because they are more of a city entity than a state entity. I'll wrap up by saying, these courageous workers have been organizing for 2 years for collective bargaining rights under very difficult circumstances. You will hear more from them. And we also have Teague Patterson, our counsel, here to answer, more specific questions and elaborate on that. But we urge your support and favorable recommendation for SB 284. Thank you very much.
Good afternoon. My name is Will Hayes. I'm an associate registrar at the Walters Art Museum, and I've worked at the museum for more than 10 years. For 2 years, workers at the Walters have been organizing and fighting for collective bargaining rights. Not once have we met with our executive director to even begin discussions, not even a conversation. At the Maryland House Appropriations Committee hearing, our director said she would be open to receiving a union election agreement for the very first time. We turned one around in a little over a week, and she responded with leadership's own proposal. I was so excited to receive it, but so disappointed to read it. Our agreements are very different. The museum's proposal contains conditions I would not want any of my coworkers to agree to. I honestly can't say that it was offered in good faith. For over 10 years, I've seen wage stagnation, high staff turnover, positions being eliminated with duties assigned to other employees with very little substantial increase in compensation. One example being my own, when I assumed the responsibilities for some of our most critical databases when our full-time database administrator left and the position was never filled. I have seen so many dear coworkers leave, not all because they wanted to. It's hard not to feel frustrated when I see people pushed out by low pay, increased workloads, and unsustainable working conditions. We need a say as workers who make the museum possible. We need guarantees on the conditions of our employment and on our own safety as workers. We need collective bargaining. One of the meeting norms of staff meetings at the Walters is to assume good intentions, and I do that. The actions and responses of the museum's leadership makes that increasingly difficult. Thank you so much. I urge you to support and advance SB 284.
Thank you. My name is Teague Patterson. I'm general counsel to AFSCME, and thank you for allowing me to present. I wanted to address really a straightforward issue that's been vexed, I think, for really strategic reasons only. And that's the issue whether the Walters Art Museum is subject to the legislature's authority as to its employee relations. And the answer, we believe, and many others believe, is clearly yes. The Walters was created by the legislature. The legislature endowed the city with oversight over the Walters, and subsequent enactments by the legislature have given the city more and more authority over it. And just yesterday, the Attorney General's office affirmed these conclusions, that the Walters is an instrumentality of the state and city of Baltimore, and that this legislation before you is proper. I uploaded a large number of documents as part of my testimony. These are documents that establish that really for almost a century, the Walters has held itself out as, and the government has considered the Walters to be an instrumentality of the state, a public entity. And that was true, again, for over 80 years, since the 1930s, until one thing happened. And that one thing is that its workers decided to form a union. And then after that, the Walters management decided that, in fact, it wasn't a public entity, and that the only entity that has jurisdiction over it is the National Labor Relations Board. That's clearly incorrect. And every individual or court that has looked at this has determined that the Walters is a public entity and an instrumentality of the state. And that includes the Circuit Court of Baltimore, the Maryland Appellate Tax Court, the Federal Department of the Treasury, which granted Walters tax exempt status on the basis that it's an instrumentality of the state. And the Attorney General just yesterday, the Attorney General's office, I should say. And so there's really no authority to have determined otherwise, that the Walters is in fact a public entity. So I thank you for hearing me out. And I respectfully ask a favorable report on SB 284. Thank you.
Good afternoon, Chairman Griffith and the committee. I'm Willie Flowers, NAACP Maryland State Conference President. I'm here just to chime in support of the workers at the Walters from a few perspectives. Number one, as everybody knows, Baltimore is the center of travel and tourism for the region, really for the state. And the Walters Art Museum fits into that perfectly, because it's one of the longest serving museums in the city. And I had the value of living a couple of blocks away from there several years ago and spent a lot of time there. I've seen the diversity, not just the diversity of the exhibits, but the diversity of the employees there, And they really are committed to what not just the museum is about as an entity for the city and the state, but they are also residents of the city of Baltimore. And it was unfortunate because I thought that, quite frankly, because of the magnitude of tourism in the city of Baltimore and the state of Maryland, that they would be unionized. But it was unfortunate to find that they were not. And that kind of eliminates the beauty of the city when you know that people who are dedicated to an entity like a museum, which is a staple to the city, are not protected with collective bargaining. And because of that, and because of the reality of what we've experienced in NAACP since 2017, with the aggressive behavior of some employees who crack down on employers, who crack down on employees who don't have protection, we think that this is the right way to go so that families can have the security of being not just supporting their city, having long-term employment, but also being protected with collective bargaining as long as they wish, and also to have the benefits that come with that, whether it's pension or retirement or whatever. And if that's not the case at the Walters, it should be. Thank you for the opportunity, and we certainly hope that you support this bill.
Thank you, Senator Guile, then Senator Hershey.
Thank you, Madam Chair. First of all, I love the Walters. I'm going to say that at the outset. But second, I wanted to ask, I guess this is more a question for the legal counsel. What's what is that? The Walters, what's the form of entity that it is?
It's the Walters is a public, a state incorporated entity owned by the city of Baltimore, the administration of which has been entrusted to a board of trustees pursuant to state statute.
Okay, it's a state incorporated entity. And so I take it, is it a corporation? Is that right?
It's a state corporation. It was created before the modern private incorporation code was adopted. So.
And you mentioned that it has tax exempt status. You know, what kind of under the IRS code, what's
as a governmental instrumentality.
And what number would that be? Do you know?
I don't know, but I don't think it's a number. It's not a 501c3 if that's what you're asking.
Well, I assume it's not a 501c3, but I'm curious if there's under the IRS, under the tax code, if there's a specific
there is
designation for it.
Yeah, there is a provision of the tax code. I can look it up, but that tax code describes governmental entities and their instrumentalities. So that's how it's defined under the tax code.
Okay. Okay. And I know you had mentioned that there were a few courts that had determined that the Walters was an instrumentality of the state. I know you touched upon the Circuit Court of Baltimore City, and that was in relation to a Maryland Public Information Act and whether or not they have to comply with the Public Information Act requests. Is that right?
Yeah, that's correct. The standard that's used under the MPIA is also the standard that's used under all state statutes to determine what is or is not a public instrumentality. So yes.
Okay. And the other court opinions that you had touched upon, what were the basis for those particular courts having to analyze what the entity, I guess, is, or whether or not it was an instrumentality of the state?
Sure. The one that I had in mind is called Trustees of Walters Art Gallery versus the Supervisor of Assessments of Baltimore City. And the holding in that was that because the Walters is a instrumentality of the state, any income it earns through private activity. In that case, it was by running a parking garage open to the public is taxable income because it's not, that particular function is not a governmental function, whereas the act of running a museum is a governmental function as defined by the statute that created the Walters to begin with.
Okay. And I won't belabor going through each of those. Have those opinions been provided at all in the materials that we have received? Do you know?
We did include the MPIA case. I know I included that as tab 13.
Okay.
And I can give you the site for the Maryland tax case if that's helpful to you. It's a Westlaw site.
Yeah, that's fine.
Okay.
And just one more question, Madam Chair. Thank you. Is, I'm just so I'm understanding this, because it's not that I've heard something where like a particular organization becomes like a instrumentality of the state, and I don't know what the legal precedent is, but there's legal precedent for this occurring where an organization, regardless of its formation, you know, whether it's a corporation or LLC, whatever it is, that's a private organization is being considered or determined an instrumentality of the state.
Well, I think I know what you're driving at. And I think you might be putting the cart before the horse. The question isn't, is the Walters becoming an instrumentality of the state? The question is whether it is an instrumentality of the state, and it always has been since the 1930s when it was first established. So I'm not sure. This bill certainly doesn't change that. It just confirms what's been true for the past 80 years, which is that the Walters is a public entity. It has a board of trustees, many of which are ex officio members or elected officials or their appointees. And it has the administrative capacity to run the museum, but it doesn't own the museum. And that's very important. And in fact, that's what the court has said. That's what the statute says. It says that the Walters trustees are an agency of the city of Baltimore, and their ability to even, if you're thinking who owns the artwork, clearly the city does, because they can't sell it without the approval of the mayor and city council. So I think, and that's something that the court really considered to be important.
Yeah, and I understand that respectfully, though. I guess what I'm just really asking, not whether it's becoming or whether or not it's existing. I'm just asking if there's legal precedent for a court making a decision that a certain entity is an instrumentality of the state. Are there other instances like this is not like a unique situation? That's what I'm asking.
No. This happens quite frequently.
Okay, that's fine.
That's quite frequently the court. There might be a contest, and the court will resolve it because the courts interpret the laws, right? You guys pass laws, the corporate interprets them, applies.
Right. And I'm asking you these questions, obviously, because this says import as to whether or not this needs to be before the NLRB or whether or not it needs to be before us. So that's the only reason why I'm really asking. And then I know you understand that. So that's the only reason why I'm just trying to understand that. So.
Yeah, I mean, the question of the NLRB is, I think, resolved by the fact that, everyone who's looked at this sees the Walters as a public entity and an instrumentality of the state, which the NLRB has no jurisdiction over, which is why this legislation is really so important, because without it, these workers don't have the rights that most other workers enjoy.
Okay, thank you. Appreciate it. Thank you, Madam Chair.
Thank you. And just because you were on that subject, I guess I want to follow up, and then I'll go to you if I could, Senator Hershey. So Mike, following her line of questions, did the Walters employees approach the NLRB? Does anyone know if that process happened?
No, because NLRB has no jurisdiction over them, so we wouldn't approach the NLRB.
Okay. And that determination was made by, you're saying that determination was made by the courts, right?
It's also addressed in the Attorney General opinion, Madam Chair.
Okay.
That you all should have a copy of.
I do. I just read it a little different, but we'll talk offline. Let me go ahead to Senator Hershey and Senator Washington. Senator.
Thank you, Madam Chair. To follow up on your questions and my colleagues' questions, the designation of this being an instrumentality of the state is important because it either allows the state to give the rights for collective bargaining if it is an instrumentality, but if it's not, doesn't the ability to collectively bargain fall upon the employees themselves? They could have initiated this if they were not considered an instrumentality of the state, right?
Well, and they did. I mean, they approached management, and management rejected their overtures.
What do you mean by rejected? I thought that was still those negotiations and considerations are still underway.
Well, we don't believe that the Walters management has approached those negotiations in good faith, which is why this bill is important.
So what's happened since the bill was introduced in the House a few weeks ago?
Once the bill was introduced, Walters management decided for the first time in 2 years that it was actually open to receiving documents and overtures from the union.
When you just real quick, when you say open to receiving, do they have to make that statement that we're open to, or again, does this fall back on the employees to make that determination?
The employees did make that determination and have been approaching management for 2 years, and management never responded and or rebuffed their efforts. So that was the first time in 2 years that management communicated that it was open to hearing from the workers' union.
And since then, what else has happened?
Since then, we provided an election agreement, a private election agreement to the Walters, which they rejected, and then provided just, I think, recently another agreement in response, which in our view, again, is did not evidence good faith on their part in trying to resolve the question of representation that the workers have put to management. It contained many terms that no union would ever sign. That the workers themselves, when presented with it, realized it was more of a waiver of rights than a granting of rights. And so, and that's where we are right now.
Okay, but it is underway. The process is underway. Negotiations are at least underway now, right?
I would say that negotiations have reached a point where it seems unlikely, based on the position that Walters management has communicated to us through their election agreement, is taking this process seriously. I would say that in my experience as a labor attorney and a labor negotiator.
And then finally, one last question, because I think that's, again, as my colleague mentioned, a main part of this bill, regardless of what's been decided in the courts or what any of those two sides agree to, the state would be declaring and assuring that this is an instrumentality of the state, right?
The state has declared that in at least 3 prior enactments, so this would be the 4th.
Why is it in the bill again then?
I don't know. I didn't draft the bill. I think it was probably viewed as uncontroversial because
Page
it's so
2,
clear.
line 9, the General Assembly declares that the museum is a unit and instrumentality of the state and the city.
I mean, I would just say that was confirmatory of existing law and understanding. I don't know. But like I said, I didn't write the bill.
And then finally, where does most of the funding for the Walters come from?
I'm not an expert on its funding. I do know that the Walters has an endowment, which is legally owned by the city as the beneficiary of that endowment, and that those endowment funds fund the museum. I know that they don't entirely fund it. I also know the museum receives funding from the city and the state and has over the years received a lot of public bond revenue. I'm also aware that there's an independent 501c3 foundation that has been established that has its own investments, if you will, and that is a separate entity that is separately governed. It's not governed by the same trustees as the Walters Foundation. I'm sorry, as the Walters Museum, and that separate entity also provides funding to the Walters Museum.
Okay, thank you very much. And I think we're going to have some testimony from the trustees, so they might be able to incorporate some answers as well too, but I appreciate it.
You're welcome.
Thank you.
Thank you. Senator Washington.
Thank you, Madam Chair. And just to say up front, I'm a union member, a member of the adjunct faculty, and they're part of a union drive, so very familiar with sort of non-traditional, that increasingly people find it necessary to form a union. So I know the process we went through, and it's very different than what you all went through. So I'm trying to understand the differences. So one of the things is that could you tell us, because you're saying you are doing something different, but how does it typically happen? How does one typically, how do workers typically go about establishing the right to collectively bargain?
Is that a question for me or?
I would assume it's the union organizer could tell me the steps.
Well, I'll just say this
What
is
are the
my
steps?
this
Yeah.
is my first time doing it, so I'm not as familiar with the typical way. So I would like maybe ask
Yeah, no, I'm
Denise.
very happy to take it. Yeah.
Yeah.
So I want to reiterate, the Walters Art Museum is a unique institution in that it was created both by state law and by city ordinance. That makes it a public entity. In public entities, we have to pass enabling legislation for public workers to get collective bargaining rights. Once those rights are enabled, they can go through a certification process to certify their exclusive bargaining representative. In this bill, that is either through card check, which is a process where they would certify that the majority have signed on cards, or it's through an election that they would hold that the majority are in an election. Another avenue for granting union recognition is to try and seek a voluntary election agreement. Again, this is since the spring of 2021, when these employees first, went public with their announcements, they've been attempting to meet with management to, work out the present a proposal. Management unfortunately wouldn't meet. That voluntary recognition process is the same process that we used with the Baltimore Museum of Art, for instance, in Baltimore, and the Enoch Pratt Library, but it takes both sides, reaching an agreement. Absent that, we do need, obviously legislation that would provide a fair process for certifying the union and getting the union recognized, and then making sure that, obviously it's binding and that the parties can then bargain in good faith.
So thank you. So is this legislation enabling, or are we, is this?
It's enabling legislation. Mhm.
So I guess maybe I could ask counsel. I see a lot of shalls. And so that's where I'm trying to understand if it's so, it's saying that that you shall apply labor relations, to the employees, and that there shall be one bargaining unit. So is that what's in the other? I guess I didn't look. Is that what we normally say? Is that there shall be this?
Yeah,
and
this
there shall be that?
legislation, I'm sorry, I didn't mean to
Yeah,
interrupt.
no, just-
This legislation was actually crafted very closely to the legislation that the General Assembly passed in 1982 for the employees at the Baltimore City Police Department. Again, it's addressing that gap in Maryland law currently where employees are, public employees, but their labor rights, their collective bargaining rights aren't necessarily housed for the state, and they're not housed for the city yet. I think part of the reason you see those shalls, right, is that we've got to place their collective bargaining rights into the city, because they are more of a city entity than a state entity.
And I would like, because I do believe in collective bargaining, and I absolutely the right. I do believe in workers' rights to vote for something, for a unit, and to choose their unit. So if we pass this legislation, will there be a vote to choose the bargaining unit of their choice, or is there, will they have a vote, or are we making the decision?
Yes, I appreciate that question very much. So after we pass this legislation, I'm going to wish it into existence. After we pass this legislation, the workers will be able to choose, again, a neutral third party would run the certification process. So the certification process can look one of two ways. One, either a demonstration that, a majority of workers are on like a signed card already. That's card check. That's one process to certify a union. The other option would be to do an election and have, workers, by majority vote, certify that there's support for the union. Both practices are, perfectly common in union election and union recognition situations. And so they absolutely would have the ability to, choose the representative of their choosing here if they so wished.
Can I add to that?
Yes, thank you.
Thank you. I appreciate it. The other thing I just wanted to kind of iterate is that the legislature has traditionally devolved the authority over these matters to the city. So if you look at the prior enactments, it's all about endowing the city with authority over the Walters and recognizing that the city owns the Walters, and that's what this does. So it places that authority within the city labor commissioner. And so we would expect the labor commissioner would, given this authority, run elections and union representation matters in the same way. And the city the city labor code does provide for these different avenues of representation. So it's just a matter of recognizing the sort of local concern and the way these things are already done locally.
And that's one more clarification I need, Madam Chair, and thank you. Because this is really important. That first line, the museum is a unit and an instrumentality of the state and the city. So this bill is saying it's both the city and the state and it seems like we're saying this in law. So that's the first thing we're doing. Have we had to do that to enable any other elections to occur? In other words, like with the library, all the things that we've done, have we had to state affirmatively, since this is actually in contest, I guess? So we're making a policy decision that it is both the city and the state.
Well,
So is it state? So are you state employees or are you city employees? Because it's confusing. You're saying both. So I don't see how, as drafted, this legislation solves the problem. In fact, I think it introduces more confusion.
I mean, I don't agree with that. I think that it reflects the fact that, so the city is an instrumentality of the state, right? The city of Baltimore is an instrumentality of the state of Maryland, okay, under state law. And so I think this just reflects the fact that, we're really talking about sort of, nested dolls. So you have the state, you have the city, you have the Walters. And I think, and that's the way the legislature set this up back in the 1930s. And so this reflects that.
I think it's confusing. I think that whoever drafted it, we should work on it. So thank you.
Thank you, Senator. And I guess just to follow up on that, and we can take this offline because we do have other witnesses signed up on the bill, still trying to just understand who the employees are relative to the whole conversation. And I've heard reference to the BMA. And so I'm wondering, are those employees in a similar posture? Are they, when their provisions were adopted, was there similar language that was adopted? And then I read somewhere, I don't know, reference to and, they went through a process where they did go to the NLRB or deal with the NLRA. I'm just learning all these things new to the committee. So, but in the interest of time, I can certainly catch up with the sponsor or some of you offline to get some more background, if that's okay.
That's perfectly fine. And we've got responses to all of those
I know you
questions,
do.
so.
All right. Thank you very much. We have another witness signed up in favor of the bill in person, Nina Themelis. And thank you all very much for your testimony. You can. Either way, wherever you're most comfortable, you can begin.
Thanks. I think I was supposed to be a member of the panel, but it was a little crowded up here. So good afternoon. My name is Nina Themelis, Interim Director of the Mayor's Office of Government Relations for Baltimore City. I'm here to testify on behalf of the Baltimore City Administration in support of SB 284. The right of the workers to organize and form collective bargaining units is a fundamental component of our democracy and as such must be protected. The administration has tried to resolve this issue on a local level on several occasions. For example, the administration has tried to broker a neutral third-party election agreement between Walters Workers United and the leadership of the Walters Art Museum. Mayor Scott has personally reached out to with an offer to facilitate such an agreement, as have members of the Baltimore City Council and the Labor Commissioner. Each time the leadership of the Walters has turned down these offers and rejected such an agreement as a path to union recognition. It's vital that these workers be able to exercise their basic right to come together and collectively negotiate over the conditions of their work as a union. For the above reasons, I respectfully request a favorable report on SB 284.
Thank you. Got that testimony in less than a minute. Thank you very much. Are there any questions for this witness? All smiles from Finance Committee. Thank you very much. Thanks for your testimony. We're going to now hear from Chuck Connor and Parker Theoni, signed up in opposition to the bill. Good afternoon.
Good afternoon.
Good afternoon.
Madam Chair, Madam Vice Chair, members of the committee, for the record, my name is Chuck Connor, here on behalf of the trustees of the Walters Art Gallery in opposition to Senate Bill 284. There are several elements of this bill that we think are unnecessary and concern us. The bill would make the Walters Art Museum an instrumentality of the city and state. You can see this in the bill on page 2, lines 9 through 11. The trustees of the Walters privately own and control a substantial amount of the assets of the gallery, funded and maintained by the trustees of the Walters, day by day, month by month, and year by year. A substantial amount of the art and physical plant of the gallery is owned by the trustees. In addition, we have heard on numerous occasions that the bill is necessary because there is a gap currently in Maryland law. We take issue with this premise because shortly after the hearing in the House, the management of the Walters received a proposal from the employees for voluntary recognition through a vote administered by a neutral third party. Management responded to this proposal, and there is a meeting scheduled for February 22nd to continue those discussions. If the process has already begun, it's our assertion that no gap in Maryland law exists. For these reasons, we respectfully request an unfavorable report on Senate Bill 284. Thank you so much.
Good afternoon. My name is Parker Thaney. I'm Labor and Employment Counsel to the Walters Art Museum. The museum and its employees are in the process of negotiating a voluntary recognition third-party election agreement. The parties do not need a state or local law to enter into such an agreement, as confirmed in footnote 2 of the Attorney General letter that you all have referenced today. I'm here to ask you to let us continue to negotiate this agreement. We heard the proponents of the bill tell you and the House Appropriations Committee that there's a gap in labor law such that they do not have collective bargaining rights. Yet, on the proponents' own website, they admit that the employees of the Walters Art Museum have the right to collectively bargain free from interference or retaliation. The Walters Workers United and AFSCME Council 67 website refers to the Walters employees as having the legal right to freely organize their union, and advises the employees that it is absolutely illegal and against the law for the museum to interfere with employees' union organizing activities. These statements are completely accurate. But what law are they referring to that makes this conduct unlawful? We all agree that no state or city law provides these rights. The legal rights to which Walters Workers United and AFSCME refer arise under Section 7 of the NLRA and Section 8A1 of the NLRA. This federal law preempts state or local law touching on collective bargaining, such as SB 284. So the parties agree on the right to organize a union, on the right to vote, on the right to collectively bargain, that these rights arise under federal law. The bill does not advance the interests of the Walters employees, and I urge you to respect the wishes of Walters employees and issue an unfavorable report on this bill so that the parties can, or so that the employees can get on with their vote expeditiously. If you have any questions about the AG letter, I'd be happy to answer them. Thank you.
Thank you. Senator Guile, then Senator Kramer.
Thank you, Madam Chair. You know, there's a lot of what seems to be evidence establishing that Walters is indeed an instrumentality of the state, including an IRS determination letter. There's even a letter from the Walters asking, I guess, in support of, I think, what is an application for public student loan forgiveness, and in which they do indicate that the Walters should be considered or has been instructed to check the box for government agency. So I'm just wondering, how do you respond to what appears to be a lot of evidence in support of that position?
Yeah, thank you for that question. I think here it's important to understand, and this is one of the issues that we take with the bill, that when a law is referencing a unit or instrumentality of the government, or in the case of the National Labor Relations Act, a political subdivision, that terminology means different things under different laws. Here, SB 284 does not state for what purpose the Walters Art Museum would be considered a state or political subdivision. So when it comes to labor relations, the question is whether the National Labor Relations Board has jurisdiction. And that question is answered under a test that was affirmed by the United States Supreme Court in a case called Hawkins County. And it has two components. The first is whether the entity was created directly by the state so as to constitute a department of the administrative arm of the government. think the parties dispute whether the entity was created by Henry Walters, who created the Walters Art Museum, or the state in its in enabling legislation. But the second part of that first test is whether it was created so as to form a department or administrative arm of the government. And in that instance, the analysis is whether there is substantial operational and budgetary control by the government. In this case, there is neither. The second prong of the Hawkins County test is whether the entity is administered by individuals responsible to public officials or the general electorate. So the question there really is asking whether the board is made up of a majority of individuals who are responsible to the general electorate or who are public officials. Here, 2 out of 38 board members fit into that category. So we're far from that majority. So the National Labor Relations Board and the National Labor Relations Act answer the question with regard to labor relations that the Walters is not a political subdivision and therefore falls within the scope of the National Labor Relations Board's jurisdiction.
Okay, thank you. And I'm sorry, just one more question. Who signs the checks for the employees of the Walters? Like, what entity is the one that's actually paying them?
The Board of Trustees of the Walters Art Gallery, Inc.
Okay.
is the employer of the employees and is the one that pays the employees. And want to make it clear that neither the state nor the city pay the employees aside from very marginal additional funds toward employer share of employee benefits and payroll taxes.
Okay, and that's not, I see there's some documents in here regarding the charitable foundation arm of the Walters. And that's when you just said the Board of Trustees of Walters are, that entity is not the charitable foundation.
That's
right?
correct.
Okay, all right, thank you.
Thank you. Senator Kramer.
Thank you, Madam Chair. Gentlemen, I've always heard that if it walks like a duck and it quacks like a duck, there's a good chance it's a duck. And I'm looking at that table right there and I'm seeing ducks. So it seems to me, no matter how you try to convince us that the Walters is not a public institution, I am sensing that that may not be a proper representation. And I mean, just recently, the Baltimore City Circuit Court ruled that Walters is a public institution. But you're sitting there looking at me and saying, no, we're not. So I don't see how you get around the fact that this entity is a creature of state government, that the question was asked, who pays the employees? And you all said, well, the trustees do. Does Baltimore City retain the ability to constitute the Board of Trustees?
So let me first.
That should be a simple yes or no. Do
Yeah,
they
so
retain that ability, sir? I'm
first,
not asking for
right.
anything other than a yes or no.
I appreciate that. So the Walters is subject to the PIA was this, as the judge said, the sole issue presented before the court. So as I said, there are a lot of different laws that use similar terminology and it's analyzed differently under those different laws. And the Walters Board of Trustees, yes, is the entity that pays the employees, not the city of Baltimore.
And does the city of Baltimore, you still haven't answered my question, sir. Does the city of Baltimore retain the statutory power to constitute the Board of Trustees? Yes or no?
The city of Baltimore does not. It has given the Board of Trustees the authority to be a self-perpetuating Board of Trustees.
I understand, but who ultimately controls the Board of Trustees?
The board itself.
All right, I think there's a lot of distinction in statute that's not an accurate answer, sir. But happy to engage offline with you further on that because I believe you're very much mistaken.
Thank you.
And I hope that's accidental and not intentional. Let me ask you this. Are you all opposed to the hardworking employees of Walters having collective bargaining?
Fully support the employee's ability to choose whether they would like collective bargaining.
In that regard, would you right now in front of this committee commit to a neutral third-party election agreement that exactly mirrors the same agreements that are in place with the Enoch Pratt Free Library and the Baltimore Museum of Art?
I'm not aware that those agreements are identical. I've not seen the Enoch Pratt Free Library agreement. I wouldn't make that commitment on behalf of my client at this time, but I can assure you that an agreement has already been proposed to the employees that provides all of those benefits.
And if
Happy
I
to
were to
discuss those terms
represent to
further if
you,
you'd like.
sir, that the agreement that the museum received from the employees mirrors that of the Baltimore Museum of Art and Enoch Pratt Library, that the museum received from the employees mirrors them, would you commit to support that?
Yes, thank you, Senator. I have seen the Baltimore Museum of Art agreement, and the agreement that was proposed to the Walters Art Museum is different in two material respects. First, the Baltimore Museum of Art and AFSCME agreed that the employees of the Baltimore Museum of Art are not employees of the city, and they agreed that the National Labor Relations Board has jurisdiction over the Baltimore Museum of Art. Those are terms that we proposed to the employees in the counter proposal. We look forward to discussing with them.
So let me ask you this, if that agreement cannot be reached before this committee votes on this bill, would you acknowledge then that you had the opportunity to reach such an agreement, it did not occur, and that it's appropriate then for the legislation to be enacted?
No, Senator.
Given the opportunity that you have right now to reach an agreement before a bill is passed.
Yes, we very much appreciate the opportunity to reach an agreement and sincerely hope that we do. And one of the things I will say is that in the cover letter to the agreement that was proposed to the employees, it was indicated that if they have any issue with any of the terms in the agreement, we will welcome their counter proposals and open to a discussion about negotiating those terms. I will say that we would not be in support of the bill passing because ultimately, as noted in the Attorney General letter, this is a question whether an entity falls within or outside of the jurisdiction of the National Labor Relations Board that is governed by federal, not state law, and is within the exclusive province of the National Labor Relations Board and federal courts and not state legislatures or state courts.
So then if this were to pass, what would prevent you from availing yourself of the court system and trying to make the case that the Maryland law is in violation of the federal regulations? That would be an easy process, wouldn't it?
It would be a lengthy and expensive process, and I think it would prove a giant hurdle to the goals of the employees who are trying to get to a vote, and they can get to that vote quickly by negotiating an agreement. So we hope that we do, and we hope that we can get there quickly.
Or if we
and
were to
efficiently.
pass this bill, they could get to it quickly also.
I don't believe that's correct, and that is not my testimony.
Thank you. Thank you, Madam Chair.
Thank you. We have Senator Washington and then Senator Ellis.
So I just want to clear something up. So is it possible to be considered an institution or an instrumentality of the state for one purpose and not for others?
Yes.
Okay, thank you.
Thank you. Senator Ellis.
Yeah, thank you, Madam Chair. So question, you speak on behalf of the employees. So do you represent the employees or the Board of Trustees?
No, to be clear, I represent the museum. The Board of Trustees of the Walters Art Gallery, Inc. is my client.
The Board of Trustees?
Yes.
Okay, sure. Thank you. So the employees of the Walters Art Museum, their compensation, do you consider it like fair compensation and work conditions are pretty good?
What I will say, I'm not going to pass judgment on whether the compensation is fair because I'm not a member of management and I am not an industry expert, but I know that management quite recently underwent a significant study of the industry and made adjustments to compensation that it feels are very appropriate. And I think the employees all saw a very large increase, some very large, and that the floor compensation at the Walters Art Museum is above the floor compensation for city employees in Baltimore City.
So being very responsive. So compensation, of course. So what's the full package for the employees? Of course, their salary. What else is in their compensation package?
I believe that the employees are entitled to their salary in addition to common fringe benefits, various types of insurance, including health insurance. And there is a small subset of employees that are entitled to a defined contribution retirement benefit, and then another subset that's entitled to a defined contribution and then defined benefit retirement system.
Okay, and who manages, say, the retirement system for the employees?
My understanding is that the defined benefit system is managed by the city. I cannot tell you. I would have to get back to you on who manages the defined contribution.
Okay. So at least one part of the retirement system is through the city.
Yes, that's correct.
Okay, so
to be clear, that system has been discontinued for the Walters by the city.
okay, you said something and you took it back. I'm not sure why you did that. So
Would you like me to clarify?
well, I mean, you just said the city manages part of the retirement system, and then you just took it right back. You said no. I'm
No.
not sure what that is about.
The city manages the defined benefit system, but they ended that program. So employees that were currently employed remained within that system. Newly employed employees no longer participate in that system.
Okay, so some employees, so thank you for that clarification.
Sorry,
That
sorry
kinda
for the
took me
confusion.
for a loop right there. So the city does manage some employees' retirement system.
Yes,
I'm sorry,
that's-
retirement
that-
plan, retirement.
That's
plan.
correct.
Okay, so I'm just trying to understand. So ultimately, I think being a CPA, when you try to determine who is responsible for who, at the end of their career, the people who are responsible for them are the people who pay their retirement. So you just said the city pay their retirement. So they're pretty much somehow under the city government auspices. That's my conclusion from your analysis.
I would not agree with that conclusion.
Okay, all right, thank you.
Thank you. Senator Kramer.
Thank you again, Madam Chair. I appreciate, because I had asked, I was not given a copy of the Attorney General's letter of advice, and I just received it, which brings up a question, gentlemen, where I'm reading, it says, in part, I am persuaded that the factors that the court relied upon for its finding about the application of the PIA similarly support a finding that the state and Baltimore City have sufficient control over the Walters so that the General Assembly may direct that the Baltimore City Code will apply to labor relations between the Board of Trustees and museum employees, at least as a matter of state law.
That's correct. That is in the Attorney General's letter.
So the legal source that we rely on here in the Maryland General Assembly, rather than your commentary, states that this body has that authority by state law.
Well, if
Is that accurate?
Well, it's qualified in the AG's letter. The AG articulates that articulates expressly that it is federal, not state law that controls this, and also elaborates on the fact that NLRB may assert jurisdiction.
I think the words I just read were crystal clear, but thank you. I appreciate it. Thank you, Madam Chair.
Thank you.
Thank you. And we'll go back to Senator Ellis. Oh, okay. I saw your light flashing. No, there's no further questions for this panel. Thank you very much for your testimony. We have 4 virtual witnesses signed up in support of the bill. We'll start with Karen French. Good afternoon. Oops. If you can unmute That'd be great.
Okay, hopefully you can hear me and see
We
me.
can.
Okay, thank you very much for having me here today. My name is Karen French. I live in Central Baltimore, and this September I will have worked at the Walters Art Museum for 30 years, so I am a long-term employee. And over these decades, I've seen many changes and reorganizations, but I've also heard many promises for improvements, some of which have not been forthcoming. I've been part of several short-term staff committees, including the first diversity task force, but as staff, we were unable to effect much change. So I've learned that along with many of my co-workers and the Walters Workers United members, of which I'm one, that we think the most direct, inclusive and transparent way to achieve lasting improvements at the museum is to have a single union representing workers across all departments. I must say I am very grateful personally for myself and my family that this year we did get the long promised pay level adjustments, which I just heard a little discussion of. I started at the museum in 1993. And at that time, we had a stepped pay scale with incremental raises alongside an additional cost of living raise. But in 1998, that pay system was changed to merit increases tied to annual performance reviews with no additional cost of living adjustments. And these increases weren't assured or inconsistent. Staff in the same job could receive different percentages. Some years there have been no increases, and they rarely reflected the cost of living changes throughout these past 25 years. So this pay level adjustment is very welcome. And we believe that these recent positive changes are due to our organization and collective action, but many issues still remain, and having a union would allow us to be part of the process when the decisions are being made about revamping our retirement accounts, cost of living increases, health and safety, lack of parental leave, the two-tier retirement system, just to name a few. Have I been cut off? I don't know. So a union contract will protect these improvements and help us collectively make future ones. So we ask you to support this bill. Thank you.
Thank you very much for your testimony. I don't see any questions from the committee, so thank you very much. We're going to turn to Martin Mitchell. Good afternoon.
Greetings, couldn't find the mute button. Appreciate it. Greetings, distinguished chair and esteemed colleagues. My name is Councilman Martin Mitchell. I am the at-large councilman for the city of Laurel. More importantly, I'm a father of twin boys. The Walter Art Museum is special to me and my twin boys. It's the first museum of fine arts that we visited, and we do frequent the museum. I was shocked to learn that the dedicated and hardworking employees weren't already unionized. One of my twins overheard me discussing collective bargaining and the need to unionize and inquired, "Daddy, what's a union?" Of course, it's a complex concept to break down to a first grader, but I attempted and I tried. And I said, "Sons, unions are a collective group that fight for the rights of workers. And unions are one of the biggest reasons that workers' have more rights and have better working conditions." And as someone who has advocated for unionization for several years, I've seen injustices happen in places that aren't unionized. So I just want to urge this deliberative body to pass SB 0284. And thank you.
Thank you very much for your testimony. Seeing no questions from the committee, have a great afternoon. We'll turn to Rachel Leeds.
Hi, is the video working or not? Oh, yay.
It
okay.
is now. There you go.
Wonderful. Hello. Thank
Hello.
you for having me here. My name is Rachel Leeds, and I work as the accessibility advocate at the Walters Art Museum. I've been working at the Walters for almost a year, and I'm a proud member of Walters Workers United. One of the things that drew me initially to the Walters is the emphasis on inclusion and community. And on the public-facing side, everyone's on the same page. However, there's a huge gap between the Walters approach towards visitors and their approach towards staff. When I bring up an access barrier that impacts visitors, my point of view is respected and taken into account. When I bring up an access barrier that impacts me personally, historically, there's been no recourse. When I started my job in March, I was under the impression that I had flexibility to work from home, which I need due to a chronic illness. In October, this flexibility was taken away. I filed for an accommodation. I was told the wrong process at first, and then I had legal and ethical questions about the documentation form sent to my doctor. I was told not to raise these concerns because they could hurt my relationship with HR. This experience put me in survival mode for 3 months until the accommodation was approved. This issue didn't stem from any particular person, but rather from the museum's systemic practices around accommodations and accessibility for staff. I think it could have been avoided. After I testified in front of the House Appropriations Committee in support of the legislation we're talking about today, our museum director did email me, connecting me to outside legal counsel hired to investigate my concerns. I am very grateful that the museum took this step, and I'm hopeful about what changes the process might bring. It should not take testifying in front of a Maryland General Assembly House Committee to have my concerns recognized. That's not a sustainable or accessible way to have our workplace issues addressed. There's no guarantee of a grievance procedure for similar concerns moving forward. Systemic barriers remain unaddressed. Through a union, collective bargaining would give me and my colleagues a path to address the policies that have huge impact on our lives instead of after the fact. That's why I'm asking you to support SB 284 and the Senate Finance Committee. Thank you.
Okay, thank you. There are no questions, so we'll now move to AJ Kurian. Good afternoon.
Hi, good afternoon, everyone. Thank you for having me. I am on the board of trustees for the Walters Art Museum. I was asked to join the board in 2021. I'm the first artist on the board's history. And in many ways, I thought I was going into a very inclusive group of people, and I just was trying to get my bearings for quite some time. The line that I had heard over and over again was that workers can at any time unionize through the established routes, which meant going through the NLRB to organize the election. This path, however, is inadequate for the desires of Walters workers who are committed to a wall-to-wall union, which would unite museum workers and security into the same union, giving them better unity and more material unity. Additionally, it's contested whether or not the NLRB even has jurisdiction if the museum is public or private, which currently it is, I guess it is public, so it would need a third party. As the House hearings have gone, it has become more uncomfortable for me, and it seems as though legislation would be necessary for this to pass through. The museum leadership had never been in touch they had never spoken to the workers directly. And this is, well over 2 years. And all of a sudden there's a third party, they're willing to entertain a third party agreement after this legislation was proposed. It just doesn't seem like this is being done in good faith when there were plenty of opportunities prior for them to meet and address these things. So it's with that I'm coming forward and speaking to you all now to say that I do hope you pass this bill. Thank you.
Thank you very much for your testimony. I don't see any questions for you, so thank you very much. And that will conclude the hearing on Senate Bill 284. Colleagues, we're going to now turn to Senate Bill 367, which is Public Employee Relations Act. Senator Lamb. And this will be our last guest appearance by Senator Washington from 3E.
All right, I will go ahead and begin. Good afternoon, members of the committee, Chair Griffith. For the record, Clarence Lamb, Senator District 12. Pleased to be here to introduce Senate Bill 367, the Public Employee Relations Act. Before I begin, I want to at least make clear that the bill does not impact private employers in the state. This only affects public employees that either work for the executive branch, are in K through 12 schools, or in public higher education institutions. Does not affect private employees and private employers. Currently, Maryland's laws governing collective bargaining for public employees are spread throughout the education and state personnel and pension articles. This means that employee rights and procedures governing collective bargaining vary based on where an individual is employed. Additionally, the state has 3 separate public labor relations boards: the State Labor Relations Board, the State Higher Education Labor Relations Board, and the Public School Labor Relations Board. Although these boards are all very dedicated to their work, they are oftentimes underfunded and understaffed because the state labor board budget is spread thin. This results in employees and management experiencing delays in getting resolutions resolved related to disputes over contracts, unit clarifications, unfair labor practices, as well as bargaining. The primary focus of this bill is merging the 3 current boards into one unified public employee relations board. This is similar to the single National Labor Relations Board and will ensure that public employees and employers have one central board to officiate disputes related to collective bargaining. The bill also requires the board to hire an executive director and deputy directors for each of the 3 main public employee sectors. Finally, the board will be permitted to hire staff to ensure that it has the support needed to address complaints in a timely way. In addition to creating a single labor relations board, this bill will also standardize the laws governing public employee collective bargaining. The laws currently governing public labor relations have developed in a piecemeal fashion over decades. This has resulted in inconsistent and out-of-date labor relations laws. This also means that the rights of employees are treated differently based on where they are employed. There are several areas of public employee labor law that this bill seeks to update. Number 1, this bill provides for updated procedures and shorter timelines for responding to complaints for unfair labor practices. This is a benefit for both employees and employers because collective bargaining and negotiations can be held up when either side files an unfair labor practices complaint. Second, state funds will be prohibited from being spent on anti-union campaigns. The decision on whether to unionize or not should be made by the employees involved, and this is not an appropriate use of state funds, in our opinion, to try to break up union efforts. Third, the bill standardizes the use of a process called card check. Essentially, this means that if more than 50% of employees in a bargaining unit petition the board for a union, then they can bypass an expensive union election. Currently, some public employees are permitted to use the card check process, however, others are not. Fourth, the bill standardizes the state grievance process. Currently, the grievance process varies depending where an employee works. One specific change is to allow a union to file a grievance on behalf of all of its members in a bargaining unit. So, for example, during COVID, our state prison employees argued that their contract entitled them to hazard pay. The state refused to pay, and because the union wasn't able to file a grievance on behalf of their members, each impacted member had to file individual grievances. This is inefficient for everyone involved and delays resolving complaints unnecessarily. Finally, the bill updates the law governing what public school employees are permitted to bargain on. This will allow school systems and unions to work through ways to address growing classroom sizes. I believe there are a few amendments that are in your packet. Happy to talk more about those and to entertain additional amendments as well. I recognize that this is a very long bill with a lot of moving parts, but believe that it's important that we do begin this conversation on how best to streamline our state's public collective bargaining laws and labor boards. It has been built on decades of precedent that in our state statute have been, or in my opinion, are long overdue for updating, and this bill begins that process. I want to thank the committee and pass along to other members of the sponsor panel.
Thank you, Senator. And let me just mention, as your panel prepares, I don't have a copy of amendments. I don't know if any of the members do. So if you do have or have seen some amendments, that would be great. Good afternoon.
Good afternoon. Christy Anderson, I'm General Counsel with the Maryland State Education Association. I have to say, I was probably here 15 years ago when we started this march towards a public school labor relations board. And you're probably asking, well, why are you back? Over the years and experience that we've had with these various labor boards we have learned we need a labor board that is appropriately staffed and has all adequate resources in order to do their job. And we need a labor board that is steeped in labor relations, understanding labor law, negotiations, mediation. Currently, that doesn't exist. These labor boards are not, this lack of experience in labor relations on the labor boards has resulted in very much delayed decisions. For whatever reason, I can give you one example. We had a case in Prince George's County. We filed an unfair labor practice in May. This was during the course of negotiations, and we did not get a decision until November. It was the day after the parties actually reached an agreement, because we can't wait on the labor board. Unfortunately, the negotiations law is only as good as the mechanism by which we can enforce it. We can't hold the parties accountable unless we can get timely, effective decisions. All parties need to promote effective labor relations in this state. We need an effective board, and that's why we support the consolidation and the creation of a singular public employee relations board. I think it is necessary if we are going to promote positive, effective labor relations in this state. And so we do, again, urge that you give a favorable report to Senate Bill 367. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is David Marr. I'm an attorney at Conn Smith & Collins. My firm represents Ask Me Counsel 3. We also represent firefighters, teachers, county and municipal employees, and many other public sector employees here in Maryland. And so as a result, we practice before the 3 state labor relations boards we have here. So I'm speaking from experience. Collective bargaining laws for public sector employees in Maryland are fragmented, they're unequal, and they routinely go unenforced. You've already heard about the unification of the board's aspect of this bill. I'm going to talk about the other aspect of this bill, which is standardizing labor law between these different sectors. So currently, public sector employees, unions, and employers all have very different rights, procedures, and obligations simply depending on who the employers are. And in some cases, such as in public schools, a teacher and a paraprofessional in the same classroom have a different set of rights and obligations and procedures they have to go through, even though they have the same employer. And this difference in laws is exacerbated by the fact that these 3 boards are interpreting identical or similar language differently. It is very routine. For example, in an information request, very basic thing you do under labor law, the boards will come down differently on the same or identical language. And this process, as Mr. Anderson just put forward, often takes up to a year and a half to go through. This creates significant administrative hurdles, both for employers and for unions, but it is also, more importantly, unfair and inequitable for employees. There is no good reason for one group of employees to have the right to card check, but other employees not to. And an important issue such as employer neutrality, union access, and grievance procedures, you have an availability for some employees, but not for others. This bill levels the playing field and creates a single body of labor law for the one unified labor board to enforce. And very critically about that, very little in this bill is new. Almost everything is a right or an obligation or procedure that one group of employees already enjoys. All this does is provide equality across the public sector. And for those reasons, we ask that you give a favorable report to SB 367.
Thank you. Senator Reedy.
Thank you, Madam Chair, and good afternoon. A couple of questions come to mind as I look at this. The testimony from, I think, our last witness talked about the hodgepodge of labor laws around in the code, and you used the example of the classroom. Does this bill then say all employees are going to be treated exactly the same under labor laws? They're going to have exactly the same kinds of regulations? Can you talk about how we're putting this all under one roof? Because the responsibilities of a classroom teacher versus a one-to-one professional that's in the classroom are different. So can you elaborate on that comment? One of you spoke.
And I was going to just very quickly, I think the substantive negotiations law for the respective sectors, so whether it's K-12 public schools, state employees or higher ed, the substantive negotiations law will stay the same for each of those sectors. What this merges and makes uniform would be unfair labor practices, the card check process, some of those the recognition process, those would all be standardized through this merging into one board. So those would be the regardless of where you're employed in the public sector, you know, in terms of recognition, card check, unfair labor practices, access by the union, all of that would be standardized under this law.
And it would treat, and this, if we pass this bill as is, and I understand there's amendments coming, but if we pass the bill as is, it would treat a teacher as no different than somebody who works at a museum, for example, since we spent some time on that earlier.
Well, I don't know if there are any museum employees.
Or custodial staff in the General Department of General Services is the same as a state police officer for labor purposes. Am I getting this right, or am I like overstating it? Can you help
I
me?
think it depends on what you mean by for labor purposes. It's a very narrow body of things that they're treated the same for. For instance, the procedure by which you go about having a union election or card check to certify a union to represent a bargaining unit, the process by which a bargaining unit is determined to be correct, what happens when someone alleges that an employer or a union is committing an unfair labor practice.
So it's the procedural part of it. It's not the job duties. I didn't think so. I'm
Oh,
just
no,
trying to
no,
clarify
not
that,
at all.
right? And then,
Sorry.
or what constitutes some sort of unreasonable demand on an employee. That's not subject to this. This is just talking about what happens when that's alleged, correct?
No, this does not.
Yeah, you're right.
Well, this does not touch the bulk of the laws that, you know, govern, for instance, teachers or paraprofessionals or Department of Transportation employees. It really only regards the process of organizing and certifying a union.
Right, okay. Then one follow-up, if I might, Madam Chair. So what task force or study does this come out of? Because this seems like a pretty big change. So was there like a task force or a study or something we're following with this?
I think discussions about this started a while back simply because a number of the lawyers who practice for these boards had noticed that these labor boards have these issues over and over again. They take too long to reach a decision. They aren't sufficiently investigating the complaints that are being made. They're applying things inconsistently between the boards, and realizing that and looking at what other states are doing. And we have put together some studies. I don't know if it's been provided to the committee yet, just of how other states do this. We've looked at other states that have substantial collective bargaining rights in the public sector and seen how they do things. And it's very, very rare to have 3 different boards for large sectors of this. And what's much more common, and, you know, of these states, I think we've identified 17 that do it this way, there's a single labor board applying a single generally applicable labor law, whether that's New York's Taylor Law, Pennsylvania's Pennsylvania Employee Relations Act, New Jersey, Washington, Nevada, New Mexico, Hawaii.
Okay.
States across the country that do it.
And I lied. I had one more question. If it's okay, just real quickly. You mentioned about it's taking too long to get answers back, which I'm sympathetic to, of course, because you want answers.
Right.
Although in the example you give, it sounds like it took just the right amount of time because they all came to an agreement. So it sounds like it was perfect.
Unfortunately, we can't stop. I mean, we've got a collective bargaining agreement that the contract ends on June 30th. And so
Right.
we won a
So-
contract for our employees.
So time limit, there's nothing, I don't think there's anything in the bill, but are we setting a time limit for what is reasonable? I didn't find it yet. Is it in the bill or is it?
I believe there's a time limit for once a charge is filed for the board to investigate it, or the deputy director to investigate it. And then after that point, there's, I believe, a 90-day deadline to actually resolve the complaint.
Is 90 days like kind of medium what it's taking right now? Or is that a generous amount of time?
I don't know that it's ever taken that short.
Yeah, I was gonna say that would be short,
Yeah.
unfortunately.
So we may not want to set that as the limit, but okay. Thank you. Thank you, Madam Chair. I apologize for asking a third question after I said it was my last question. So thanks.
It's okay. Thank you, Senator Ellis.
Yeah, thank you, Madam Chair. And listening to your testimony, thank you, Senator Lamb, for this bill. Use some terminologies that I'm not kind of knowledgeable about and the process. So you several times talked about card check process. What's that? And can you give us the context of that and how important it is? Because you mentioned it several times, both of you. So,
A card check is often seen to be the gold standard for certifying a union where you don't have the costly election process. Essentially, when more than half of a bargaining unit signs a card under specific, it has to be specifically formatted in a specific way, but that card has to say, I certify and authorize that I want this specific union to represent me, and it does represent me. When more than 50% of the bargaining unit has signed those cards and the board finds that it has, that the union is automatically certified. So there's no reason to go through an election because the employees have already.
I'm sorry, no reason to go through what?
An election, because the employees have already, a majority of them have already decided that they want this specific union to represent them.
So that card, who is it like a federal government card, but form number and have such number?
It's actually much simpler than that.
Okay.
It has to have certain information. I mean, currently, at least for public schools, it has to have certain information. It has to be signed and it has to be collected within a certain time period prior to what would otherwise be the election, and submitted. But it's just a real simple, I hereby designate that whatever union you happen to be organizing to represent me and serve as the exclusive.
Yeah, so what law authorized that process, the card process?
So it's currently authorized for community colleges in a bill that's passed, I think, 2 sessions ago.
Okay, from the Maryland General Assembly.
Yes, from the Maryland General Assembly. It's also the Employee Free Choice Act that's been in front of the federal Congress a number of times. And I believe Senators Cardin and Van Hollen also had a bill that would set the just the standards for public sector collective bargaining would require there be an alternative to use a card check process. And the language in the bill is actually taken from that.
So in addition to Maryland, this is like a national way of foregoing the election process.
Yes, it's used across the country.
Okay, great. Thank you. I appreciate that. Thank you.
Thank you. I don't see any additional questions for this panel. Thank you very much for your testimony. We have one additional witness signed up in support of the bill. That is Christopher Cano. You could come forward. Good afternoon.
Good afternoon, Madam Chairman. My name is Christopher Cano. I'm the political coordinator for the Service Employees International Union Local 500. And I just would like to ask this esteemed body to provide a favorable report for this bill here. I'm a native Floridian. And in Florida, since 1968, in the Constitution, all public sector employees have had collective bargaining rights. And we have a Public Employee Relations Commission down in Florida. As a union organizer, prior to my work up here in Maryland, I had the opportunity to conduct several union organization campaigns and such through the Public Employee Relations Commission in Florida, and they operated smoothly. So I can tell you that if you're looking for a state that you can model after, it might surprise you that the crazy folks down in Florida are actually getting it right. And I can say that as a native Floridian, but the fact is that this body would do well to listen to the witnesses that previously were up here and streamline the government to make sure that as you move forward, the expansion of collective bargaining rights this body has granted over the past several years would benefit greatly of having a single entity that they can go to manage their union elections. And so thank you. I ask you for a favorable vote.
Thank you very much. I don't see any questions. Thank you for your testimony. We have 3 witnesses signed up in opposition. They are John Willems, Sherry Roxas, and Carolyn Skolnick. If you're here, please come on forward. And good afternoon.
Good afternoon. Would you like to go first?
Sure.
Madam Chair, members of the committee, John Willems representing the Maryland Association of Boards of Education, here today to testify in strong opposition to the provisions of Senate Bill 367 that apply to public school systems and the regulation of collective bargaining between public school systems and employee associations. This bill would convert the mediation process to one of binding arbitration. It would add both class size and school calendar to the subjects of permissive bargaining. And it would upend a process through which we have a standalone labor relations board to resolve disputes arising in the education sector. And for those reasons, we're very much opposed to those provisions of this bill. To be clear, not weighing in at all on the provisions related to the consolidation of the Labor Relations Board as it relates to state employees and higher education employees. And if it is the will of the body to create a consolidated Labor Relations Board, including the K-12 negotiation issues, we would certainly urge the removal of those provisions that change the scope of bargaining with regard to class size and school calendar, and would also request that binding arbitration not become the rule as it relates to negotiations in the public education sector. Thank you.
Good afternoon, Chair Griffith, Vice Chair Klaus Meyer, members of the committee. Thank you for the opportunity to share our thoughts regarding Senate Bill 367. I'm Carolyn Skolnick, Associate Vice Chancellor for the University System of Maryland with responsibility for policy and human resources. This bill proposes a drastic restructuring of the collective bargaining process in the state of Maryland. As I think someone noted earlier, it's 57 pages long. Under existing laws, certain fundamental rights are reserved to management that help ensure the effective and efficient operations of the USM institutions, including the right to determine the mission, budget, organization, numbers, types, and grades of employees assigned, the work projects, tours of duties, methods, means, and personnel by which university operations are to be conducted, the technology needed, internal security practices, relocation of facilities, the services to be rendered and operations to be performed, and finally, the right to hire, direct, supervise, and assign employees. These rights are consistent with management rights provided under labor statutes in the private sector, federal government, and states throughout the country. Senate Bill 367 seeks to drastically limit the rights of management to merely determining the university's functions and programs, determining the budget and organizational structure, and directing employees. The narrowing of management rights stated in the bill would eviscerate the university's abilities to run their operations. At the same time, this bill would make it legal for employees to engage in a work slowdown or refuse to perform employment duties, behavior that is currently considered an unfair labor practice. The bill would extend collective bargaining rights to supervisors and managers, including employees with access to personnel, budgetary, or fiscal data used in collective bargaining, thus creating an inherent conflict of interest. As mentioned before, the bill, of course, would abolish the 3 specialized labor relations boards. It would establish binding interest arbitration. And along with abolishing the labor relations boards, it would also abolish the presumption that prior labor board rulings are binding precedent, allowing the board to overturn many years of prior precedent, leading to a lack of predictability in labor matters. So for these reasons, the University System of Maryland urges an unfavorable report on Senate Bill 367. Thank you.
Good afternoon, Chair Griffith, Vice Chair Klaus Meyer, members of the committee. My name is Sherry Rojas. I'm the Director of Labor for the USM. In addition to the comments made by my colleagues, Senate Bill 367 significantly disadvantages both management and employees. The bill takes away the right of an employee to vote by secret ballot and choose how they want to be represented if a petition for election is supported by over 50% of the unit. Instead, immediate recognition of an exclusive representative is required. Signatures collected by an exclusive representative to get elected are valid for 18 months, yet signatures collected for removal of an exclusive representative are only valid for 90 days. An exclusive representative has essentially unlimited access to management's facilities and employees for campaign activities, yet it's an unfair labor practice for management to spend money, use time, or resources to engage with employees honestly and openly on the same topic. The interests of the union are put before the interests of an employee under the bill. Dues deductions are automatically reinstated for an employee who separates and then returns within 1 year, regardless of whether that employee actually wants to continue financially supporting that union. And an exclusive representative would have the ability to file grievances as the party in interest, regardless of whether an employee wishes to pursue a grievance or whether it's in the best interest of employees. The time frame for filing an unfair labor practice is twice as long under this bill, making it harder for management to investigate or support its position. And interestingly, while the bill's claimed intent is to follow the National Labor Relations Act, the provisions of the bill seem to only be consistent with the act when advantageous to the union. This is not just a bill to consolidate the labor boards, it's a complete revamp of the existing collective bargaining laws. For these reasons, and as further detailed in our written testimony, the USM respectfully requests an unfavorable report on SB 367. Thank you.
Thank you. Senator Reedy.
Thank you, Madam Chair. So looking through the bill earlier and being a little bit new to some of the labor stuff in this committee. So the bill includes, it makes everything binding arbitration for all, or just for Mr. Williams, was it just for the folks you're representing, or is it binding, this would make everything binding arbitration in the state?
So the bill, as I understand it, the way that I read it, it would require the parties to include in a negotiated MOU a binding dispute resolution procedure. And thus binding interest arbitration, because it would require that procedure to address the terms that are being negotiated.
And when you talked about it, it eliminates, and if you don't have this up there, I'd love to know where in the bill, and because I hear there's some amendments coming, it sounds like that's a good thing. It eliminates being able to look, it says it's not a past rulings of the board are not binding anymore.
Correct. The bill specifically states that past decisions of the currently existing 3 boards would no longer be binding. They could only be used as persuasive authority only moving forward.
So we would just be kind of starting from scratch on all our labor law precedents, or not our labor law, but our labor ruling precedent. Okay. Well, maybe sounds like there's some room to work on this legislation. Thank you. Thank you very much, Madam Chair.
Thank you, Senator Kramer, and then Ellis.
Thank you, Madam Chair. Ms. Skolnick, just to, I think, point out an error in one of your comments. You indicated that in this bill, we would be providing supervisors and managers with collective bargaining rights. You may want to reserve that opposition to my bill, which will be up shortly, which does that. So
I'll be happy to do that.
I
sir.
just wanted to bring that to your attention. Mr. Williams, quick question. I noted your opposition to binding arbitration. Without binding arbitration, what is your suggestion for resolving an impasse?
The Public School Labor Relations Board has the authority to make final decisions with regard to impasse disputes. And so there is a mediated process that leads up to final decisions by the Public School Labor Relations Board. The bill significantly repeals a lot of that mediation process. It does preserve some role for mediation, but at the top of page 9 of the bill, it does substitute quite clearly mediation with binding arbitration.
And with binding arbitration, you have a professional who makes these decisions, does this. I mean, this is somebody who is trained in this process, and that can go either way. Certainly in binding arbitration, the arbitrator can look at the bargaining unit and say, nah, you know what, this is a bridge too far, and management comes out ahead. So why is it you would resist having a professional who does this take a look and say, one way or the other, here's the decision? Why is that disconcerting?
One of the primary reasons that it's disconcerting is that we are consistently advocating for the use of a balancing test where mediators and final decision makers like the Labor Relations Board make their decisions informed by a balance between the employee interests, which are clearly important and significant and valid, and the interests of the school system to meet the needs of students overall. And so we advocate for that balancing test analysis as an integral part of the final decision-making process. We also emphasize that we are fiscally dependent, unlike many local boards around the country. And so as the end of the fiscal year is rapidly approaching, we're also finalizing contracts, and we do not want to be bound by binding arbitration to agreements that essentially are structurally unfunded based on the amount of state and local funding that we have. And so we also want to preserve the role of not only the Public School Labor Relations Board, but school systems to have that final decision-making authority on contracts.
And I would proffer to you that every one of those items that you just identified are exactly what the arbitrators look at when making their decisions. But thank you. I appreciate that. Thank you, Madam Chair. Thank you.
Thank you, Senator Ellis.
Yeah, thank you, Madam Chair, and thank you, distinguished panel. Question for Mr. Williams first. So listen to your testimony. You came in just and written unfavorable, you don't like the bill. And at the end, you say, well, you know, if you go and do it, make these changes to the bills. So I'm not, that kind of took me on a loop, basically. So could you say, if the bill passes, what are the changes that the Board of Education would love to see to protect their interests?
Well, Senator, I mean, first and foremost, changing the scope of bargaining. There is another standalone bill in to add class size as a permissive subject to bargaining. We're on record as opposing that standalone bill. This bill would do not only that, but also add school calendar to the subjects of permissive bargaining. Those are two subjects that have been excluded as illegal topics of bargaining for decades. And so that's a specific change that the bill would make that we would oppose, even if it were the will of the body to create a consolidated labor relations board with authority to hear disputes in the public education sector. There are certainly other issues that we would want to see reflected, like a balancing test and perhaps an enhanced role for mediation with regard to our disputes. But by and large, the front section of the bill that deals solely with eliminating the Public School Labor Relations Board and changing the scope of bargaining and the role of mediation, we're opposed entirely to that section of the bill.
So did you send in a kind of recommended amendments like we just articulated to us for us to review later? Did you put those in writing for us?
I could certainly do that,
Yeah,
Senator.
if you could, yeah, definitely.
But I would say the other sections of the bill are really outside our area of expertise or interest in that they would radically change the scope of bargaining for state employees and higher education.
Yeah, I understand. I just want to know within your scope to have it in front of us so we can really, you know, take that into consideration and give it serious consideration. So you could reach out to us and send that to us. And so, thank you, sir. And ladies from University System of Maryland, your testimony, I think I get the impression, so correct me if it's unfair. The system is set up mainly as like, it seems like it's us versus them. Basically management versus the employees. And it's like if you add managers and supervisors to be able to bargain, they have more knowledge than they should have than the regular employees. That will give them an unfair advantage over us. And that's how I understood it. Could you kind of clarify that a bit for me, please, as far as your testimony?
Sure.
Yeah.
Do you want to? And I'll take a shot at responding first. Thank you for that question, Senator. I don't think that we are saying that it's an us versus them sort of mentality. I think the concern about expanding collective bargaining rights to supervisors and managers is that it creates an inherent conflict of interest. And as Senator Kramer said, there's another bill up today, and we're going to be expanding on that topic during that testimony. But it creates this inherent conflict of interest interest. Supervisors and managers really function as an extension of management, and it's through our supervisors and managers that we're able to accomplish the goal and the mission of our institutions to effectuate, develop, implement policies, to make management level decisions, to hold employees accountable, to make decisions for hiring, firing, promotion, layoff, assignment, to make decisions related to addressing an employee grievance. Our supervisors and managers are responsible for doing those types of things. So for us, it creates an inherent conflict of interest.
So if those supervisors, managers, which would be ideally more experienced employees in the system, that have greater knowledge about how the system function, being just great public employees, you would think we want to have them to use that knowledge to make working conditions and employees' entire career better. And I would think, first, from my opinion, that would be an advantage when we come to really negotiate, to have serious discussions. The more knowledgeable folks are, I won't say, well, on both sides, you would think that would be ideal instead of, say, much less experienced folks arguing for better conditions. Isn't that so? So, thank you, Madam Chair.
Thank you. I don't see any further questions from the committee. Thank you for your testimony. That will conclude the hearing on Senate Bill 367. We'll now turn to Senate Bill 258, which is hospital credentialing, reappointment process for physician staff modification. Senator Lamb. And if you have a panel, you can bring them all up.
All right, there is a panel, so ask the sponsor panel to come up. This includes Ms. Dorian, Sigrid Haynes, Mr. Steve Wise, and Mr. Marcus Ross, and maybe a few others. So good afternoon again, Chair Griffith, members of the committee. This is a much shorter bill, much more straightforward than the prior bill. For the record, Clarence Lamb, Center District 12. So up until very recently, the Joint Commission on Accreditation of Hospital Organizations was previously, some folks who in the healthcare field may know that as JCAHO, now just known as the Joint Commission. So just call them the Joint Commission. It's the accrediting body for hospitals, basically. The Joint Commission required that hospitals reaccredit their physicians every 2 years. The recredentialing is a fairly labor-intensive process for both hospitals and physicians. It involves completing performance reviews, reviewing utilization data, assessment of the physician's mental and physical status, among other things. Additionally, physicians with privileges at multiple hospitals have to complete this process separately for each hospital. Recently, the Joint Commission decided that it was appropriate to extend the timeline for recredentialing from 2 years to 3 years. This will reduce the administrative burden on both hospitals and physicians. However, the state's hospitals will not be able to extend their recredentialing timeline because current state statute explicitly includes the 2-year requirement in state law. This means that Maryland hospitals will have to continue to do physician recredentialing every 2 years, which is an extra burden and puts on them a disadvantage when it comes to hiring physicians, because physicians could go work at other hospitals in regions where they don't have to deal with this administrative burden of recredentialing as frequently as every 2 years. And again, the Joint Commission is now recommending every 3 years. What this bill does is just remove the 2-year requirement in the current law and replaces it with the requirement that hospitals use a recredentialing that is consistent with the accrediting body for the facility. With that, let me stop there, pass along to others on the sponsor committee. Happy to take any questions.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. I'm Steve Wise. I'm here today on behalf of MedCod, the Maryland State Medical Society. We are strongly in support of the bill. I think Senator and Dr. Lamb laid out the positives of the bill very well. It's really a housekeeping efficiency measure that frees up a lot of time, both for the hospitals and the providers, and we ask you to support it for those reasons.
Thank you very much. Thank you, Madam Chair, and members of the Senate Finance Committee. For the record, my name is Erin Dorian. I'm the Vice President of Policy at the Maryland Hospital Association. I too want to thank Senator Lamb for introducing this very simple but important bill. All I will say is that aligning state law with the national standard eliminates the administrative burden for both the hospital and the physician. In the time of great healthcare workforce crisis, where we have workforce shortages across all occupations from the Eastern Shore to Western Maryland, our state needs to be competitive so we can recruit and retain a world-class medical professionals. We all want to serve all Marylanders. And for these reasons, we urge a favorable report on Senate Bill 258.
Thank you all for inviting us. My name is Sigrid Haynes. I'm an attorney in private practice. I've been doing credentialing work for hospitals for about 35 years. I'm a partner at Whiteford Taylor in Preston. To my left, although they've not signed up to testify because we don't want to be duplicative, Sheila Myers is the immediate past chair of the Maryland Association, that is the accreditation body, that the group that promotes this specialty. And to her left is Lenita Gregg Jennings, who is the past president. President-elect of the same association. The National Association has promoted this legislative change. Many states, but not all, are silent on this issue. Maryland has had a 2-year reappointment requirement for a number of years, but we would like to come into conformance with the national standards, which is the Joint Commission. HMOs are already, the body that accredits HMOs are already on this standard. It will save a great deal of money for the hospitals, and we believe will actually increase the compliance with the proper credentialing standards, because instead of the current processes, which are every 2 years and lead to some rubber stamping, because of the constant nature of the review, to be able to do that to every 3 years, what we believe will actually increase the focus on quality, because there will be more time to review each application. Further, the standards have changed as to how hospitals credential physicians. They now have an ongoing requirement to constantly monitor quality, which is why the Joint Commission, I believe, felt it was safe and appropriate to make this change to a 3-year reappointment process. So we actually are thrilled at Senator Lamb's willingness to sponsor this, and we urge support and passage of Senate Bill 258.
Thank you. See no questions from the committee. Thank you very much for your testimony.
Thank you. Thank you.
I did have a Marcus Ross signed up on this bill. Going once, going twice. And that will conclude the hearing on Senate Bill 258.
Thank you.
Enjoy your afternoon.
Thank you. You too.
Okay, we're going to turn to Senate Bill 299. Which is, let me say it real slow. Senate Bill 299, which is Food Service Facilities Automated External Defibrillator Program. Senator Kramer, and you can feel free to bring forward your panel if you have one.
Thank you, Madam Chair. I would appreciate that very much. Carol, are you in here? Uh-oh.
A lot of people in the hall.
Uh-oh. My panel is not here being a panel. Ruh-roh. You mind if I just? Yeah, me too. Do you mind if I just yell out in the hall real fast, Madam Chair? See if I can shake my panel loose. Carol McDermott, you back here? That's a good idea. Take an opportunity to stretch, Madam Chair. Everybody. Come on, Senator Lamb. Do we have our other folks here? Are they coming in? Okey doke. I found my panel, Madam Chair. Thank you, Madam Chair, and good afternoon, colleagues. Ben Kramer here introducing Senate Bill 299, the Joe Shia Act. Colleagues, this is about a bill about saving lives, period, end of story, saving lives. This bill relates to the subject of sudden cardiac arrest, which is a sudden and unexpected abnormality of the heart's electrical system, which causes the heart to stop beating normally. When one occurs, blood stops flowing properly and the person collapses. The only way to restore their heart rhythm is by administering a shock immediately, and anyone can do it. An AED will analyze the heart rhythm and tell the individual to deliver a shock if it is necessary. And we're going to have an example of how the AEDs work very shortly. The shock is only given if in fact it is required. The AED also directs the individual how to properly place the pads and administer the shock. And if they've got it wrong, it's not going to deliver the shock. So the bill before you would require that food service facilities in the state have a program for implementing an automated external defibrillator, an AED. And the purpose for that, and by the way, colleagues, this committee in 2016 passed this bill unanimously, and it passed off the Senate floor with a 41-6 vote. Unfortunately, as things sometimes happen, in the House, it was turned into a study. And the study was conducted. And interestingly, and we'll clearly hear from my friends in the food service facilities that they're opposed to the bill, and I don't blame them. I get it. But the study showed, although it doesn't happen frequently, it does happen. And in restaurants alone, by the way, as a course of the study that was done, it was shown this happens more frequently, cardiac arrests, than at the racetrack, golf courses, public beaches, hotels and motels, movie theaters, at the park. Surprisingly, happens in restaurants more often than at health clubs and gyms. It also happens more frequently than at swimming pools, which, by the way, we do require by law that AEDs be placed at swimming pools. The chances of survival when shocked with an AED increase dramatically. For every 1 minute that an individual is in cardiac arrest without getting a shock, the chances of their survival are diminished by 10% each minute. If they do not get a shock within those first 10 minutes, there is virtually no chance of that individual surviving. However, when they do get that shock in the first minute, 9 out of 10 times, they make a full recovery. That is how important these devices are. And they have become so sophisticated, as I had mentioned, that now the device tells you everything you need to do. The device walks a total stranger, Ben Kramer. I see it happen. I think I could even manage to make the device work and save a life. So again, I understand that our friends in the food service facilities, and by the way, when the restaurants come up and want to know why we're picking on them, we're not picking on them. This is the entire food service facilities, which is a large, broad swath of entities in the state, well beyond just restaurants, that we are asking to have these devices on site. The cost in the big picture, it's not a huge deal. Brand new, they're now in the $800 to, at the high end, $1,500 range. Certified used ones are $300 to $500. So in the big picture, when you think about it, and by the way, the bill provides that it's only, the law is only applicable to food service facilities with gross sales of greater than $400,000. So we're talking a larger business that has already made a significant investment in their equipment, which also is required to have significant safety applications in those in their equipment in restaurants. And we do have all kinds of safety requirements for food service facilities. So the question before you all is simply going to be, are we as a legislative body going to require that this segment of our business community provide this life-saving AED in their facilities? And is that worth saving a life? And I would proffer to you that for me, hands down, one life is going to be worth the $500, $800, $1,000 investment that we require of these businesses. And by the way, Senator Zucker in Budget and Tax is offering a bill that is tied directly to this, that would provide a $500 tax credit to any of the restaurants. It does say restaurants in his bill, not food service facilities. So it wouldn't be all inclusive of the businesses that are part of this bill, but it would provide a tax credit that would either cover the entirety of the AED or a significant portion of it, depending on the AED that's purchased. With that, colleagues, I will turn it over to the panel featuring the lovely widow of Joe Shia, for whom the bill is named, and certainly appreciate the committee's serious consideration, as was done in 2016 when the bill passed this committee unanimously in the same posture. Thank you.
Thank you, Senator. Thank you. Madam Chairwoman, members of the committee. Joe, my dear heart husband, was a joyful man who was not ready for his life to end. He was a public school teacher for over 33 years. He was a Reiki master who helped Congressman Jamie Raskin during the first fight for his life. He rode motorcycles with Senator Astle and was a student pilot. He taught Hapkido, gun safety, and scuba diving. He was an officiant who united many couples in marriage, including our 2 daughters. He was a lot of fun, a loving, honorable, courageous, good man. He was a victim of sudden cardiac arrest. There was not an AED available in the restaurant. He did not survive. Damar Hamlin is a joyful young man, a talented athlete who gives so generously to his community, a good man. He was a victim of sudden cardiac arrest. There was an AED available. He did survive. Cedars-Sinai Heart Institute states, compared to Caucasians, African Americans face twice the rate of cardiac arrest and are an average of 6 years younger. The Maryland Restaurant Association website says the restaurant industry is the most diverse industry.
The patrons that support the restaurants are a beautifully diverse population that spent $15 billion in Maryland restaurants in 2021. Legislative Services said regarding the Relevant Comar section, this bill does not require a trained person on site at all times. Yesterday, MIMS wrote to me, quote, "A trained person is not required to be on site at all times. Anyone willing to operate the AED can do so without being trained." They do have one AED coordinator on site, but they do not need to be there to have the AED used. They're, of course, covered by the Good Samaritan law. According to MIMS, the cost of AEDs varies from $500 to $1,700. This is a very small price to pay to protect the owners, the employees, and the patrons that keep the Maryland restaurants open. Please accept this bill for what it is, a simple, inexpensive, undisputable way to save lives that are not ready to be ended. From my heart, thank you. And I think it's important to mention that in each building here on campus, at the security entrance, there is an AED, and in the State House, there's one on every floor. Thank you. Dr. Zachariah.
Here's the more glamorous part.
Give you guys a quick demo, exactly how the AED operates. We were trying to get Senator Hershey to volunteer, but he wasn't. So Carol's gonna be our volunteer victim. This is a. Yeah. This is a trainer only, but it simulates exactly what would have happened.
We
in
have a real one
situation.
if you want to. If you want to try. I'll invite him up to my office later.
So they talk to you, it requires no training, they tell you everything to do. If it decides to come on.
Unit open. Stay calm, get responsiveness, call for help.
Talks to you, shows you pictures, the words are on the screen. You open the envelope, you put the pads on the person, of course, you have to have their clothes off and it has to go on bare skin. I won't embarrass Carol like that. Senator Hershey wouldn't take his shirt off, so we have tape here. And we're just gonna pretend to put these on her. They go on just like that.
Don't touch patient, analyze it.
It then analyzes the rhythm of the heart to see if they're in a shockable rhythm or not.
Don't touch patient, analyze it. Shock advised.
I assure you, this is a simulator. A real AED still won't shock anyone. It doesn't need to be shocked. You press the shock button, it shocks them. It walks you through CPR. It'll tell you how to do CPR. It'll tell you if you're not doing CPR correctly and how to correct it. It's as simple as that. This beep means you should be doing chest compressions. In 2 minutes, it'll stop you. It'll reanalyze the heart and shock again if necessary. As Carol said and the senator said, it will walk you through every step of the process. It really is foolproof. So simple to use, doesn't require training, pretty inexpensive, and the only way victims are going to survive cardiac arrest 95% of the time, they do not survive. If they do survive, it's with an AED, a fast defibrillation, as you've seen most recently in the news. So thank you for your time in demonstrating AED.
See, it's more glamorous than my testimony. Thank you for the opportunity to present. My name is Sammy Zachariah. I'm a cardiologist at Johns Hopkins, and it's an honor to present in front of the Madam Chair, in front of all the senators here. I currently serve as director of the Johns Hopkins Bayview Cardiac Intensive Care Unit and work at Johns Hopkins Hospital as well. And I've worked at other hospitals in the state, including the University of Maryland. I'm also the governor-elect of the American College of Cardiology for the Maryland chapter. It's not as glamorous as the governor over 1 block away, but it does represent about 100 cardiologists and about 200 cardiovascular professionals. So all of us are in favor of this bill. This will save lives. When we were testifying about this 2 days ago at the House, we were talking about my personal experiences where I was at a restaurant in Pikesville, and there's 6 cardiologists, and we had a patron who had a cardiac arrest at that time, and we did CPR, but we were useless without an AED.
And we were doing compressions until the EMS came up. If there was one on site, it would have made a big difference, and then we had to rush to a car to get one. And that's why now I bought my own just in case, but I haven't used it, thankfully. In the hospital setting, I must have seen more than 1,000, 2,000 patients with cardiac arrest. The ones that do well are the ones that get prompt CPR and get defibrillated within a few minutes. If you finally get a defibrillator after 10, 15 minutes, those patients may survive, but they're irreversibly neurologically injured. Their brain is not going to be the same. And that's devastating for the patient. It's devastating for their families. It's devastating for the state, for that matter, where they're now unable to take care for themselves. So, we're here to support this bill. We're happy if you need more information from us. I'm certainly available to take any questions. Thank you.
Thank you. I have a couple of quick questions and then I'm going to call on some colleagues. I was actually not here in 2016. So my questions may be for those of you that were sound a little elementary, but the device that you just demonstrated, does it require being charged or refreshed in any way?
That's a great question. So for the devices to be sold in the United States, they have to be approved by the FDA. The FDA sets regulations that they have to go through a self-check every 24 hours. So they don't have to have electricity. They all have battery packs. Those battery packs and the AED itself goes through a computerized check on a 24-hour basis and will alert the end user, the owners, that the AED, it's like a smoke detector. When it needs a new battery, it'll beep at you. These do the same thing to alert that they need new batteries. So it does take a human to come in, hear that alert, put new batteries in it, but they run through a self-check every 24 hours.
Okay.
The only maintenance is needed to change the batteries and the pads about every 5 to 6 years without use.
Okay, so 5 to 6 years if it's not used. And then do you have a sense since this passed or since the bill passed out of one chamber some years ago as to whether or not there was an uptick, and maybe for the sponsor, if there's been an uptick in usage since there was some initial indication that there was support for this back in 2016? Have you seen any change, like voluntarily without the bill?
I'm not sure that there is any methodology for tracking that. And so I have to say, I have no answer for you. Some of them are if it is registered, but see, if you're doing it voluntarily, you don't have to have it registered with the state, I don't think.
Okay, so would the
So-
bill require that registration, or there's some?
The bill does at the moment, and by the way, because there is a little bit of confusion, and I'd like to see if we can maybe get it rectified. These have advanced so much that they do it. The devices will talk, like I said, me through it. That currently under our education article, which is where the AEDs are housed, there is a requirement to have somebody at the facility who's trained. I'm not sure that it's appropriate at this point to have that requirement. So I would like to have the opportunity to look a little more closely at it. And we got an email yesterday from the state agency that oversees this, and they said that you don't have to have somebody on site that is trained, but I think there still is this question, do you need to have someone at the facility, even if they're not on site, that is trained? And that's what I want to try to get clarified, because this email that we got said, somebody doesn't have to be on site that has been trained.
Fair
So-
enough.
Yeah.
Thank
May
you.
I, Senator? Is it okay? So they do require now an AED coordinator. So it should be somebody from the business who makes sure that it's registered, makes sure checks it once a month to make sure the batteries and everything are okay. And to say to the employees, here's where the AED is if you need it. But that coordinator does have to be trained every 2 to 3 years, but they do not need to be on site for the AEDs to be used by a bystander, an employee, or anything.
Thank you. So we'll go to Senator Mounts, Vice Chair Klausmeier, and then Senator Hershey.
Thanks, Chairman, and thank you, Chair. So for the devices, we're voting, and when you are voting on things, it's important to know, true, just some of the information. The price on the units, where did you come up with that price, the proposed price? I'm looking at an invoice for one that's it's $2,224 for a new unit.
Wow.
Does that sound logical?
No,
Or
that's a
does that
very,
not sound-
that's one that the fire department might use. But I think for NIMS said that they're about from $500 to $1,500 typically. I very rarely see anything.
If you look in the
above
fiscal
2,000.
note.
I'm looking at an actual invoice. Like I did a little research on it and checked it out. And that's the invoice I got, but I didn't do a lot of, I didn't go try to find the discount one. I just wanted to, I wanted to see if that made sense. I'm not against AEDs. I lost my father to a heart attack. And I wish I had one at the time, you know. But I didn't know that price because I've got an invoice that I was looking at and that price differs from the testimony. And
I mean, I could speak a little bit. I think you can find them as refurbished as the senator described. I know that they can be through a nonprofit for up to $600. You can get one with more bells and whistles that you don't have to push the shock button. That might be $2,000. I'm assuming you got a price from a vendor, so depends on what their markup is on it. But they are, I would say the range is a fair range to say from $500 to $600 for a refurbished one to it could be around $2,000 for a new one. All depends on who you're buying it from.
yeah, and then is there a monthly service fee for them?
No, I mean, again, some vendors will sell you a package where they come out and they'll do checking on it for you every month. Is it required? No, like I said, the FDA makes them to a standard where they have to do a self-check every 24 hours.
Okay.
And then the person should know, the coordinator, as Carol spoke to, should know the expiration date for the batteries and the pads so that they can be replaced when expired.
Because the invoice that I was checking out, I had a monthly fee and it was $350
For the year.
No, it was a monthly fee for administering.
Oh.
No, for the year.
For the
You're right,
year.
You're right.
So some of the companies out there will offer you packages and services. They're kind of like buying a car, depends on how fancy you want your car to be and how big the maintenance package you want to be on it.
Right.
But none of that's required or necessary.
Right, but it's not, well, anyway. But that makes sense. There are some out there that have a monthly fee and that.
Yes, and you can rent them. And they have a fee.
And then where did 400,000, where did that come from to be the cutoff for what businesses should be covered and which ones shouldn't?
That's a good question, and it was tied to the minimum wage and overtime exemptions that we passed here in the state. So that was the original guide that was used in 2016, and it's, again, the bill's identical to what we did.
My question sounded critical, but I am not critical of AEDs. I think they're great resources.
I didn't think it was critical at all. I think it was a great question.
Thank you, Senator.
Thank you, Vice Chair.
I know we have them at the entrances to come in here. How long can a person go without being shocked or, because somebody would have to run all the way down 3 flights of steps and go out to the entrance and then get back up here. Is that enough time?
I can start with the answer, but so the statistics are for every minute that passes, your chance of surviving decrease 10% per minute. So if it takes 5 minutes to get it on, you got a 50% chance of survival. I'm delighted that one's in this building. They should be in every building, but one's really honestly not enough for this building this size.
Okay, and then the other question I have is the machine, you have that on, you put that on, but then you have to do CPR as well.
Correct.
So-
And most machines will walk you through that process as well.
Yeah, but the CPR, does it tell you how to do CPR?
Yes, it has
Okay.
pictures and it has compressions. And if you're not doing it right, it'll auto correct you. I shouldn't say auto correct you, it'll
Okay.
verbally
Well,
correct.
that to me is worrisome for me because I'd be so worked up, I wouldn't be able to read it. So, but okay, thank you.
It talks to you too.
Thank you, Senator Hershey.
Thank you, Madam Chair. And Carol, it has been a pleasure working with you on this piece of legislation for so many years, and fingers crossed this is the year. And so we're very hopeful about that.
Thank
Madam Chair, I think you talked a little bit about, our restaurants doing this on their own. And that's obviously certainly something we'd like to see. And I think just by observation, I know that I've noticed it more often than not, but I think we still need to get to that next step where it is a requirement in locations that we see this happening more often than not. And Carol, you'd mentioned Damar Hamlin. For those that might not know that name, which could be hard for people not to right now, he was the football player on the Buffalo Bills that had the cardiac arrest event on Monday Night Football and was saved because the training staff for his team had this device and knew immediately to use that. And I think what that has also done, and maybe to the vice chair's comments about people being apprehensive to use these types of devices and not fully understanding, whether it's the AED, whether it's, administering Narcan, whether it's, the Heimlich maneuver or something like that. That event, from what I've heard, has caused more people to sign up for CPR classes and saying, I want to be in a position that if something like this were to happen, that they know the skill sets in order to be able to use that. So without saying, isn't that so? I just wanted to, again, thank you, Carol, and thank you all for being here as well to present
Thank you,
this bill.
Senator.
Thanks.
Thank you. Senator Reedy.
Thank you. I had just a question about, do we have any idea about current compliance, not compliance because it's not mandated, but current participation by restaurants? I know you said there was a study done. There was a study done a while ago. I mean, did that include any information?
Not that I'm aware. I don't think that was part of the study unless Carol is, I don't think that was.
I'm a big believer in, and Senator Hershey mentioned a big believer in trying to encourage and incentivize as opposed to mandate. And our small restaurants particularly, it's not an easy time. And $400,000 sounds like a lot of money, but it's not. I will say I looked up on Amazon. I think a brand new one I'm selling on Amazon is about $2,500. I understand you could probably get some refurbished that are cheaper. So I have to do some considering about this, but I was just curious if we have any sense, and maybe when they come up to testify, we can find out if there's any sense of, how many restaurants we're talking about that don't have this versus not. I assume there's no easy way to collect that data, but anytime you're adding mandates, this one seems like something, well, of course we would want to do it, but this is not the only mandate we put down on them. So I've just got to consider that, but thank you for your answers and for the great presentation.
Thank you. Senator Ellis.
Yeah, thank you, Madam Chair. So, I just reading the bill, listening to the testimony, and thank you, Senator, for this bill, and sorry for your loss, your husband, man. So the restaurants, I think there's a training component in there. Is that correct? It's not just putting these defibrillators in the restaurant, but there's a training. Is that, would that be part of the
one person
process?
needs to be the AED coordinator.
Mhm.
They need to be trained in AEDs and CPR every 2 to 3 years. And that person is expected to monthly check the AED, make sure that they're registered with MIMS and, everything is properly being done. Nobody else needs to be trained.
Okay. Yeah, so I'm kind of concerned about that. Echoing on our vice chair's comment about if we're up with that situation where someone needs that help, even listening, following instructions will be very challenging. And so I know from way back when in the military, we were required to have every member annual CPR training. And it doesn't take long. And maybe it was maybe an hour per year to kind of go through the process. And we didn't have to go to a special school. That CPR coordinator, we had one additional duty in every unit in the Air Force, was responsible for going through the training with each member. And like I said, it wasn't costly, it wasn't very time consuming, but very effective. Would you consider that as far as, would that be too onerous, you think?
It's one of the restaurant's major concerns is that They think it would be very expensive to train everybody. Every high school graduate in Maryland has to have CPR AED training. And there are people like Dr. Zachariah and Ryan Killo who offer their time frequently for free. Compress and Shock offers there's free classes everywhere. Anybody who's interested, if you want to pay for one, you can get them from $20 to maybe $100. I think the most expensive class I've ever seen was for about $115, but all the classes I've seen are donated. They're free. So not trying to put more restrictions on restaurants, and the law is currently that only the coordinator needs to be trained. But as far as being panicky and stuff, they're already dead. If you don't do something, if you don't put those pads on their chest and press that button, no matter what, you're panicking, your heart's going to be pounding, it's going to be terrifying. That's how they're going to survive.
Yeah, and that's so true. And, I've had a close family member pass away in a restaurant, I won't name the restaurant, a couple of years ago.
I'm sorry.
So it's a real issue and that we need to really pay attention to. And it's not really, you would think if we go through the extra effort to be prepared to save someone's life, what price can we put on that?
Right.
Yellow. Thank you, Madam Chair.
Thank you,
And
Senator.
if I could just add to that, the training is very important. Of course, I think everybody should be trained. That's another subject. But, if you use the FAA, for example, an AED is required to be on every FAA regulated flight in the United States. Nobody on there has to be trained. A lot of times they count on paramedics or physicians to be on board to help them assist in resuscitation, which is the same thing you could expect in a restaurant or to be a nurse or paramedic in EMC.
Thank you so much. Thank you very much for your testimony. I don't see any further questions from the committee for this panel, so thank you. I think we have one other witness that was signed up on this bill that is favorable, Garima.
She's sick.
sorry.
Sorry about that.
Okay,
Yeah.
thank you very much. Then we'll move on. We have two additional witnesses, Callie Locklear and Melvin Thompson, who've signed up in opposition to the bill.
So sorry.
Good afternoon.
Good afternoon, Madam Chair, honorable members of the Senate Finance Committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Association in respectful opposition. Sincere condolences to the family. I want to start there. And we firmly believe that this bill is well intentioned. We understand that instances do and can occur in public. But our food facility locations barely rank, contrary to what was presented on the cardiac study from 2017. And we need to flag a handful of issues for you all. The AED bill language before you in this bill specifies meeting the requirements of section 13-517 of the education article. That includes device maintenance, facility registration, certification, and training for each individual who is expected to operate an AED for the registered facility. Because employees would have to receive training and certification at a time when it's extraordinarily difficult to find employees, this can be an additional obstacle for employers who may have existing and potential employees who are uncomfortable performing this task. But probably most concerning is that with high turnover and numerous shifts, having somebody on each shift that needs to be trained just may not be possible. We would prefer the carrot approach here rather than the stick. There's actually another AED tax credit bill. It's Senate Bill 624, but it's just a tax credit for restaurants. So I reached out and asked them if they would broaden that definition to food service facilities, and they said no. So that was really interesting. These devices do cost money. I think what's reflected in the study is actually old information. If you go to aed.us, they can be a lot more expensive and there can be routine maintenance costs as you flagged. But we really believe that a business should be able to choose whether or not they're going to have such a device on their premises. So I'm glad to answer questions. We urge an unfavorable report at this time.
Thank you very much, Madam Chair, members of the committee. I'm Melvin Thompson. I represent the Restaurant Association of Maryland, and we're also opposed to this legislation. And of course, I'm so sorry for the loss of Carol McDermott's husband. But I just want the committee to understand that the way this bill is drafted, an estimated 7,800 of Maryland's 11,000 restaurants would be required to comply with this bill because they have over $400,000 a year in gross annual revenue. And according to the 2017 study by the Maryland Institute for Emergency Medical Services Systems, that study revealed that the incidence of cardiac arrest is very low at restaurants compared to the other ranked locations. In that report on Table 1, restaurants are at 26 out of 31 location types. And in Table 2 of that report, restaurants are at 23 of 26 location types. And as noted in the report, knowing how probable it would be to experience an arrest while in a given location type is important to consider when trying to determine the placement and education for AEDs. And we also saw the same language in a similar 2007 General Assembly Task Force report on this issue. In that report, it said that programs that place AEDs at low-risk locations are unlikely to be cost-effective since there is a smaller likelihood that the AED will ever be used. And, you know, this would be a significant cost on our industry, not only for the device, but as Kaylee mentioned, for the training, particularly in the restaurant industry, where we have very high staff turnover in our industry. And as we understand the requirements for training under this program, you are required to have anyone who is expected to be able to use the device to be trained in CPR and AED training. So to us, that's everyone who's working on a shift could be expected to use that device. And so for these reasons, we oppose this legislation. We don't think the incidence being low at our industry justifies the cost to us. And so we request an unfavorable report. Thank you.
Thank you. Senator Kramer.
Thank you for that, Madam Chair. Ms. Locklear, I make note that most of your concern, if not entirely, was around this issue of training and employees becoming uncomfortable at the notion of having to do this. I just want to share there is nothing in the legislation that requires anyone to act. And in fact, our Good Samaritan laws already address that. Should someone choose not to utilize an AED, they're not required to. But I also had mentioned in the introduction of my bill that there is some conflicting information with regard to the necessity to have people trained, particularly that they don't need to be on site. So I'm hoping to get some clarification on that. And if we were to get clarification on that, that in fact, somebody every shift doesn't have to be trained, and we don't have the challenge of finding already difficult to hire employees and sending them off to be trained. If we can get that issue more closely identified, would you then be supporting it, since it seems that most of your focus in your testimony related directly to the training piece?
Always open to a conversation, but if I may, I think the answer is actually already in the packet of information that you have from MEMS. In the second paragraph of the letter that they sent to all of you, and just reading directly from it because it gets to your question earlier, by statute, MEMS administers the Maryland Public Access AED program. That statute requires non-healthcare facilities that place AEDs on their premises to meet certain requirements. And those were the requirements that I went over earlier.
Correct. And that's what I'm saying. There seems to be, because there seems to be some contradictory responses with regard to that issue. And my point with the committee was maybe we can, it certainly seems to me that that might be outdated in light of the advancements in the technology.
Sure.
That, you know, the devices now just will talk you through it. And therefore, we've come a long way where you really don't need that training to learn how to use the piece of equipment. So I am hoping to get a little clarification on that.
Great.
Thank you. Senator Reedy.
Thank you, Madam Chair. Maybe Melvin, this might be better for you, although either one of you, I suppose, could answer it.
Yes, Senator.
Are you aware of issues where is it true that the Good Samaritan law would cover somebody in your restaurant using one of these on somebody? I mean, the demonstration, talking about taking somebody's shirt off, putting something on their bare skin, I would find that a little intimidating unless I was really well trained. So my concern about, I mean, we obviously need to straighten out this one issue was just discussed, but could you just talk about, like, is it your understanding that someone would be covered if they tried to use an AED and they make some kind of mistake? Or I understand it's cardiac arrest, but what if it's something else and they think it's cardiac? I mean, can you just talk about that?
Well, certainly, and I'll just say generally, I'm not an attorney, but I did look at the Good Samaritan law, and we would ask our legal counsel that question because the Good Samaritan law is just in general, whereas under this statute, you are provided that liability immunity civilly, specifically related to the use of an AED device if you've had the certification, you've registered, and you have the required training. So we would want to make sure that the Good Samaritan coverage would be the same there for the use of an AED device rather than just in general.
And I know you guys don't want us to require this, but if we were to require it, I would want to be sure we're very clear that if someone, let's say, doesn't use it because they're not trained and then someone dies and, oh, you had one and didn't use it, I don't want the restaurant being sued. Conversely, if somebody does use it that wasn't officially trained because they're trying to help, so those are issues I think we also should try to work out.
To your point it's on page 3 of the study that goes over immunity. So first of all, if you're registered, as long as actions are not willful or grossly negligent under that existing program, the business then has liability protection. The Good Samaritan law says that you may be able for an individual to claim immunity. So to hit that point. And then most interestingly, the Court of Appeals held that Maryland businesses that opt to have a defibrillator on site have no legal obligation to use it in the case of cardiac emergency. So that's something else interesting to flag for the
So
committee.
all things we should probably try to
Figure all that
work
out together.
I generally am against mandates, but this is one where it's like, hey, we want to be sympathetic and think if you're going to mandate something, this is not a bad thing necessarily, but we need to get those details worked out.
I have Senator Mounts, then Senator Ellis.
Just a quick question. And whether it be a retailer or a restaurant, how would the business know whether it was covered by this if it were enacted? It says 400,000. So the businesses, I'm kind of unclear on how that would work. It says if it's over 400,000 in gross revenues, then it would be covered by the bill. But that's kind of a interesting way of trying to say who's covered and who isn't covered. And then I always look on regulations like what is the punishment? And it seems like it would be business license type thing where if there's a violation, then I'm not sure.
Well, on the $400,000, Senator, and thank you for the question, that is on gross annual income. And so that would be your sales. And most businesses would know what their sales are, but it does not say net. And so you can have $400,000 in gross sales, but if you're an industry like restaurants where you're averaging a 4% profit margin, that doesn't leave you a whole lot left from $400,000 in sales.
And groceries 1 to 3% profit margin for the record, which is just interesting in that conversation.
And what about the penalty?
So that's interesting. It's pointing us to a different section. So I'm not clear on the thoughts around penalties here. Bill doesn't specify anything. That would not be ideal.
Thank you.
Yeah, I see nothing referenced in the fiscal note either, Senator.
Yeah, gotcha. Senator Ellis.
Yeah, thank you, Madam Chair, and thank you for your testimony. You mentioned, Haley, a registration. Could you go over that? Who has to be registered and
Yeah, so there are requirements, you may be able to pull it up in your computer, but it's Comer 30 .06 includes all of the criteria around that registration. Our understanding of that, and this is what I talked about earlier, is you have to maintain the device itself. So these devices, pads have to be replaced, just like everything else.
When you say you're referring to
If you had this device, you
Well,
was the
any-
business,
the
excuse me.
business, okay.
Correct. So if you had one of these devices, device maintenance must be met, and the state sets certain standards around that. The facility itself has to be registered. It has to be certified. And in order to receive that certification, you have to meet those criteria, but then also have an individual who is trained to use the device. So that's what they lay out in the law.
So that's the current law.
Correct.
With having these defibrillators in businesses, any business.
Correct.
So it's not just buying one and stick them against the wall. Is that what you're saying?
So this is where we go back to a little bit of the confusion that we were talking about earlier, where the statute is requiring non-healthcare facilities that put an AED on their premise right now to meet these requirements. That is what our law currently says. So we might need to tweak that if the thought is just put the AED on the wall, it walks you through it. Liability protections are there under Good Samaritan, walk
Thank you.
away.
Thank you. So if this bill passed, would it change that registration requirement, or that will be still there?
We're gonna have to talk about whether that needs to change or not, and what the committee wants to do around that.
Okay, so it's a gray area right
A
now.
little bit right now,
Okay,
yeah.
all right. Thank you.
Thank you.
Okay, thank you. I don't see any additional questions from the committee on this, for this panel, so thank you very much for your testimony. That is the final testimony on this bill, so that concludes the hearing on Senate Bill 299. We'll now turn to Senate Bill 298, State Personnel Collective Bargaining, Supervisory and Managerial Employees. Senator Kramer. I just remind the members, we still have about, 60 or 70 witnesses to hear on the bills that we have remaining. So maybe we want to keep that in mind as we have our conversations, and isn't that so moments with the witnesses? Good afternoon again, Senator Kramer.
Thank you for that, Madam Chair. Good afternoon to you, Madam Vice Chair, members of the committee. Ben Kramer here to introduce Senate Bill 298. Colleagues, this is a very straightforward bill. Currently, within state government, our state agencies, and our University of Maryland system, the managers and supervisors, and there are thousands of them, are not provided the opportunity of, having collective bargaining, should they choose to do so. This bill simply extends that opportunity, that right, which I believe all of our public employees should have, the right to avail themselves of collective bargaining if they choose to do so. There's nothing in the bill that specifies they have to do it. It is enabling. There's nothing in the bill that says a particular bargaining unit is going to represent them. As I said, it's straightforward. I heard earlier in conversation about supervisors and managers from the university system that they believe that somehow this violates and creates a conflict of interest between managers and supervisors and colleagues. Seriously, the fact of the matter is, right now, a manager and supervisor negotiates their contract. What changes if instead of doing it on an individual basis, they decide my interests are best represented by a bargaining unit to negotiate? What are my working conditions? What is my pay scale? What are my benefits? Nothing at all changes. So this notion that somehow managers and supervisors are going to have a conflict of interest is ludicrous. They're still going to do their jobs, whatever that job assignment may be. And it varies dramatically depending on what the duties of that manager or supervisor are. But clearly there's no conflict of interest. This is not an extension of the president to the non-managerial employees. So colleagues, I firmly believe that the hardworking women and men in state government, regardless of their job position, should, if they choose, be given the opportunity to bargain collectively. And with that, Madam Chair, I have a panel here that knows exactly what the issues are. Thank you.
Good afternoon. My name is Denise Gilmore, Legislative Director with AFSCME Council 3. I wanted to thank the Senator for bringing this important legislation forward. Many of our members, when they get promoted, maintain their membership because with our union, because we can still represent them on issues that are related to like disciplinary appeals or grievances. They're still merit employees. The one thing they lose is their ability to collectively bargain for pay and working conditions. We think this is incredibly unfair. There is plenty of precedent both here in Maryland and nationally for employees who have supervisory and managerial duties to collectively bargain. I too want to quickly reference some of the comments that were made on a previous bill on the topic of supervisors and managers negotiating. I should state, like, the previous bill does not enable collective bargaining for supervisors and managers. This bill does. So that, is the first thing I wanted to clear the air on. But the second notion that there's some kind of conflict either with the National Labor Relations Act or internally in the process that management is untrue. Nationally, the best way that we can point to this as example is that we already do it. Here in Maryland, principals, public school administrators have collective bargaining. AFSCME has collective bargaining units in Prince George's County with supervisors, and Howard County with supervisors, and Baltimore City with supervisors. Nationally, we've organized supervisors and managers at all levels of state government and higher ed. Just listing a few of these states, it's in Connecticut and Michigan and New York and Massachusetts and Washington and New Jersey and California and Minnesota, Hawaii, Rhode Island, Pennsylvania, and again, Florida. These are all states where we do this already. We would very much urge a favorable report on SB 298 to give these hardworking employees the ability to collectively bargain. Thank you.
Hi, my name is Crystal Cooper, and I'm a supervisor at the Motor Vehicle Administration in Glen Burnie. I'm here today to ask for support for Senate Bill 298 for passing collective bargaining for the state supervisors and managers. I've been with my agency for 12 years. I recently was promoted about a year ago, and I had to make a decision. Did I want to be promoted because I knew my hard work with AFSCME would then have to be put aside. I don't feel like I should have had to make that decision. I have been very committed to my agency for the last 12 years, even wanting to move. I even wanted to move to another state agency. So all state agencies, we are very committed to the state agencies. We're committed to improving the conditions there, and we should have a right to be able to collective bargain. I also wanted to make sure that no other person was put in my shoes of having to decide whether to be promoted or not be promoted because they cannot bargain. So I'm asking that you support us.
Thank you. My name is Jerron McCall. I'm currently employed at Morgan State University, where I have been so for the past 32 years. I work at Morgan in the capacity of an HVAC chief, which they consider as a supervisory position. However, I do not hire. I do not fire. I do not have the authority to exercise any of those independent judgment opportunities that the supervisors currently do. I support this bill because, like my coworkers, I've been a union member since day one. I started there as just a simple HVAC mechanic and was promoted several times, and then I'm the leader of the unit. However, I do not have the ability to collectively bargain over my wages and working conditions, and I feel as that is not right. I think it's unfair that I don't have a voice at the bargaining table, and nor that I have a voice to make the workplace a better place to work. So therefore, I believe that this bill will level the playing field. I believe that it will give us the opportunity to make a more cohesive working environment, and that we can protect the rights and benefits and working conditions of all employees, not just the small exempts and non-exempts. Thank you for hearing me today. I appreciate your time.
Good afternoon. My name's Renee Nadro, and I'm a customer agent supervisor at the Glen Burnie headquarters Motor Vehicle Administration. I'm here today to ask you all to support Senate Bill 298, passing collective bargaining for the state supervisors and managers. I have been in my agency for 27 years. I started in a position that was in a collective bargaining unit belonging to AFSCME. Now that I'm a supervisor, I still work alongside my union coworkers. The difference is that they have a voice on the job, but I don't. In my time at the state, the staffing crisis has never been as bad as it is today. Whether it's due to the pandemic or the vacancies that were never filled, the result is still the same. My agency is in dire need of more staff, and that is an issue my colleagues and I deal with every day. Supervisors are working with other frontline employees to make sure that the agency keeps going. We are the ones making plans on how to split up the workload between our employees. When someone calls out sick or goes on vacations, the supervisors fill in to get that job done. Supervisors train new staff to carry the quality standards that make Maryland State Service excellent. We work day in and day out to make sure our employees have what they need to do the best job possible. However, when we have a concern or idea to make things better, we have no collective bargaining to make those improvements, but the employees we supervise do. In my time at MVA, I have learned what works well and what doesn't. I know from experience that the way to make the workplace better is for its employees to have a voice in the day-to-day process and the ability to problem solve along with the decision makers, and the right to negotiate their own working conditions. For these reasons and so many more, I'm asking you to support collective bargaining for the supervisors and managers so that we can continue serving the public and make our agency better than it is today.
Thank you for your testimony. Senator Guile.
Thank you, Madam Chair. I've got just a couple quick questions that I think I'm just going to ask it all at once. And maybe this committee already knows these answers, but I don't. For the definitions, for one, what's the difference between a supervisor and a manager? And other question is, I see it's a confidential employee, and I guess I don't know what that means. So you could help me out. Thanks.
Yeah, I'd be happy to. So honestly, a lot of times it's just how they're classified. I will even say, like, internally, we don't always understand the classifications or that they make sense, but certainly within the state, they've got a process where they classify employees based on bargaining units already. And so the employees that they determine to be supervisors, they put in like Unit S for supervisors. The employees that they determine to be managers, they put in Unit M in managers. I think duties vary. I will say a lot of times folks that are in, supervisory positions, for instance, don't do, lots of, even supervisory duties on some instances, but that's how they're classified. In some instances, they have a much more active role in like assigning, duties. So it really is just a classification system that management uses. I think the second part of that question was kind of around confidential status. So, an employee who is, for instance, knows management's bargaining position, right, would be considered confidential and not eligible for this bill. An employee who, is involved in representing the, agency in, labor relations or, disciplinary issues, like they've got access to information that would maintain their confidential status. They would not, be eligible for this bill. The folks that are eligible for this bill in many ways are, to use a term, worker bees like everyone else. They are, executing the duties and responsibilities of the agency, and we, in our opinion, are doing so in a really great way and doing a great job with it, and deserve to have the same collective bargaining rights that their subordinates do.
Thank you. Thank you, Madam Chair.
Thank you. I don't see any additional questions for the sponsor of this panel. Thank you very much for your testimony. We have additional witnesses signed up on this bill, so listen closely. Marilyn Miller, Christopher Cano, Nita Hodges, Donna Edwards, and LaPaul Morceau. Oh, no, we're just getting warmed up today. Good afternoon. Good afternoon. You guys go first. Somebody start. You want to start?
I'm sorry, I'm just wanted to introduce the supervisors and MCEA members that are testifying today. I was not approved to be on the panel, but I wanted to just introduce LaPaul Morceau.
Good afternoon. I'm LaPaul Morceau, Madam Chair and committee members. I am sorry if I'm whispering. I am with the Maryland Classified Employee Association, a 10-year member. I've also been with the state of Maryland as a supervisor for 5 years, but with the state of Maryland for 17. Maryland workers, because of its state employees, we're keeping the roadways safe, the waterways. We're ensuring that drinking water is clean, educating students with special needs, working in state hospitals, as well as providing vital services to Maryland residents. Currently, this administration recognizes the problem, coupled with a state legislator that has been more budgetary authority than it has been. This bill, Senate Bill 298, will begin to reverse that trend. The three things I want to just make clear is that the Maryland General Assembly must pass a budget that does three things: fully funds and dramatically increases state employee compensation. State employees need to be treated as the professionals we are. Some of us, such as myself, we're working an extra 8 to 10 a week, which gives out 40 hours in a month, which is half of the salary, right, that we were making a week. The second thing is that this bill will not cut staff. Too many agencies are having to, they have too many vacant positions, and I think that was mentioned earlier, and they can't provide high-level services. One of the agencies that is definitely suffering because of this, excuse me, would be the one I work in, which is Baltimore City Foster Youth. So that is definitely a strain with the lack of staff. And the final thing is that the bill will reverse the chipping away of the state employee benefits, so that current employees and prospective candidates that want to work at the state are valued, and as mentioned before, do not feel the need to have to go to another state to get competitive wages and salaries. Thank you.
Good afternoon. My name is Marilyn Miller. I am the advisory board president for the Maryland Classified Employees Association, Local 1935. I was a state employee for 27 years, and I have been retired for the past 7 years. I am here to state what I have witnessed in my tenure as a state employee. The supervisors are caught between a rock and a hard place in their positions. They are the first in the chain of command, put in the position of bringing out the best of the employees they supervise and carrying out the mandates that upper management places on them. Some of these mandates are unrealistic, but due to the fact they have no collective bargaining rights, They have no recourse to have a say in their workplace issues or the mandates placed on them. The employees they supervise do have collective bargaining, which entitles them to bargaining for better pay and working conditions, thus leaving the supervisors in some cases with salaries less than the employees they supervise. This definitely causes a huge morale problem, one I am sure the state does not want. In closing, that is why I support collective bargaining for supervisors. Thank you.
Christopher Cano, political coordinator for SEIU Local 500. I would just say that our position is clear. We believe every worker deserves the right to collective bargaining. I can tell you my own experience as a union organizer over the past 6 years. I have seen time and time again to where bargaining units' powers are diluted by purposely trying to reclassify folks as managers and supervisors. And so this would put it into that and would ensure that every worker in the state has that right to collectively bargain. And we ask for your favorable vote.
Good afternoon, Madam Chair, Madam Vice Chair, and the committee. Thank you very much for the opportunity. I'm Donna Edwards. I'm president of the Maryland State and DC AFL-CIO. I think that the employees have done an excellent job of explaining this bill and laying out why it is necessary. We will be far from the first state to do this. Many states have done it, as you heard that line, and it is time that we open up just to enable, if they do want to continue to build their union and join unions to get and collectively bargain together, that they have the freedom and that right. We strongly support this bill, and I ask you for a favorable report. And I also say, anytime you'd like to form a union, let us know.
Thank you. And I see no questions for this panel, so thank you very much for your testimony. Have a good afternoon. We have two additional witnesses, Sherry Rojas and Carolyn Skolnick. Signed up in opposition to the bill. Good afternoon again.
Good afternoon, Chair Griffith, Vice Chair Klaus Meyer, and members of the committee. Thank you for the opportunity to offer testimony on Senate Bill 298. Sherry Rojas, I'm the Director of Labor for the USM. You have our written testimony, so I'll just make some comments. Senate Bill 298 would have a negative impact on the USM and its institutions and the state. The bill goes against the longstanding precedent and creates an inherent conflict of interest. State law currently excludes supervisory, managerial, and confidential employees from collective bargaining. These exclusions have been in place for over 20 years and were established by design. These are consistent with the exclusions under the National Labor Relations Act, which is the federal collective bargaining law applicable nationally to both federal employees and employees in the private sector, and the law to which our boards look for guidance on labor matters. By contrast, each state or local jurisdiction must enact its own legislation to provide public sector collective bargaining rights. An examination of the law in each jurisdiction is required to really identify to whom collective bargaining rights extend. Almost no state law completely and unequivocally extends collective bargaining rights to both supervisory and managerial employees. And some define manager in such a way that supervisors, as we've defined them in the USM, would still be excluded. Howard County, for example, excludes confidential and management employees. The law does not specifically exclude a supervisor by using that term, but supervisors are excluded by definition. Howard County law defines a management employee much like the USM defines a supervisor. The same is true with Anne Arundel County. The reasons these groups are excluded is that supervisors and managers function as an extension of management. They must be able to exercise independent judgment, something that they may not be able to do if facing pressure from their peers or an exclusive representative if a part of a bargaining unit. Extending these rights to both supervisors and managers would put Maryland in the minority and would improperly hinder the effective and efficient operations of the institutions. For these reasons, we would respectfully request an unfavorable report on this bill. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Thank you for the opportunity to offer testimony on Senate Bill 298. I'm Carolyn Skolnick from the University System of Maryland, Associate Vice Chancellor for Policy and Human Resources. At the outset, I want to remind you that I'm here only on behalf of the University System of Maryland. This bill has wider application, but the University System of Maryland has its own independent personnel system with its own policies and rules. This bill will likely have a substantial impact on the USM institution's operations. It would affect routine management decision-making and impair the university's ability to carry out their goals and mission through supervisory and management officials. Under existing law, each institution president has a legal right to determine the numbers, types, and grades of employees to hire, direct, supervise, and assign, and to take other actions that are necessary to carry out the university's mission. These statutory management rights are critical for any business, government entity, or university to operate. And the vehicle through which the university exercises these management rights is its supervisors and managers. Universities are inanimate entities. They can only act through their employees and managers, or supervisors and managers. And those employees' roles are specifically designed to act on behalf of the employer. They have an obligation to act on behalf of the employer. By giving supervisors and managers collective bargaining rights, the bill would create a conflict of interest. And I'll give you one example. For example, if a supervisor or manager in the finance department of a university is negotiating with the university over wages, they would have a personal incentive to advocate for additional wages, even though that might create a budgetary issue or problem that the finance department has an obligation to guard against. So in other situations, you would see a conflict of interest where the person's, who is participating in collective bargaining essentially wears two hats, that of representing the employer and that of representing the employee's interest. For these reasons, we respectfully urge an unfavorable report on this bill. Thank you very much.
Thank you. Senator Kramer.
Thank you, Madam Chair. Very quickly, Ms. Roxas, did I hear you say that professionals are not covered by the NLRA?
It's Ms. Rojas, thank you.
Oh, excuse me, Rojas.
That's okay. That's correct. The National Labor Relations Act specifically excludes supervisors from the act. And it also excludes professional employees and by policy confidential employees as well.
Are you familiar with 29 USC 152(12) that explicitly does cover professionals? Does that mean anything to you? Of the NRLA?
That specific provision that you cited to, I'm looking at 29 USC right now, just defines what a professional employee is.
And in fact, very often, what the NLRB does not do is mix professional and non-professional units, but it does in fact cover them. Is that not a fact?
Sure, that's true, but I think this
Okay.
bill is talking about expanding collective bargaining rights to supervisors and managers.
Correct.
Professional employees would be different than a manager.
Okay, and that's your interpretation.
No, the National Labor Relations Board has specifically also defined the term managerial employee.
Got it. And you're aware that under the bill, employees who are confidential are not covered by this. So perhaps when Ms. Skolnick is making reference to employees who are involved in negotiating salaries and other labor-specific issues, they're not covered under this bill. Is that correct? You're aware that this bill excludes confidential employees of a unit?
Yes, this bill
You're
is
aware of
written
that.
excludes confidential employees, although I think
Okay.
Ms. Skolnick was providing an example that is slightly different than what you're referencing.
Okay.
Thank you.
Thank you, Madam Chair.
Thank you. Senator Ellis.
Yeah, thank you, Madam Chair. And again, thank you, ladies, for your testimony. So one thing I just want your view on. So the sponsor panel, the discussion was common tactic is to promote someone who might be active in collective bargaining to the supervisory level, basically to kneecap them as far as take them away from that level of organizing. How would you answer that observation from those workers Either one of you, please.
I mean, all I can tell you is that absolutely would not be condoned by the University System of Maryland and its institutions. That's employees seek promotions typically because they want a job at the next level. They want the pay that comes along with that job. They want the responsibilities that come along with that job. It's not in our institution's interest to promote folks only to, quote, get them out of the union. I think that's a red herring in this with regard to the universities.
Yeah. So you think it doesn't happen?
I don't think it happens. Now, could someone find what example among our, 20,000 employees?
Yeah.
Possibly,
Yeah.
but I think that's quite a far-fetched concern.
So someone having a testimony again from first panel, sponsor panel, get promoted, given the title of supervisor, but have no supervisory duties like hiring or dismissal or disciplining and schedule. I mean, what would be the role to have that level and someone just sit in there at that level without any of the standard responsibilities of a supervisor?
So actually, under the University System of Maryland definitions of a managerial employee or a supervisory employee, that couldn't happen. A supervisor is specifically defined as an employee who has authority to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, or to adjust their grievances, or to effectively recommend such action. And it does not include an employee who is merely performing a routine or clerical function with regard to those.
Well, thank you for that.
Thank you. I see no further questions for this panel. Thank you very much for your testimony. We have one virtual witness signed up in support of the bill. So we'll now turn to Anthony Washington. Good afternoon.
Good afternoon, Madam Chair, Madam Vice Chair. My name is Anthony Washington Sr., and I'm a Field Supervisor 1 with the Division of Parole and Probation, proud AFSCME member, and proud state employee. If after listening to all the different testimonies today, I just decided to change what I had written. So I just ripped that up, just like we should do with not letting supervisors be a part of collective bargaining. I have pretty much three bullet points that I just came up with after listening today. Respect, voice, and pay inequity. We should be able to have the respect from our upper management, our, as you can say, our bosses, to be able to have collective bargaining, just as we once did prior to becoming a supervisor. It's a huge thing to be able to say that we are a part of something as a group, as a unit, to be able to speak up for each other, because some of us lost our voice. That's my second point. When I got promoted, as well as other supervisors across this state in every one of our agencies, we lost our voice when we got promoted, because being a part of the union gave us that voice to be able to speak up via our memorandum of understanding when we had health and safety concerns, when we had concerns with our work week, when we had concerns with just overall how our jobs were being done and how we were being told to do them. So there was sort of a lack of transparency, a lot of those areas, and that's why a lot of supervisors have left all across the state. 3, pay inequity. All across the state, we're having issues where new hires are coming in, possibly transferring from other agencies, and with less time than their supervisors, I would like to call the veterans who are leaving in droves, are starting to having to approve performance evaluations and non-competitive promotions for them to get raises. So they're literally signing off on their performance evaluations to get raises, and they're being left behind and being caught up with people who have less state service. I want to thank Senators Kramer and Ellis for sponsoring this bill, and I urge you to give a favorable vote for SB 298.
Thank you very much. I do not see any questions for you this afternoon, so thank you for your testimony and for being a part of this hearing. That will conclude the hearing on Senate Bill 298. We'll now turn to Senate Bill 247, which is state personnel, collective bargaining, faculty, part-time faculty, and graduate assistants. Senator Kramer.
Thank you again, Madam Chair. I think there is a panel that may be coming up. Are we organized in a panel or are we just gonna pile on in?
Okay. Do I come?
Come on up. Just make sure you introduce yourselves when it's your turn to speak so that we know who it is. Good afternoon again, Madam Chair, Madam Vice Chair, colleagues. In a continuing theme, Ben Kramer here to introduce Senate Bill 247. And colleagues, we have an outstanding university system here. The University of Maryland system is one of the finest in the nation. And I am very proud of our University of Maryland system. What I find disturbing and embarrassing is that we do not allow the hardworking women and men who are the ones who have made the university system so outstanding, so preeminent, so powerful. We don't afford them the opportunity to bargain collectively. The university system won't let them do that. Colleagues, Maryland is a Big Ten state. The vast majority of the Big Ten states allow the graduate assistants to be part of a bargaining unit, and they allow the faculty to be part of a bargaining unit. The overwhelming majority of Big Ten states do that. These universities in the Big Ten afford their hardworking faculty and undergrad students to participate in organized labor. And we should be giving those same rights to all of those people here in Maryland. And it's disgraceful that the university system is going to come up here and oppose what should be an absolute right for these people. The university is going to come up with myriad excuses why this is problematic. They'll represent that the folks at the system are happy, they're content, that our professors, our graduate students daily are living in green meadows with bluebirds singing and robins on their shoulders and butterflies all around. The fact of the matter is, the reason we are here is that historically this system has not treated its employees with the dignity and respect that they deserve. Maryland, I believe, and I may be corrected if I'm wrong, subsidizes our athletics department to a greater degree than any of the Big Ten universities. However, they shortchange the people who are the ones that have our students and our parents wanting their children to attend the University of Maryland. It's not the trustees that are up there enticing students to come to the University of Maryland. It's these folks, the ones who are on the front lines, working hard every day. And by the way, this is not just about wages. This is about working conditions. This is about a variety of daily activities that affect the way our pardon me, employees, faculty, and graduate assistants work. And by the way, these graduate assistants are worked like dogs. They are committed, They are devoted to their work. And yet, once again, the university system says, well, no, we've got other ways of handling disputes. Trust us, it's all good. And I've actually had them come in here and say, we know what's best for these students. They don't know what's best. How ludicrous. We would not be here right now. And by the way, petitions signed by hundreds of graduate students saying, we want a bargain. And the university system's going to come, oh, no, don't worry. We've got it all covered. They've got, what do they call their, meet and greets, something like that. Meet and greets, where the university claims, oh, we sit down and confer. That's it, meet and confer and greet. The university system will come in and say, oh, the students can sit down and air their complaints and we listen. And then what? Crickets. They may listen, they don't take action, and they don't have to take action, so they do not take action. Anything short of providing these hard-working folks who want the same opportunities that their peers in the overwhelming majority of Big Ten states have now. That's all they're asking for. The same dignity and respect that is afforded these other, and by the way, all these other universities didn't go bankrupt, and it didn't destroy their relationships with their faculty, with the graduate students. Those relationships were not destroyed. And in fact, I proffer to you that if they choose to do this, and by the way, this is enabling legislation. Nobody's going to force anyone to be a member of a bargaining unit, to be part of a union. This bill doesn't have that in it. It just affords them the opportunity. And in doing so, we're going to ensure that we bring in the best and the brightest to teach, and we're going to keep the best and the brightest to teach. And we will demonstrate to these people who are there with our children in their classrooms, we will demonstrate to them that we respect them. Even if the university system is not going to do this willingly, we as a General Assembly must guide them down the path and show them the way. And that's what this bill is about. And once again, I'm disappointed that my school is going to come to the table in opposition, but I will also say, listen closely to their words. They're disingenuous. And I would ask for a favorable report. Colleagues, this is long overdue. Let's ensure we maintain the finest university system in the country and give these hardworking folks just the opportunity to bargain collectively if they choose. Thank you, Madam Chair. Thank you, committee.
Madam Chairman, Madam Vice Chair, members of the Senate Finance Committee, I'm Karen Rosenblatt. I'm a professor of history on the College Park campus. I also sit on the National Council of the American Association of University Professors. The USM leaders are going to come before you today to testify that collective bargaining for graduate assistants is going to ruin the mentor-mentee relationship. I'm a representative of the mentors, and I was also a mentee on a campus that had collective bargaining. I can tell you, unionization does not ruin the relationship. If anything, it fortifies it because it clarifies rules and procedures. USM leaders will say that graduate assistants are students, that they're not workers. But we admit graduate students because they have the right skills and the right preparation. They bring a lot to our campus. The USM will tell you that if it spends on graduate stipends, it will not have enough money for good faculty salaries. But each year on my campus, the campus takes in about $132 million more than it spends. Back of the envelope, that's about $30K more for each graduate assistant. Now, the USM will tell you that if they spend more on contingent faculty and graduate assistants, they won't have enough money for equity hires or for retention offers to tenure track faculty. Administrators, how about cutting back on your own cadre of well-paid managers? Frankly, USM administrators are trying to drive a wedge between graduate assistants and faculty and between tenured faculty and part-time faculty. We won't stand for it, and we hope you won't either. We won't fall for the half-truths of the administration, and we hope you won't fall for those half-truths either. On I'm not going to say anything about shared governance. Members of the Senate Finance Committee, for decades, university administrators have been making decisions about how to run our campuses, and they've chosen to increase their own ranks and their own salaries, and I can provide evidence. Those are the choices they have made. Now let faculty and graduate assistants make our choices. I ask for a favorable report. Thank you.
Chairman Griffith, Senate committee members, my name's Mitch Tropin. I'm a communications professor at the University of Maryland Global Campus. I also serve as an officer on its Adjunct Faculty Association, a pseudo union that does nothing. I'm here to urge passage of 247, which would do something really basic. It would say that faculty and graduate students at University System Maryland institutions deserve what other state employees have and enjoy: the right to collective bargaining. Now, I'm very familiar with USM schools. I've taught at the University of Maryland, College Park. I've taught at Towson, taught at Morgan State, and also at the University of Baltimore. Now, each school is unique in its own way. However, they have something in common. The faculty and grad students there work hard every day to make sure that the students get the tools, skills, and knowledge that enable them so those students can leave those institutions able to earn a good middle-class life. And that's terrific. What would also be terrific if those same faculty and grad students could enjoy a middle-class life. They are badly underpaid, barely making a living wage, insult to injury. We don't even get the cost of living increases that every other state employee has been getting lately. Another good reason to give us collective bargaining, it gives us a voice. The great playwright Atul Fugard once said, "A man who cannot speak for himself is not a man, he is a ghost." Well, we may not be ghosts, but we're invisible. We have no way of really talking to the administration, bringing in issues that matter, and participating in true shared governance. And I know the difference. I teach at Montgomery College, which has had a union for 10 years, and the 3 unions there have done wonderful things with the administration, all to the betterment of the entire Montgomery College community. So I wish you to favorably report this bill. Thank you.
Thank you. It is an honor to be here. Greetings to all of you, and especially to Senator Kramer, who requested that I attend today, and to Senator Klausmeier, who met with me yesterday, and to the whole committee. My name is Holly Brewer. I'm the Burke Professor of American History at the University of Maryland. I'm also president of the UMD College Park chapter of the American Association of University Professors. And most importantly, for purposes of this meeting, I'm the chair of the Council of University System Faculty for the University System of Maryland, the main representative body of the faculty. I should not have to be here. This is the first time I've ever done something like this. It is not part of my regular job. I want to be in archives, writing books and articles. I want to be teaching my classes. I want to be mentoring my graduate students. I'm here, as are so many of my colleagues, because something is broken in shared governance. I'm engaged as fully as I can be in shared governance. I'm going to go tonight and have dinner with the Board of Regents. I give reports monthly to the President's Council and the Chancellor. But faculty have a very weak voice in the system. Why? Declining number of tenured faculty, so many decisions made without seeking formal approval. It's hard to identify and to solve basic problems. I have tenure, job security, and even an endowed chair. I'm not here for my personal interests. I'm here to speak about imbalance of power. So many people at the University of System Maryland, including faculty, have no job security at all. They have their positions at will. It is difficult for such employees to speak up about problems that need to be solved. That includes graduate students. I hear in both of my roles many complaints and concerns, and I have so few resources to solve them. I have no staff. We, the members of my council, the Council of University System Faculty, which represent all 12 institutions, are a bunch of faculty volunteers. How can we address systemic problems? It's not easy. So many decisions are made without our input. And I'm going to close I wanted to say, I hear from USM today that collective bargaining we shouldn't have it because it represents conflict of interest. What we have now is conflict of interest. What we need is some balance of power. And thank you. I hope you support this proposal.
Madam Chair, Madam Vice Chair, members of the Senate Finance Committee, my name is Yen Michael Archer. I am president of Fearless Student Employees, and like thousands of grad assistants that I speak for, I am frustrated. Across the USM, we must fend for ourselves in abusive workplaces that rob us of our dignity, sanity, and voice. On Tuesday, I testified before the House Appropriations Committee in favor of this bill. I explicitly shared the poor working conditions I experienced as a graduate research assistant. I explicitly shared how my attempts to navigate the paper-thin grievance process were met with bullying and retaliation from my advisor. I explicitly shared how escalating abuses impacted my mental health, nearly driving me to suicide. What followed my oral testimony were galling claims from some of the same USM administrators who are here today, including the claim that graduate assistants are students first, as if that justifies our poor treatment. Stephen Fetter stated the following: "My greatest concern is that collective bargaining would change the relationship from student mentor to employee supervisor, and that will negatively affect the educational experience." First, graduate students and faculty members are both represented in this bill. Secondly, in the years that I have known him, Stephen Fetter has never shown any concern for my educational experience. And indeed, after my painful testimony on Tuesday, he had no words of support or even sympathy. My mother taught me to believe people when they show you what they really are. Senators, we have been here 5 times in the last 5 years. These administrators show up year after year spending taxpayer money to spread outright lies, but they have never shown up for graduate assistants. Meanwhile, grad assistants show enormous courage, leadership, and solidarity, risking retaliation to commit hundreds of testimonials with their names and addresses to the public record. These administrators have access to every single page of our testimonies, but I'm almost certain they have never looked at them, because it is easier to tell you that they care about us than to actually care about us. Senators, you too have access to these testimonies. In them, you will find the names and addresses of your constituents. I implore you to do more than the administration has done with these testimonies. I implore you to care and compel the USM to care about us. And please pass a favorable recommendation for this bill. Thank you.
Okay, are there any questions? Senator Ellis?
Yeah, thank you, Madam Chair, and thank you, Senator Kramer and panelists for your passionate testimony, your commitment to the university. As a graduate of the University of Maryland, and as a father of 2 graduates of various institutions in the University of System Maryland, I know my commitment to make sure the university becomes greater and greater. And I'm just really concerned about your experiences and trying to work within the system to learn, to do your jobs, and to help the current generation to become leaders. And that's really admired. And going forward, I think we all have to work to make sure we improve on what we do. Because if we don't, then, we become very much a relic of the past and history. So I'm just kind of curious as to, being able to go forward and work with the leadership at all these institutions, looking back at great companies that have been around a long time, like Ford Motor Company, who, they went through a period of almost extinction, right? And they decided to bring the workers into the management and decision-making. And so pretty much, is it your goal to basically run the institution or just to make it better? As far as organizing and getting more say in how things happen.
So the university runs on shared governance that's set out in policies of the USM and of the institutions. According to the American Association of University Professors, which is the main national voice on these issues, faculty, for example, should have primary responsibility for matters of curriculum, research, matters of student life that affect curriculum, and they should also have a say in questions around budgeting, long-term planning, and so on. Our university put together a strategic planning commission that the average salary of the members of that commission was over $300,000. So that tells you about how they care about bringing the university community as a whole into this discussion. Around the system, I hear that shared governance is broken. Faculty spend months sometimes crafting new curriculum, and then there comes around an administrator and just tosses it aside, no explanations given. That is in contravention of the principles that have really guided our universities and made them what they are. So this system is broken. Now, the university will say that collective bargaining will break shared governance, but they can give no examples of that because there are many universities, including Montgomery College, that have collective bargaining, and collective bargaining can be a voice for improving shared governance. And there is, in fact, good research that unionized campuses are more efficient and they're more effective.
So you're saying shared governance is a concept, but it's not being practiced. Is that what you're saying?
Not as it should be. Can I just add a little bit to that?
Sure.
Because of our time element, we have about 50 or 60 more people, not on your bill.
2 sentences.
Very quickly, because we
So
really.
80% of
won't
the
be here till
faculty now at the
midnight.
University System of Maryland, or almost 80%, are not tenure or tenure track and hold their positions at will. And it's hard to speak up about problems and solve them when you
Did you
have
say
no job.
80%?
Almost 80%.
80.
Almost 80%, 78% exactly. Do not have tenure, or serve at will, often without any contracts of any length. And it's hard to speak up. They're in very insecure. So to solve problems, people need to be able to speak up. And if they can't, it's a problem.
Thank you, Madam Chair.
Can I give a good example?
No, I
I'll make it
hate
very
to say this, but we have about, this whole bill is about an hour long without questions. And so if you tell somebody back in the audience, because we have a lot more people to come up, tell them to say what you were going to say. It's fine.
Okay.
So, so that ends this panel. So the next panel can, I'm sorry, Senator Hershey.
Chair, and I won't say what I want to say, but I've never heard so many people complain about working hard that I have today. But ma'am, you mentioned one thing about Maryland takes in, or one of the system takes in $132 million more than they spend.
The College Park campus on average, but
On
every
average.
year pretty much they take in more than they spend.
That's
yes.
interesting because I know we give them a lot of money in the state budget. We should probably find a way to reduce that amount.
I don't think so. I think they should spend it rather than a 4% decrease in wages since 2010 for faculty, which is what has happened. They should be improving the wages. College Park has the second lowest
losing faculty?
wages. Yes, of course.
Yes.
And that's the
A lot
one
of
thing
them.
with the
We've lost a lot of
administrators
faculty.
will agree with us on.
And they don't believe, is that a problem for them that they feel that they have to increase wages? Are they able to find enough people that, I mean, I'm not sure how working at a university is horrible working conditions, the way that you guys have all mentioned. it almost sounds like you work in coal mines or something by how unfair and safe this
A
is.
professor at Frostburg on a temporary contract makes $2,100 per course. That turns out to $14 an hour.
They're working as a professor.
As a
in
professor
classroom
teaching a
environment.
course,
I mean,
teaching a course.
Okay.
Yes.
And again, that's okay, but they're not going to do that job forever, are they?
Well,
I mean, are they?
you have
Why
some.
not?
What's that?
Why not?
I mean,
A lot
I
of
don't know. Are
people
there other,
devote themselves to teaching.
are there other jobs that you can do besides being somebody that works for $14?
Many people leave.
What's that?
Many people leave, including many of the best people
And then they
working.
get, and then they are backfilled with other people that do the jobs, right?
Sometimes people without even many credentials.
Oh, that's. Anyways, it's interesting to hear how much additional money comes in, and I think that there's some things that many of us would like to do with that money rather than just send it to the university. So I appreciate at least those comments. Thank you, Madam Chair.
Okay, okay, next, the next panel, and
Thank
you
you.
tell whoever you want to bring it to our attention. It's here. Okay, we have one more. And state your name so we can brush off the list here. You start here and we'll just go down the line.
Okay, thank you. Good afternoon, Chair Griffith, Vice Chair Klausmeyer, and members of the Senate's Finance Committee. My name is Joshua Davis. I'm an associate professor of history at the University of Baltimore, where I've taught for 8 years. I'm also a proud member of the American Association of University Professors. I'm testifying today to respectfully ask that this committee issue a favorable report to Senate Bill 247. In his recent State of the Union address, President Biden stressed our responsibility to revive the dignity of work in our country by protecting workers' rights to unionize. This is what this bill would do for USM faculty if passed. For those opposing this bill, I ask, why are you not willing to provide our faculty and grad assistants the dignity and respect that we deserve? The same rights enjoyed by virtually all state workers, including community college faculty and non-teaching staff at USM institutions. At the University of Baltimore, I encourage our students to pursue jobs in K-12 teaching. One reason I do this is because our public school educators in Maryland have collective bargaining rights, as opposed to neighboring states like West Virginia, where teachers are prohibited from doing that. I'm happy to report that we've had at least 4 history majors become teachers in Baltimore City and Baltimore County public schools in the last 5 years. Sadly, however, college faculty in Maryland don't have collective bargaining rights. So honestly, I'm not as eager to encourage our grads to pursue faculty teaching jobs in our university system. Prohibiting faculty and grad assistants from collective bargaining is both unfair and short-sighted. Our state is losing out on talented graduate students and university faculty to neighboring states where the systems allow collective bargaining, including Pennsylvania, Delaware, and Washington, D.C. Faculty and grad students want and are demanding the right of collective bargaining. Consider the fact that American Association of University Professor chapters at Bowie, Towson, Salisbury, College Park, and the University of Baltimore have all endorsed this bill, in addition to our good graduate student colleagues at the University of Maryland, College Park. In closing, please offer a positive report on this bill. Thank you for your time and consideration.
Good evening, Madam Vice Chair and members of the Finance Committee. My name is Zane Poffenberger and I represent the UMBC Graduate Student Association, and I'm here to ask for a favorable report on Senate Bill 247. UMBC is a Tier 1 research university whose graduate assistants provide vital contributions to the research and teaching, which highlight the quality of higher education in Maryland. UMBC is a minority serving institution as more than 50% of our students are people of color. UMBC has the second largest USM graduate workforce with over 750 GAs in research, teaching, and administration. According to a GA survey, more than half of our GAs are women and almost 40% are international students. This past fall, some were not paid for months with no streamlined or timely way to report these issues. We need the option to unionize to ensure that we can negotiate and enforce formal and binding contract agreements that include adequate pay, benefits, and workplace conditions. 64% of our survey respondents said that their stipend does not cover their living expenses. 2/3 of respondents are full-time master's students who receive the pay minimum of $1,733 per month, far below a livable wage. More than 15% of respondents also reported a responsibility for dependents, which is even more untenable on this salary, especially as we do not get subsidized dependent health insurance. The current process of meet and confer is meant to consist of formal discussions every semester between grad school leadership and the GA Advisory Committee. At UMBC, no such official meetings took place for 2 years until fall of 2022, a prime example of how shared governance is not working. The mandatory report each university must make to USM each semester provides no way for graduate students to directly articulate lingering concerns. We need the option of collective bargaining, and I thank you for your time.
Hello, my name is Jaden Mikulinski, and I'm a higher education graduate student at the University of Maryland, College Park. The nature of the graduate assistant financial package has required me to take on overload positions alongside full-time study and pre-existing full appointment assistantship. I earned my positions through tenacity, a rigorous and diversified CV, and my passion. Assistantships are not just simply handed out to graduate students. They're earned under the principles of merit and recruitment funnels, as graduate talent is thoroughly vetted first in applications, then in interviews, and even programmatic preview processes. I've co-managed the process of connecting students to over 55 assistantships in my program and can attest to the meticulous planning and deliberation that goes behind our assistantship hiring processes. Opposition to this bill neglects to acknowledge the inefficacy of shared governance, a process through which real, enduring change is combated by the system truly being ceremonial in nature. Nominal influence is granted to faculty and students, as our concerns are often lost in the noise. As a former student body president, I'm all too familiar with the failures of the current structure of shared governance. This sentiment has prevailed in my studies at Maryland and involvement in student government here as well. It is simply the illusion of support and democracy that is offered in our shared governance. A mere checking of the box for advisory relationships and truly putting people in positions to not be heard. There's also a harmful narrative that collective bargaining will serve as a distraction to the university's communities and missions. It is instead a basic liberty and protection for faculty and students. Please protect your student constituents and faculty constituents, as well as the next generation of public servants with a favorable report on Senate Bill 247. I thank you for your consideration.
Greetings to those gathered. My name is Jared Ball, and I'm currently a tenured full professor at Morgan State University, where I have been for almost 18 years. Before that, I spent roughly 7 years at both Frostburg State and College Park as both faculty, graduate student, and undergrad, giving me 25 years of experience within the Maryland higher education system, but not within Maryland higher education, but not necessarily within the University of Maryland system. And it is this last point to which I'd like to draw some attention, given that it has not been made clear previously here or in my written submission. Specifically, collective bargaining protections must be afforded to those of us working within already hostile conditions and who have actually less recourse to address those issues given the insular hierarchy of institutions like Morgan State. Without the ability to collectively bargain, individual faculty are left on their own, mostly to languish, quit, or perhaps to bring about their own independent lawsuit, which Morgan has seen plenty of and yet can easily withstand without corrective measures taken. In addition to the many grievances described by my colleagues here and in my own submitted written testimony is the fact that these copious and well-documented abuses are protected by an existing state university structure and made worse by the fact that we have nowhere else within the university system to go with our concerns. I spent personally the better part of 7 years trying to address every abuse, from administrative plagiarism of my work to arbitrary hiring, firing, pay increases, and an endless list of microaggressions designed to destroy spirit and collegiality, only to realize that Morgan State has, under the guise of historically Black autonomy and false claims to already shaky concepts of shared governance, continued with impunity to scuttle academic freedom, the value of earned rank and seniority, and even due process. Shared governance suggests a balance of power, and yet there is none among our faculty whose voice can only be heard when parroting messaging that comes from the president's office via our university councils. This is not sharing, nor is it at least good governance. I am therefore in favor of SB 247 and support for this long-held human right to collectively bargain. Thank you.
Esteemed senators, my name is Dr. Tina Kelleher. I have served for 22 years at Towson University in a range of roles, and I'm currently a 4-4 load lecturer on full-time non-tenure track faculty. 11 years ago, in March 2012, I submitted testimony for legislation similar to SB 247, which halted in committee and resulted in a disappointing meet and confer policy. I coincidentally received a non-renewal for no reason amid this meet and deferring while serving as the first lecturer representative to our Senate. So when the pandemic hit, TU lecturers still lacked sufficient healthcare and retirement assistance. In 2021, HR therefore reclassified us into sub-tiers for payroll deduction access to benefits. Contingent, opting out, regular contingent, opting in, or temporary contingent, still no access. After a decade of meet and suffer, most lecturers finally could elect benefits available to all other regular status employees. But in reality, nothing changed. We are all still contingent. These longstanding problems became evident last May when a new lecturer promotion policy surfaced on the Academic Senate without notifying our rank or our tenure track colleagues. Only belatedly informed chairs could contact those eligible. Despite the new senior lecturer ranks of Lecturer 2 and 3, those already qualified for the highest raise level inexplicably could not apply. The promotion ladder was designed to delay progress, not to support it meaningfully. The USM frames collective bargaining through a glass darkly, but the glass in this case is neither half full nor half empty. It's cracked and warping. I urge ending these meat and obscure practices. Maryland academic professionals have already waited too long and deserve better, as do the thousands of students that they teach, support, and advise. I ask for a favorable report.
Good evening or good afternoon to the chair, Madam Vice Chair, and members of the committee. My name is Beth Gay, and I'm a librarian at the University of Maryland, where I've worked for 26 years. I call on this committee to issue a favorable report to SB 247. It is clear that the right of collective bargaining should be extended to all of higher education in Maryland. UMD librarians are classified as non-tenured continuing contract faculty, which provides an opportunity to gain permanent status, which is similar to tenure. One would think that permanent status, which requires a rigorous review at a great expense of time and money, would help the libraries retain its best performers. In 2018, 9 librarians were promoted to ranks with permanent status. Between 2019 and 2022, 5 of the 9 left for positions at other academic institutions or the Library of Congress. 4 were for positions in the DMV. 3 of the 5 were parents of young children. Similar occurrences of promotions followed by departures have continued. When librarians leave, their responsibilities are often assigned to those who remain, increasing their workloads. Low salaries and excessive workloads are apparent contributors to the library's retention problem. The state of Maryland's investments in University of Maryland library faculty ultimately reward institutions outside of the university and outside of the state. I believe that enacting SB 247 will lead to fairer salaries and fairer workloads that will help the libraries retain outstanding librarians who apply their professional, scholarly, and disciplinary knowledge in support of the educational mission of the university. Thank you.
Thank you. Are there any questions? Seeing none. Okay. And I think we just have a few more folks to come up. We have Christopher Cano and Adam Schneider. And Donna Edwards. Is Donna here? Okay.
It's been a long day, long hearing. I'll be brief. Christopher Cano, SAIU Local 500. We asked for a favorable vote for this bill. Just very briefly, you know, my time in the United States Air Force, the one value that we always instilled in each other was no one gets left behind. Our educators in the university system are the only ones left behind without collective bargaining rights. Do the right thing, pass this bill.
Christopher. Adam Schneider, is not here. Okay, now we have 4 unfavorables. Allison. Ren, Sid Kaza, Jennifer King Rice, and Stephen Fetter.
Thank you, Chair Griffiths, Vice Chair Klausmeier, and Senators. I'm Dr. Allison Rinn, the Senior Vice Chancellor for Academic and Student Affairs for the University System of Maryland. I'm under no illusion, nor will I claim that all workplaces are perfect, but shared governance has been an integral part of higher education for 100 years, and it is a critical way of ensuring that faculty have a voice in institutional governance. This definition was described earlier on an earlier panel, so I won't repeat it. But I will say this process is not just a theoretical concept. The USM produces an annual report on shared governance that emphasizes the importance of faculty involvement in personnel decisions, selection of administrators, preparation of the budget, and determination of educational policies. Shared governance within the USM is dynamic and nimble. Additionally, each year faculty, via their Council on University System Faculty, conducts a survey of campus senate chairs on the state of shared governance on their campuses. In the most recent survey, faculty described shared governance on their campus as moving towards open collaboration and communication, although work still needs to be done. Most Senate chairs describe shared governance as an obligation to consult. Shared governance begins with the belief that the faculty and administration feel that they are partners in a common project. This is what the shared and shared governance means. This doesn't imply that there is agreement each time, but there is collegiality and respect. Thank you for your time today. The USM respectfully urges an unfavorable report on Senate Bill 247.
So thank you, Madam Chair, Vice Chair, Committee. I'm Jennifer King Rice. I'm Senior Vice President and Provost at the University of Maryland College Park, and for 30 years have been a professor there, and I'm very proud of my tenure on the faculty there. Given time constraints, I'm going to comment just on the graduate assistant part of this bill, and I'd like to start by just recognizing that graduate assistants are students first and foremost. Their stipends are not salaries. Their stipends are financial support to offset the cost of earning their degree. And that's why their stipends, for instance, are not subject to payroll taxes. When we hire faculty and staff, we conduct a search to identify the best qualified candidate for the job. But graduate assistants are awarded entirely on the applicant's promise as a student. It's a temporary state, and they're here to learn. And it's our goal to provide the best educational experience possible, including critical research and teaching experience and invaluable faculty mentorship that's afforded by assistantships. Our assistantships have to be competitive with our peer institutions if we want to attract the top students. And we do attract the top students. We are very proud of our graduate students. They're provided full information on the terms of their assistantships that include the stipend, include tuition remission, and access to the same healthcare benefits available to our full-time faculty and staff. University leaders like myself meet regularly with our graduate students through various advisory groups and councils to hear their concerns and discuss their solutions. And yes, we listen, but we also take action. My written testimony notes the progress that we've made without collective bargaining that includes a 58% increase in minimum stipends over the past 5 years and 32% increase alone in the last year. We have a grievance process in place to ensure that our students have voice to raise concerns, and we take that very seriously with punitive responses for faculty if needed. Now, as a faculty member myself, I've supported and mentored GAs for the past 3 decades, and my greatest concern here is that collective bargaining can impede the process that we're making. And I do want to point out that only 5 of the 13 Big Ten institutions have collective bargaining, and only 1 of them allows research assistants to bargain. The rest, the other 4, it's teaching only.
Thank you.
Thank
All
you.
right.
I'm Steve Fetter, Dean of the Graduate School at College Park, and since Mr. Archer called me out, personally as being uncaring, I'd like to say that I did speak with an administrator who was involved and believes that he was caring and supportive, and he was frankly shocked at the testimony by Mr. Archer. And because he raised the working time in his House testimony, I'd like to clarify a point that I think illustrates the difference between GAs and employees. The limit of 20 hours per week applies only to work that's unrelated to a student's own research or degree requirements. Many GAs have research assistantships that allow them to focus largely or entirely on research that's required for their degree. The PhD requires original research and scholarship. That is a very high standard, and I don't know of anyone who earned a PhD for 20 hours of research a week. The amount of work that is required for a PhD is an academic matter entirely, to be determined by faculty, not an employment matter subject to union negotiation. And the inclusion of research assistants in the bill is problematic because it can be impossible to distinguish between the GA duties and research that's required for degree. And that's why most peer institutions with collective bargaining explicitly exclude research assistants. As Provost Rice mentioned, only 1 of the 15 Big Ten institutions have collective bargaining for research assistants. And that's one reason why we seek an unfavorable report on SB 247. Thank you.
Good afternoon. Thank you for allowing me to testify here. I'm Sid Kaza. I'm the Associate Provost for Research and the Dean of Graduate Studies at Towson University. I'm also a professor in Computer Information Sciences. I have a written testimony in, so I'm going to limit my remarks as well as unfavorable to this bill. TU is currently expanding our research and graduate student capacity. However, majority of our students are master's students, and they will remain so. The master's students are with us for about 2 years. And in that short amount of time, we develop professional mentorship relationships with these master's students. And we believe that collective bargaining will interfere, as my colleagues have pointed out as well, with that relationship. Graduate students to us are very important members of our university, and they're included as members of college and university level committees, including committees that address the budget, the curriculum, and student appeals, including grievance committees. In fact, our graduate student association president, Marcus, is a member of the academic senate at the university, ex officio. He has in fact been appointed to the presidential search committee. We are searching for a new president this year, as you might know, which goes to pointing out how important the Graduate Student Association is for us. But in addition to shared governance, participating in shared governance, we do utilize the meet and confer process and ensure their voice is heard by university leadership. Our meet and confers that happen every semester are attended by the provost, the vice president for administration and finance, human resources, and the dean of graduate studies, myself and my associate dean. Between the stipend level increases, which came out of the meet and confer process, we have increased our investment in GAs, 1.1 million since spring 2018. Overall, I'd like to summarize, we have a very strong collaborative relationship with our graduate students assistants, and we urge an unfavorable report on this bill.
Thank you. And I see we have Senator Ellis.
Thank you, Madam Chair, and thank you for your testimony. I know you're in a tough position, and I know Dr. Rice for a few years, and I respect the good work you are doing, have done. I'm just concerned when you have so many members of the university system comes up and talk about the problems. And then we have the administrators come and say, oh, you know, everything is working fine. I mean, if you put yourself in our position here in this, right? It's like, how do you address the dissatisfaction with so many important members of the university community? And how do we listen to make as many folks as possible happy in their chosen pursuits?
That is a great question. And I really, Senator, I really appreciate that question because you're hearing things that are concerning. I'm hearing things that are concerning here. We need to take that very seriously. I will say that, we have 10,000 graduate students on our campus. So we have a lot of graduate students. Some of them are having a difficult time. There are some things that, so I'm not trying to suggest that things are perfect. In fact, things need some work, and I've been in this position for 1.5 years. We're taking things on one at a time. I've started with graduate students because I felt like that's where the need was greatest, particularly in terms of their stipends. And so we are addressing the issues, and we're doing it in a way that's hopefully collaborative. I listen and I act. So we need to continue to hear the issues. I think that some of these, we have a grievance process and it's not used nearly enough. I think that would be one of my recommendations, particularly for some of these issues around working conditions. I've heard the word abusive. What are those circumstances? And please bring them forward so that we can address them.
Thank you.
Okay. Senator Kramer?
Thank you, Madam Chair. In quick response to your comment there, Ms. Rice, you were talking about you have these grievance processes and you want these individuals who have concerns to come before you. Evidently, nothing is being done by virtue of the fact, as my colleague was just raising the point, we haven't, trust me, I asked to please stop any further by virtue of my respect for how long the bill hearing would go. Let's cut off the testimony, or we'd have had hundreds more in this room today with their grievances. So clearly there is a disconnect between you folks and all of those employees who we're hearing from saying, give us the opportunity to bargain. What is it that you are worried about if they have the right to collectively bargain? Why are you so afraid of giving them that opportunity?
So I'm not afraid. I'm not afraid. My job is to look out for the best interest of our university community. That is my job. In fact, I'm a faculty member. I look forward to going back to being a faculty member. And in the interim, my job as provost is to be the steward of our university community and our academic enterprise. And I really, as I have studied this, our graduate students asked me 1 year ago, will you support us in this collective bargaining? And I said, I don't know. I'm new at this job. I need to understand this. I need to learn about it. Give me a little bit of time to understand it.
We've had a year.
And I understand it, and now I'm opposing it. So yes, I have learned about it. And my feeling is that we do have a strong and important tradition of shared governance. It's very hard for people outside of academia to appreciate what that means, because it's a very unusual arrangement where faculty and students and staff at our university, many universities it's just faculty, but in ours, it's all of them sit on our university senate and make decisions about policy. They develop policies, they make decisions about policies. They make policy decisions about how merit pay will be allocated across themselves. So there is a lot of autonomy, a lot of agency among
What is the enforcement mechanism for those decisions, ma'am?
the enforcement mechanism.
In other words, if they are making decisions about their pay scale, their benefits, what their work environment will be, what happens if you look at them and say, I'm being a steward, and as part of my stewardship, no thanks. I'm not going to change that. What are their options once the decision is made?
So as provost, I don't have the authority to do that.
Okay, but you're stewarding. I heard you say that you're there to steward. And what
I am to bring people together, to engage in conversation, to listen, to help make changes where I can, to allocate resources in ways that support our people. Our strategic plan, which by the way, had 5 committees.
That, but you're not answering my question. All I'm trying to get a handle on is, what are the alternatives for all of these faculty and grad students who came in here today and said, you're not listening. The system is not listening. Give us this opportunity.
So I would.
So, and you're representing, oh, they've got all kinds of alternatives. Clearly, that is not working, ma'am. That's my point. But I will terminate it there because I have a question for Ms. Nguyen. Ms. Nguyen, you focused very much about this issue of shared governance. Is it my understanding that you were a professor at Cal State Long Beach?
You've Googled me and it's Dr. Rin. Thank you. Yes, sir, Senator. I was
Were
for
you-
14 years.
And were you a professor at Cal State Fullerton?
I was actually the director of undergraduate studies in general education with retreat rights to the faculty.
And did those schools have shared grievance?
Shared governance, do you mean?
Excuse me, shared governance.
They had incredibly active shared governance.
And so you're saying the reason University Maryland system doesn't need collective bargaining is because of shared governance. But ma'am, I will point out to you that as I understand it, Cal State Long Beach and Cal State Fullerton both have unionized faculty.
Indeed, they do.
So evidently, contrary to your statement that shared governance can replace collective bargaining, it appears as though they work just fine together, as you indicated. So why wouldn't we do that here at the University
Senator,
of
today I
Maryland
was talking
system?
about the University of System of Maryland. I was not talking about the California State University system and how
Okay,
shared governance and bargaining units work. That's a different conversation.
got it. Perfect. Thank you for that, ma'am. Thank you, Madam Chair.
Okay, thank you. All right, I see no other questions, but we have two virtuals, Joan Bevel Aqua. And Alberto Baca. Unmute.
Can you hear me?
Yeah.
Hello. Good afternoon, Chairman Griffith and Senate Finance Committee. As a university adjunct professor for over 20 years, I'd like to introduce myself and my colleagues. For those of you who are unaware, we are the only ones left. We are the only state employees who cannot collectively bargain with our administration for better working conditions, such as job security and compensation. We want to sit down at the bargaining table and speak for ourselves and for our students. With the hard work of over 10 years, community college faculty finally won the right to collectively bargain because of the courage and will of those on this committee. How can the professors of Maryland universities be left behind? I've been an officer of the Adjunct Faculty Association at the University of Maryland Global Campus for over 6 years, where we meet and confer with the administration. Firsthand, I can be honest, this is not shared governance. It is ask with no right to negotiate. We are not asking for handouts or special treatment. This legislation simply gives the faculty and grad students the right to decide for themselves if they want to form a union, not mandate it. We are the same professionals, whether at our community colleges or public universities. I, like thousands of other adjunct professors, teach both at our universities and at our community colleges. But as of now, we have disparate faculty experiences. As a community college professor, I have the right to collectively bargain. But as a University of Maryland Global Campus professor, I do not have that right. Where is the fairness in this? The time for change is now. As our Governor Wes Moore has said, no one gets left behind. I strongly urge you to vote yes on SB 0247. Thank you very much.
And we'll move on to Alberto Baca. And thank
Good
you very
evening.
much for your testimony.
Thank you.
Good evening. Pardon me for sitting in the car, but I've had some family urgent matters today, and this is just the best I can do. But this is how important this is. Again, I'm AJ Baca. I'm the president of the Montgomery College chapter for full-time faculty, the only organized group in the state of Maryland for the last 40 years. So this is really, really important. And we're here because we value this and we want to share the fact that we play an integral role at our institution, and we want to talk to you a little bit about that. We know this directly impacts students and academics at our institution, and we're proud of the decision-making role we play that complements shared governance that we have at our institution. I'd also like to share that I am an alum of Maryland, and frankly, it doesn't matter to me what the other Big Ten schools are doing. I'd like for our institution to be fearless and lead the pack, lead the way, and how things should go. What you won't see on TV from us is we don't negotiate in the media. We don't strike. We don't publicize internal things that are going on except in verified extreme circumstances, but we do collaborate constructively, regularly, and effectively with management. We engage and inform and mobilize our constituents, but we also hold them to account. We negotiate compensation and benefits, of course, but we also discuss working conditions and negotiate things like office hours and policy related to online learning, amongst many other things that you would not get done in shared governance. We protect the contract from our standpoint and from the out of management. We serve as a check and balance, and those things are really, really important. Again, things that cannot happen in shared governance. We navigate the grievance process, and we serve as an informal mediator, and we find common ground solutions, again, collaboratively with management. And we try to avoid grievances whenever possible. I'll just close with this. Faculty don't want the final say, they just want to have a say. And they want to have leverage with a contract in hand so that they can affect real change and ensure consistency and equity across the institution. So on behalf of the faculty at Montgomery College, who have had shared governance and a union for 40 some years and making it work quite well, we urge you to pass this, and we thank you for your time and consideration.
Are there any questions? Hearing none, thank you very, very much, and you have a nice evening.
Thank
And
you,
we
ma'am.
couldn't even tell you were in the car, so.
Good to hear. Thank you.
Okay, that concludes the hearing on Senate Bill 247. We're going to turn to now Senate Bill 259. And so Senate Bill 259 is business regulation flavored tobacco products. What I want to say to all of our witnesses in advance, we have 52 witnesses signed up on this bill. And so we are going to ask that you watch the timer. We are going to give 1 minute for testimony, whether you are speaking in support of the bill or in opposition to the bill, whether you are in person or virtual. We'll have 1 minute testimony on this bill. We encourage you to listen to the testimony of those who have come before you that share your position so that you're not repeating. You're using your 1 minute to give your unique testimony on the bill. I'm going to repeat that in just a second as people are coming in. I want to make sure they hear this so that there's no fruit thrown up at the front of the room when the timer goes off. All right. Because I know it's probably loud out in the hallway. So we are going to begin the hearing on Senate Bill 259. 52 witnesses signed up. If you are signed up as a witness, you will have 1 minute to testify. Whether you're a proponent or opponent to the bill, you'll see a clock on the screen. Ask you to respect the time. I suspect even with 1 minute, we're here for another hour, hour and a half. So I ask you all to just bear with us, keep your remarks concise. We are here to hear you, but we did have to make some adjustments. It's been a very long day. So with that, we will turn it over to Senator Lamb to present the bill. Are there any questions from the committee? Okay, very good. Senator Lamb, you have the floor.
All right, thank you, Madam Chair. Appreciate that. And we have asked our stakeholders to also be brief as well. Understand that we're testing everyone's bladder and biology tonight. So here to introduce Senate Bill 259. Good evening, Madam Chair, members of the committee. For the record, Clarence Lamb, Senator in District 12. As many folks may know, the Family Smoking Prevention and Tobacco Control Act of 2009 banned flavored cigarettes, but exempted menthol cigarettes and did not address flavoring in any other tobacco products. In the years following the original flavoring ban that was done on the federal level, the number of teens that stopped smoking dropped dramatically, and the issue of tobacco use in youth seemed to have been addressed at the time. Since then, however, there are now more than 15,000 e-liquid flavors being sold and targeting children. Additionally, the tobacco industry has historically promoted menthol flavorings to Black communities. Menthol flavoring has been shown to make it harder to quit smoking and appears to be part of why cigarette smoking rates have not decreased as fast for Black Americans as compared to white Americans. 97% of youth tobacco users have reported that they began smoking because of flavored products. With labels like cotton candy, blue raspberry, and sour apple, I believe this clearly indicates that the industry is catering to a younger audience. The e-cigarette brand Juul, for example, has even put ads out on the Cartoon Network that appear similar to the Kool cigarette ads, the KOOL cigarette ads in the 1990s and early 2000s that were catering to teens, for those who may recall from then. In 2020, the federal FDA did issue guidance prohibiting e-cigarettes with flavored cartridges that appeal to kids to be sold, including fruit and mint. But this exempted open tank systems and disposable cigarettes. So there were huge loopholes in the federal FDA guidance that was issued 3 years ago because it exempted open tank systems and disposable e-cigarettes. Surveillance and other studies have shown that flavored tobacco users among youths quickly migrated to these exempted type products. Disposable flavored e-cigarettes, known as ELF bars, have become particularly popular amongst children. In 2020, the FDA rule also continued to exempt menthol cigarettes, another huge loophole that was left out in the FDA's guidance, which disproportionately affects the health of Black Americans. For decades, tobacco companies have targeted their menthol advertising and outreach into Black communities, including handing out free menthol cigarettes in Black neighborhoods. From 2004 to 2008, 30% of all persons who smoked menthol cigarettes were Black, while 3% who smoked non-menthol cigarettes were Black. Additionally, a survey among Black smokers found that 93% of them used menthol cigarettes when they first tried smoking. Prohibiting the sale of menthol cigarettes under this legislation could have prevented almost all new smokers within the Black communities in Maryland. Throughout the years of considering this issue, this committee has heard that it will reduce state tax revenue, that by reducing the number of smokers, you're reducing state tax revenue. It was estimated that there could be a reduction in state revenue, but smoking related healthcare costs themselves cost the state about $2.7 billion each year. So the fact that smoking continues at a high rate means that it costs the state $2.7 billion each year in healthcare costs. Additionally, a 2011 study estimated that 250,000 Black smokers' lives could have been saved if the 2009 restriction on flavored cigarettes included menthol flavoring. Arguably, the lives and health of Marylanders is worth more than the loss of tax revenue. Additionally, the increased tax rates on tobacco was supposed to be a motivation in reducing smoking in the first place. That's why we passed a tobacco tax to help reduce the rates of smoking. So I think the argument that we're going to have less smokers that would reduce our tax revenue is actually proving the point that that's the intention of the tobacco tax to begin with. In 2019, Massachusetts was the first to pass a comprehensive law that ended the retail sale of all flavored tobacco products. Studies have shown that the success of the Massachusetts law has been great. And compared to other regular sales in neighboring states, the statewide prohibitions were more impactful than e-cigarette specific flavored policies in reducing flavored tobacco purchasing overall. The policies included in this bill would have been proven to be effective in reducing the consumption of flavored tobacco products, which have spearheaded the rise in youth smoking rates. Some of the opponents may state that the FDA is already looking to expand their 2009 flavored ban to include things like menthol. But that has been in discussion for the last 14 years, and FDA has not taken any action to ban menthol products from being sold. And so FDA was actually recently sued by the African American Tobacco Control Leadership Council for failing to take action to protect the health of Black Americans by permitting menthol flavored tobacco to stay on the market. This is a long overdue ban on menthol that should take place for the good of public health. And I don't think that we can wait until FDA will take action because it's been a long time and so far no action has been coming. And so with that, I think the rest of the bill we've covered. Happy to turn it over to other stakeholders on this sponsor panel to answer any questions at the end. Thank you.
Thank you. Good evening, Madam Chair, and members of the committee. My name is Laura Hale. I'm the Director of Government Relations with the American Heart Association, here in strong support for this legislation. We truly believe that this legislation is the next step forward for protecting the heart health of all Marylanders. We know that flavors are addicting the next generation, and many current smokers started smoking because of these flavors. By removing these flavors, we know this is a proven policy that will be able to help, and we truly see this as something that will make a strong change. We ask for a favorable report on this legislation. Thank you.
Good evening, Chairman Griffith. Willie Flowers, NAACP Maryland State Conference. I'm here in full support of Senate Bill 259. And the NAACP offers strong support and not just token support for this legislation. And it's strong support for a lot of reasons. And one is the 75,000 people who die annually in this state. And that's a significant number because when we talk about the reality of crime and we talked about the reality of gun victims of gun violence, there's always structures put in place to mitigate that or to stop it. And I think this legislation is simple. The evidence is there about the loss of life, the loss and destruction of families and communities. And we are in full support of this and full support of every step to mitigate the use of smoking, but also the elimination of ads that contribute to long-time smoking and death. Thank you for your support.
Good evening, Madam Chair and members of the committee. My name is Megan Cassell with the Campaign for Tobacco-Free Kids, and we ask you to fully support Senate Bill 259. Maryland's made really good strides against tobacco use and nicotine addiction, and all of that is truly threatened because of flavored tobacco. When you look at self-reported data from high school students, 1 in 4 high school students will tell you that this is self-reported, that they're using e-cigarettes. And these are flavors like cotton candy and watermelon ice, mint and menthol. High school students and middle school students, they're also using products like cheap flavored cigars, like Banana Smash Swisher Sweets, and a Black and Mild cherry that you can get for 2 for 99 cents. And then when we're talking about menthol cigarettes, half of the high school students who are using cigarettes, they start with menthol, and it's no surprise because that's very intentional. Menthol cools and numbs and makes it easier. So please support ending the sale of flavored tobacco.
Thank you. Senator Hershey.
Thank you, Madam Chair. Senator, I'm just a bit confused. I thought a few years ago, we raised the age to purchase tobacco products from 18 to 21. Doesn't that include flavored tobacco as well too?
It includes flavored tobacco, but what this is actually targeting are there were exceptions that were in there. So it didn't include disposable flavored tobacco. It didn't include menthol. And so we're hoping that this will close some of the loopholes that remain as part of that. So we did raise the age, and that's a huge public health improvement, but there continues to be concerns with some of the flavored tobacco products that are out there. So it bans things like Juul that use the cartridge, but not some of these open-based systems where they're kind of mixing their own tincture, as well as the disposable e-cigarette type products.
You mentioned menthol. Menthol cigarettes were not banned for children under 21?
Smoking is banned for children under 21.
Right, you can't
but-
purchase this. You continue to mention youths in your testimony, and ma'am, you did as well too. So I'm confused on if you continue to mention that this bill is necessary to protect our youths. Why didn't the legislation that we passed that raised it to 21, why didn't that do the trick?
So I think it helped, but we know that there are youths that are not complying with state law, right? And youth are still able to access cigarettes, even with the restriction in place prohibiting individuals under the age of 21 from purchasing it. They are still able to get cigarettes. And the fact that these companies are targeting youth through marketing that's intended to capture that age group with, as you can hear, some flavors that really are intended to attract them to start smoking, they're still able to get these cigarettes illegally. So while it does help by raising the age to 21, we're still concerned about the public health impacts
All
here.
right, well, then that's a different issue. I mean, if that sounds to be more like an enforcement issue, we've raised it to 21, we've done what we could, but now you're taking this legislation now takes it a step further and says, we're going to ban this for adults, right?
We're going to
Adults are not
ban
able to make their own decisions
flavored tobacco for
adults,
everyone,
for adults,
including adults.
right? Because it's already banned for kids.
It's banned for kids.
Kids cannot do it. So, I mean, I think we should be genuine in the testimony when we continue to talk about, we need to do this for the kids and for the youths. We've already done that. Let's be honest and say, you guys are intending now to ban tobacco products for adults. You're taking away the opportunity for adults to make their own decision, right?
And I respond to that with two pieces here. One, like I said, it's still being marketed to kids. Kids are still able to access it. And
Not according to our laws or not.
right, but we know that not everyone's complying with our laws.
Well, then
right.
that's
And
a different
so
issue, Senator.
And so I think it's still important for public health to put this restriction in place to reduce the number of kids who get addicted at a young age, who are able to obtain their cigarettes illegally. And I think it's also important because, and I think the youth piece is an important argument, but it's not the only argument here. There are other folks, including adults, who continue to use this because of menthol and other flavorings that are in these tobacco products.
And I agree, but they're adults. I think I believe that they should be able to make their own decisions. And I think that we have taken the steps forward, which I agreed with, that if we can limit it for the youths in what we did from going from 18 to 21, that was good. I think this takes it a little bit too far. You've got a problem here that for some reason kids are able to get this illegally, but now you want to take away the option for all of adults. And I think that is going a little bit too far with this legislation. Thank you, Madam Chair.
Thank you. Any additional questions for the sponsor of this panel? I see none. Thank you very much for your testimony. Next, we have signed up Nelish Kali Anaraman, Darcy Curran Garber, Ashley Pagano, and Emily Scar. If you're present, please come forward. Apologize in advance for any pronunciation errors that I've made. And you can get started as soon as you're settled. Thank you.
Absolutely. Thank you, Chair Griffith and members of the Finance Committee. I am Dr. Nilesh Kalyanaraman, the Health Officer for Anne Arundel County and the President of the Maryland Association of County Health Officers. I'm here in support of Senate Bill 259. The health harms from tobacco products have been well documented for decades. And we're seeing that with electronic cigarettes and vape devices, they're the most common tobacco products being used by youth. Nearly 1 in 5 Maryland middle school students have tried an electronic vape device. It's higher in high school students, with 40% having tried it and 10% using a product 6 times or more in a month. Maryland middle and high school students nearly all report using flavorings such as fruit, candy, and menthol. Additionally, as we've noted, the tobacco industry has targeted flavors such as menthol to the African American community for decades. Prohibiting the sale of these flavored tobacco products, including menthol cigarettes, small flavored cigars, vape products, is a powerful step to reverse the recent increase in nicotine addiction, particularly amongst youth. So thank you for your time.
Good afternoon, Madam Chair, Madam Vice Chair, and committee members. My name is Darcy Kerwin-Garber. I'm an intern with MACHO, the Maryland Association of County Health Officers, and a graduate student at the Johns Hopkins Bloomberg School of Public Health. I'm speaking today with MACHO to support Senate Bill 259. Tobacco-related deaths and disease have significant financial costs to families, community members, businesses, and the state. Communities targeted by the tobacco industry, particularly Black and Brown communities and low-income communities, carry disproportionate burdens of these health and financial costs. This looks like $2.7 billion per year for Maryland in direct medical expenses and an additional $6.4 billion per year in lost productivity due to smoking. This can be when community members aren't able to fully function at work, when they have to take additional sick days, or when they're unable to continue to work at all. One of the best ways to slow tobacco-related loss of life and financial loss is to reduce the number of young adults who start tobacco in the first place. Banning flavored tobacco products will set the foundation for healthier and more equitable communities, a more productive workforce, and a more fiscally sound Maryland for the future. Thank you.
Good evening, Madam Chair and members of the committee. My name is Ashley Pagano, and I am testifying in support of Senate Bill 259. I will be making 3 points tonight. First, federal law does not preempt this bill. When Congress enacted the Tobacco Control Act, it made sure that states had the authority to adopt sale restrictions for tobacco products. Courts have routinely upheld flavor bans like Senate Bill 259 as sales restrictions. Second, Maryland should not wait for the FDA to enact a comprehensive flavor ban. The FDA's recently proposed rule only bans menthol in cigarettes, as well as menthol in flavors in cigars, but this bill will not become effective for years to come. SB 259 ensures that a flavor ban applies to ESDs and other tobacco products. Third, locals' authority to act in this area is uncertain. The Altadis decision forces locals to rely on the state to pass laws like SB 259. Thank you.
Hi, Madam Chair. My name is Emily Scar. I'm the director of Maryland PIRG, the statewide public interest group. We've had a long history of working on smart, common sense forms to reduce tobacco use. As you've heard, flavored cigarettes, with their unfortunate exception of menthol, have been banned in the US since 2009. It's time to close the loophole for other flavored tobacco products. They hook kids. An NIH study found that 80% of youth who ever used tobacco started with a flavored product. On a personal note, I spent the first decade of my life living with my grandfather, who was a pediatrician who quit smoking long before I was born. But it took me, my mother, my brothers, and full-time nursing care to take care of him as he lost his quality of life and ultimately his life to smoking. A generation later, my stepsister quit smoking before she had kids, but I've watched 3 of my teenage nieces start smoking e-cigarettes and saying, "Oh, I'll just quit if my lungs feel funny." And one additional note, we should just save the next generation from the what we've lost generations to previously tobacco use and make up for the gains we've made. We respectfully request a favorable report.
Thank you very much. Senator Beidle.
Thank you, Madam Chair, and thank you to my health officer for being here, Dr. K. Dr. K, is the concern really the flavored e-cigarettes? Is that what we're trying to get to?
The flavor is an attractant to children. And as Senator Lamb noted, the marketing is targeting children and is hooking them early. There's studies that show that getting youth using those cigarettes changes those brain chemistry pathways and keeps them addicted for life. If you don't start smoking early in life, it's much less likely that you will take it up.
But the flavors, other than, the flavors aren't really in cigarettes.
The
Right.
flavors are not into cigarettes. No, they're because that was not allowed, right? Except for the menthol. But in other products like cigars, the e-smoking devices, they are there.
I really have a concern about the e-smoking devices, and I hear about it in schools and from parents, and so I think that's the number one concern is how do we manage the e-cigarettes?
I agree, and at a personal level, my 5th grade daughter walked into a bathroom and saw one of her classmates smoking.
5th grade.
At 5th grade. I did not think I had to have that conversation until she got to middle school, and I was wrong.
Thank you for your testimony.
Thank you. I just have a quick question, I guess, for you, Dr. K, since I'll use Senator's nickname. the enforcement, the inspections, is it the local health department that goes to stores and makes sure that they're not selling products to youth?
So the enforcement is typically done via the health departments. We contract with police who do that typically through their recruits and trainees who are younger to do that enforcement. But the issue isn't that enforcement isn't happening. It's that kids are able to get their hands on it, as evidenced by the fact that they're smoking, right? When 40% of high school students say, yeah, we've tried it. I mean, we have to actually ask the question of how are they getting it? Is that something we're going to stop, or what is attracting them, right?
Right. I guess I'm wondering, kind of following up on the colleague's question, because I do know what happened to local public health funding since the 08-09 period. And I know that we've been under-resourced in that space. So I was just wondering if that had any impact on excessive, the fact that so many young people seem to have access to things.
I don't think that's the biggest issue in this.
Okay.
The bigger issue is that the flavors are a hook to get a new generation onto these tobacco products.
Is there like an illicit illicit flavor market? I guess I'm trying to figure out, because we're having all these conversations about cannabis, and I'm trying to learn from what we've already learned with tobacco and these e-cigarettes. Is there something that we are missing in terms of the illicit sales? Because it sounds like if they're not getting them at stores because we've already passed these provisions.
So it's a combination of there are sales that should not be happening, but then there's also being able to get it from others who do buy it for you, right?
Right.
And high school students and college students are able to get these just in the same way that alcohol is also purchased by those who are not, or obtained by those who aren't of age.
Right.
But typically what we're seeing is that they're getting it from either relatives or friends, and we don't have a way to regulatorily deal with that piece of it.
Wow. Okay. Thank you for that. Any further questions for this panel? Senator Lamb.
Thank you, Madam Chair. Just one brief question. A lot of the questions have pertained to youth and youth starting to use these devices, and certainly there's a huge concern there. But I think with the menthol piece too, that there's another component to this bill, that menthol is used to hook people, but also doesn't menthol also make it harder for people to quit?
So menthol tends to potentiate or increase the effect of the nicotine, and then therefore make it harder to quit as well. And so that menthol piece is particularly, as we noted, targeted to the African American communities for decades. And so it's made it, once people start, it's made it that much harder to quit, as you're saying.
Okay, thank you, Madam Chair.
Thank you. I don't see any additional questions for this panel. Thank you for your testimony. Have a good afternoon. We're now going to turn to, I'm going to try to call folks up 2, 4, 5 at a time. Kirk McCauley, Fred Parsons, Nashir Chima, Mark Halloran, and Candace Gott signed up in opposition to the bill. Did I call 6? Good afternoon.
Good afternoon, Madam Chair, Vice Chair, members of the committee. My name's Kurt McCauley. I'm with the WMDA Service Station Association of Convenience Stores. And since our testimony is cut down a little bit, I'm just going to cut right to the chase on the buying. Our retailers are the best barrier against youth smoking. They check ID. If they don't, they can lose their business. They check the ID. The only thing this bill would do would create a market out there that's already there. It would just turn into a robust illicit sales. You can go into Baltimore, you go to any big city right now and buy cigarettes. Lower taxes, cheaper price. This bill would put menthols and every electronic smoking device in the hands of people who don't check ID and they don't collect taxes. $340 million in taxes on menthol products last year. Thank you.
Good evening, Madam Chair. For the record, Mike O'Halloran here today on behalf of Mid-Atlantic Petroleum Distributors Association, in which our members include convenience store operators. Again, I want to be very cognizant of the time, but but banning legal and regulated products hurts legitimate businesses that you're going to hear from this evening. And it does so to the benefit of the illicit and unregulated market, Madam Chair, that you kind of alluded to in your questions of the previous panel. Consumers will still find a way to get their products, but in other jurisdictions, or worse yet, the aforementioned illicit market, where our retailers can't check IDs and can't keep them out of the hands of underage users. I think what you're going to hear from members today is that they're business people. They are tax collectors for the state, and I know certainly that's not the end all be all to the argument. But I think it's a very, very important factor, and that's why there are so many of them here today. Thank you.
Good evening, Madam Chair and Senators on the committee. My name is Fred Parsons, and I represent the George Falter Company that's been in Baltimore since 1878. We've been distributing legal products to retailers since that time. In 2022, we had a total of 306 employees. 298 of those employees were from the state of Maryland. They contributed $995,000 worth of state withholding. Our company collected on these flavored products that will be considered to be banned $48.4 million for the state of Maryland in OTP and cigarette taxes. And we're just a small part of what's collected. We're here to try and save our business. In this law, it says we will not even be able to store these flavored products in Maryland. We will not be able to sell to the Delaware stores that we currently sell to, or the Virginia stores that we currently sell to. In this law, this would put us out of business. Unfavorable.
Good evening, Madam Chair and members of the committee. My name is Nasser Chima. I'm a retailer, and I'm testifying against Senate Bill 259. I understand legislators' intentions are good, but unfortunately, Maryland has a chance to learn from Massachusetts ban. Massachusetts ban, the state lost $62 million in revenue. At the same time, the neighboring states, Rhode Island and New Hampshire, their sales were increased 24.3% and 22% sales. And in the same time, just like Senator said, we favored when there was age restriction change from 18 to 21. We did not oppose that bill as a retailer association, because we think this will reduce the teenager smoking in high schools and middle school. But if we ban these products, people are going to be selling these products in front of schools, and they're going to deliver in the neighborhoods. You're going to bring more criminals to your communities and more illegal trafficking of cigarettes. So banning is not a solution. I think is more solution is implement the law. We already have in books. So then people sell on the streets, nobody check anybody ID. So I request the committee to give an unfavorable report. Thank you.
Good afternoon, Madam Chair and Committee. My name is Candace Gott, and I'm a small business owner in the Maryland community and a member of the Maryland Vapor Alliance. Flavored e-cigarettes helps adults quit and then abstain from smoking. E-cigarettes is a new technology that should be viewed as a harm reduction tool. After all, combustible cigarettes such as Marlboro Lights and Newports remain the leading cause of preventable disease, disability, and death in the United States, and they are not fruit or cake flavored. The Maryland Vapor Alliance has collaborated with this committee and with our legislators, and we agreed with Tobacco 21, and we pushed for that legislation. Since Tobacco 21 was enacted, the United States as a whole has seen a decrease in teen vaping by 53%, according to the Youth Tobacco Survey conducted by the FDA. Tobacco 21 has done its job. If we want to move people away from a product like tobacco that kills them, why would we require them to use a product that tastes like the one that could kill them? It makes no sense. I'm asking for an unfavorable report on this bill. Thank you.
Thank you. Okay, let me just say this. I know you all are loving what you're hearing. But if I have to wait for the applause to die down, it's gonna just eat up our clock. I also want to say to everyone, I appreciate you acknowledging me and the committee before your remarks. We'll just put a blanket, Madam Chair, Madam Vice Chair, members of the Finance Committee. We'll establish that so you can save your time to make your testimony. The Vice Chair has a question followed by Senator Vital.
Just quick question. Shouldn't have said that. Does anybody know, can you buy the vapes online, on the internet?
Yes.
I mean, I don't care who answers, but one of you.
So with the PACT Act that was enacted federally, you can, but there are certain stipulations that a retailer or a manufacturer must pass before they can do so.
But I guess my biggest worry is, I just heard this on TV the other day, the vapes that you buy online could have terrible things in them.
So consumers are not supposed to be able to purchase them with the fact it's supposed to only be business to business.
Oh, so I can't go online and buy a vape pen or anything?
I'm not going to say you can't, but you're not
Okay.
supposed to
Well,
be
I'm
able
not going
to.
to, but that's okay.
Senator Vital.
Thank you, Madam Chair. I think my question is for Ms. Scott. So the FDA has approved the selling of e-cigarettes. I mean, is
So
that what
they're
I'm hearing?
currently going through a process called PMTA, which is pre-market tobacco applications.
Mhm.
And they are in the process of reviewing the data. Some e-cigarettes have been approved.
Okay, so where's the documentation that shows us that smoking e-cigarettes keeps people from smoking other cigarettes? Is there data? Is there a real study on that? Or does smoking e-cigarettes encourage smoking of other cigarettes?
So actually, there was a study conducted by Penn State. Adults who used flavored vapes to quit smoking often avoided relapse and were able to maintain abstinence longer. I can send you that study if you'd like.
That'd be great. Thank you.
Hey, just one more quick question to one person on this panel. The illicit sales, how is it happening? I want to ask you all, just like I asked the proponents, if youth are all the 40% of youth, they say are using something. How are
Well,
they
we have a recent enactment of a flavor ban in DC. DC already had a lot of hucksters selling cigarettes in front of their stores. There is no enforcement in DC. Person can drive up in their car, open their trunk and sell cigarettes out of the back of their car. They buy them in Virginia. There's a $44 profit built in because the tax in DC is $50 and the tax in Virginia is $6. So they can come and offer a bargain to the people on the street and sell them packs of cigarettes out of their trunk. The law that was passed in DC restricts the law enforcement from even hassling those people. Police officers aren't allowed to stop those people.
Gotcha. So there's an interstate flavored tobacco market.
Yes.
Okay, gotcha. Thank you very much.
301 would become called Tobacco Road.
Got you. I don't see any, it used to be when tobacco sales were in Southern Maryland, but I don't see any additional questions for this panel. Thank you very much for your testimony. Calling the next 5 names forward. Mubarak Siddiqui, Tyler Bennett, Ashad Mahmood, Parth Patel, and Matthew Milby signed up in opposition to the bill. Good evening.
Good evening.
If there aren't, if anybody's missing, let's see. Okay, I'm gonna keep going. I'm calling names once. So if you don't come, we're gonna keep moving. Michael Harrington, Michael Gotham on deck. Thank you.
Good evening, Madam Chair, members of the committee. For the record, Tyler Bennett on behalf of the Maryland Vapor Alliance. You've also, in the interest of time, you've already heard from Ms. Scott. You are going to hear from a couple of other of our members that are going to talk about some of the intricacies of their own businesses and the work that they do, keeping, converting folks from combustible cigarette smoking and working on cessation plans with them. But I would highlight, allude again to what Senator Hershey had to say about Tobacco 21. It was implemented in 2019. Youth e-cigarette use, according to the National Youth Tobacco Survey, was at its peak at that time at about 29%, and it is currently 14% as of the last year. Thank you.
Matthew Milby, I'm a small business owner in Maryland. I own a vape shop, and I just wanted to build on what Senator Hershey said. I think we passed T21. We need to focus on enforcement. You can go to accessdata.fda.gov or the Maryland website, and you can see all the violations of everyone that's selling to minors. You can sort by if a minor was involved, the sale was made to minors, and you'd be hard pressed to find a vape shop on there. Vape shops are the good stewards of compliancy in Maryland. And lastly, in the state of Maryland, we can buy flavored alcohol to get drunk. We get flavored cigarettes, cigars, and soon coming to Maryland, legal marijuana and a plethora of all kinds of flavored marijuana edibles. But for some reason, adults that want to quit cigarettes using flavored vapes, bad. Opposed.
Good evening. My name is Michael Harrington. I work with Petroleum Marketing Group. We're a fuel supplier that works with over 1,000 independent business people up and down the East Coast, of which 280 of them will operate in Maryland. These are the same individuals working at these locations that we all needed to provide essential services during the pandemic. They, along with their employees, family members, they continue to provide services face to face when there was no masks, no shields, and no vaccines on the horizon. Why did they do it? Because we needed them to do it. Now they need your help. These same individuals that are the good stewards and making sure that they are selling these products responsibly and to adults who choose to buy these products. All they're asking is to allow that to be. If there needs to be more enforcement, then there needs to be. Thank you.
Hi, my name is Mikael Goitem. I'm a small business owner in Baltimore. I've been in business in Baltimore for about 15 years. While this is a well-intentioned policy, it is not a good policy. As a business owner in Baltimore, I've seen many well-meaning policies and laws that pass that have unintended consequences. We're currently dealing in Baltimore with Baltimore City Police being unable to enforce marijuana drug dealers selling in front of our station. If they cannot arrest those drug dealers who are openly dealing in front of us, how do you think they're going to deal with people selling flavored cigars or cigarettes in front of our stores? They're not going to be able to address this problem. This is a complicated public health issue that cannot be solved just by banning something. Thank you.
How you doing? My name is Parth Patel. I'm a small business owner. It's the same question that everybody has, that how are we going to support our family and our business and pay our rent the same way where all the drug dealers are standing in front of your business doing what they're doing day-to-day lifestyle. We're banning menthol or banning the vapes. They're still going to do what they're doing. How are we going to pay our rent and pay the other stuff? So by the end of the day, we are losing all our sale and support that we need for the family and everything else. So we're not able to. So that's all I have to say against the law.
I see no questions for this panel. Everybody spoke, right? All right. Thank you very much for your testimony. We're going to call forward Robert Melvin, Riaz Ahmad, Rahul Ahuja, Denise Robbins, and Barry Margolis. I don't have time. Chris Hudgens, you come on up.
Good evening, ladies and gentlemen. My name is Riaz Ahmad. I'm a gasoline retailer and convenience store owner in the state of Maryland. 30% or more our store sales based on these tobaccos and other products are. You tell me that if this bill takes away my 1/3 of the business, how I'm going to be viable in the state where everything is gone? We have not recovered from the pandemic yet. It's been 4 years and we're still struggling. Now, this bill is going to take away 40%, 30 to 40% of my business away, and you still want to pay my taxes and keep my employees? That's not possible. It's not possible. We need to be diligent. Every state official we meet, the legislator we meet, everybody says the small business are the backbone of this economy. When this kind of bills are introduced and passed, that does not reflect that sentiments. It's totally against. My request is in favor of this bill, please. Thank you.
Madam Chair, Madam Vice Chair, my name is Robert Melvin, and I'm the Senior Manager of State Government Affairs for the R Street Institute for the Northeast region. We're a nonprofit, nonpartisan public policy research organization that focuses on free markets and limited effective governments, including in many areas, including tobacco harm reduction. We believe that while the intentions behind this bill are noble, it's going to do more harm than good for the people of Maryland. We've long been worried about the health effects of consuming combustible tobacco products, and candidly, this will undermine efforts to curb the use of those products, because many of the people that are trying to cease smoking are unfortunately going to be impacted by this, because they are switching to things like e-cigarettes, et cetera. And there's a lot of research out there that I've shared with your offices that shows that this is going to be more harmful than good. Please oppose the measure. Thank you.
My name is Lori Rodman, representing Century Distributors. We're a full-line convenience store distributor servicing over 2,000 retail locations in the Baltimore, Washington, Maryland, Delaware, and Northern Virginia. I'm here to express our opposition to Senate Bill 259. This bill is a direct impact on our business with our 200 employees and the retailers we service in the state of Maryland. We carry over 5,000 products in our Maryland warehouse, including frozen and refrigerated items, beverages, health and beauty aid products, as well as tobacco products. I will tell you that flavored tobacco accounts for more than 40% of all the tobacco products we deliver to these stores. I agree with your goal of protecting our youth and keeping adult-oriented products out of their hands. There has been some recent FDA-funded data that shows youth are 10 times more likely to drink alcohol, but that certainly doesn't mean those products should be banned either. And we will be in the same position as Falters, and that this will put us out of business.
Madam Chair and members of the Senate Finance Committee, my name is Barry Margolis, President of Cooper Booth Wholesale and a board member and treasurer of the Northeast Wholesalers Association. I'm here today to voice our association's opposition to SB 259. SB 259 is bad for business and promises results it cannot achieve. I'll give you two examples, some of which have previously been mentioned. Massachusetts was the first state of the union to pass a flavored tobacco ban. After the Massachusetts ban went into effect, tax stamp sales in neighboring New Hampshire jumped from 108.8 million to 123.1 million in 1 year alone. This happened at the same time smoking rates in New Hampshire dropped by 1.6%. There is no answer to this outcome other than the cross-border sales that occurred. Further, we see a similar story in New Jersey. In 2020, New Jersey enacted SB 3265, banning the sale of all flavored vapor products. Today, according to Grail Insights, it is estimated that 50% of all vapor sales in the state of New Jersey are illicit disposable flavored nicotine e-cigarettes. We oppose.
Hi, my name's Chris Hudgens. I'm with the National Hookah Community Association. I want to talk about something that's overlooked in this bill, and nationally, that's hookah. Hookah is a cultural tradition that started in the Middle East and India and Northern Africa almost 1,000 years ago. And since that time, it has been by nature a flavored product. So a ban on all flavored tobacco would eliminate all hookah here in Maryland. And that would also eliminate all hookah lounges here in Maryland, which are minority-owned businesses where people from these countries, first-generation Americans or immigrants from these countries go to socialize and communicate. Many of them do not drink for religious reasons, and hookah lounges serve as a gathering spot for them. FDA data shows that hookah use among youth is extremely low, roughly 1%, and that's about 10 times less than vape. And recognizing these points, the state of California, when they enacted their flavor ban in December, 2 months ago, they exempted hookah from that law. Thanks.
Okay, I see no questions for this panel. Thank you for your testimony. We are going to call forward Michelle Minton, Obi Chenamere, Finney Helmuth, Raj Singh, Matthew Bowe, yeah, thank you all for your patience. It's been a long day for you too, so we appreciate you. Feel free, whoever's got the mic, to get started.
Sure, I'll start. Hi, I'm Michelle Minton. I am a senior policy analyst with the Reason Foundation, a nonpartisan public policy think tank. I'm also a resident of this state, and I've been a scholar on public policy for about 17 years. And I don't think I've ever heard in my career someone seriously call prohibition smart public policy. That might be the first time. Moral, a requirement to protect children. Yeah, I've heard that before. And here we are again. Yes, I know menthol cigarettes are part of this, and we have an interest in helping people quit smoking, adults as well. I think literally everybody in this room probably would like to see fewer Maryland adults smoking and fewer Maryland youth experimenting with nicotine. However, not all of us would agree that that goal, laudable as it is, requires at any cost approaches like prohibition. There are other interests to consider here. So on the youth e-cigarette issue, which is, one of the, let's be honest, rhetorically, that is one of the big driving forces behind bills like this, behind flavors which hook children, as we've heard multiple times. Youth vaping has declined. Oh, never mind. You have my written testimony. If you want to hear more about how illicit markets will work in our state, please feel free to ask questions.
Good evening. Matthew Boley of Rifkin Wiener Livingston, here in opposition to this legislation on behalf of our premium cigar retailers of Maryland. They are our mom and pop brick and mortar retail shops that are adult only. What you did not hear the proponents describe is premium cigars. That's because it is a premium adult product that our youth don't want and our youth don't smoke. I would suggest that we do not belong in this bill. Thank you for our time.
Good evening, Obi Chenamere, also with the premium cigar retailers. On top of that, the average cigar retailers and cigar smokers in their late 20s, they smoke one cigar a year. And when you talk about the ways that cigars or tobacco is pushed towards children, cigar retailers have completely different markets, and therefore they have completely different marketing. They have completely different styles of reaching out to customers. And long story short, you're going to hear from two retailers who kind of do the work. So thank you for your time.
My name is Raj Singh. I own the Tinderbox in Waldorf, Maryland, particularly Charles County. We currently employ 16 full-time employees, and we primarily are in the business of selling premium cigars. Our cigars usually retail range from $10 to $12 per piece. These are not meant for the youth. We don't get the youth. The youth cannot afford this product. The only time the youth come in our stores is when we have a compliance check once or twice a year, which we pass with flying colors. Our product is not marketed towards kids. It is sold to full adults that are able to provide themselves with this comfort. If this bill is passed the way it is written right now without any amendments, it is detrimental to our business because, again, we only cater to full-time adults that are caught in the crosshairs of a bill that we don't belong in. Thank you for your time.
Good afternoon, and thank you. I appreciate you staying to listen to us testify. My name's Feeney Helmuth. I've owned and operated the Humidor Cigar Shop in Baltimore County for over 25 years with my family. We sell premium cigars, pipe tobacco, and accessories. 90% of my sales comes from those products, mainly cigars and pipe tobacco. That's all I sell. If this bill goes into effect, my biggest fear is I'm a 20-minute drive to Shrewsbury, Pennsylvania. My customers will drive there to find their product, or they'll find it online. It is available to purchase online. We've been down here many years testifying. We are, as a couple other people said, testifying that we're still recovering from COVID. So the more products that are taken away from us, it is going to hurt our business, and I fear that we will go out of business. Thank you.
Thank you. I don't see any questions, so thank you for your testimony. All right, our next witnesses, Wasim Chaudhry, Jiso Song, Ali Rabi, Saeed Salim, Abdullah Askar. Okay, I see three, so we'll keep going. Wada Naji, Atif Rabi. Okay, you can proceed.
My name is Wasim Chaudhry. I represent a few retail stores. As we look at DC, people are selling menthol and flavored tobacco products out of their trunks in the parking lots. This act will start throughout in Maryland, and also minors will have access to these products easily. As a result of the ban, tobacco sale will be down. There are very high taxes on tobacco products. Laws in the tobacco sale will result less taxes in the state. And our state budget, our tax state budget should be, lot less than before. And this shortfall can cause an increase in other state taxes. For example, income tax, property tax, and sales tax to come up with the difference. And also the unemployment can go up. I think we should, I'm voting against this ban. Thank you very much.
Senators and Chairman, my name is Saeed Salim. I'm the owner of Tobacco King. We have over 80 locations in Virginia, Maryland, DC, Ohio, Pennsylvania, Indiana. And the flavor ban that happened in DC has actually increased the crime rate in front of my store. I do have people sell out of their trunk. You can come witness it in person, not a problem. And if it's gonna happen in Maryland as well, we will end up closing the stores just like how we close in DC, which we don't have a problem. It's just gonna affect the states, it's gonna affect the employees that we have, over 200 employees just in Maryland. And this is gonna open a loophole for many of the black market that are willing and ready to sell in the state of Maryland. Thank you. We oppose this bill.
Hello, my name is Ali Rabi. I'm also from Tobacco King, but I'm not gonna stress what my brother stressed about employees only, because he already stressed that, and 200 people would lose their jobs once we close down. We have closed in DC due to people coming into front of the shops and selling it out of their trunks. Now, what I want to say is, what's the difference between the choice of smoking tobacco and the choice of drinking alcohol? I've never heard of someone walking down the street and dying off smelling a cigarette, but I've heard of someone innocent just walking down the street and getting hit by a drunk driver. Why don't we stop drinking? Right? It's a choice that adults make to smoke or drink. And it shouldn't be a bill to stop flavored tobacco. Every adult want to smoke, and it's their choice to choose the flavor that they want to smoke. We should enforce the 21 and over for sure, and that's we do 100%. But that's where the problem lies, in enforcement, not in banning the product. People will get it regardless if we ban it or we don't, because we've witnessed that in DC, and people still buy it off the street in front of the shops. Thank you for your time.
Thank you very much. I don't see any questions, so thank you for your testimony. Colleagues, we're going to shift gears for a moment. We have one in-person witness that was trying to sign up in favor of the bill, got him on the wrong list. So we're going to call forward Marcus Ross, and then we're going to move to our virtual witnesses. Is Marcus? You've been here all day, so thank you very much.
Yes, of course. Well, first of all, I'd like to thank you, Chair Griffith, and all honorable members of the committee. Hello, good afternoon. My name is Marcus Ross. I am a senior at James Reed Blake High School, and I am a member of the Maryland Students for Education Equity and NAACP Youth Council. Now, I have always been an advocate for positive change in my community, and I'm no stranger to the effects of flavored tobacco and the damage it has done to my community, more specifically Black and Brown youth. Now, many of my peers who have experimented with these products have told me that it helps them focus, decreases their anxiety, makes them feel more like themselves, and most importantly, that they are not addicted. Despite my warnings towards these products, the use continued, and soon the topic of flavored tobacco products has become very prevalent within my school. My first encounter with tobacco use was in the 7th grade. A childhood friend I'd known since elementary school somehow obtained a flavored e-cigarette. And I remember this memory vividly because I remember how excited she was to use it and how she was so infatuated with the way it lit up when she inhaled the smoke. Where, how, and why she got the e-cigarettes are questions I did not know the answers to at the time. Now, my question is, what kind of learning environment are the youth of today growing up and that they feel as though the only way they can get through the day is by consuming these nicotine-infused products? What kind of environment are they in that they even have the ability to access these products in the first place? And what kind of example are we setting for the youth of tomorrow? I asked for a favorable report on the flavored tobacco products prohibition bill. Thank you.
Thank you. Any questions for this witness? Thank you very much for your testimony. Colleagues, we're now going to move to our virtual witnesses. Speaking in favor of the bill, Alex Casper, I think. Good evening.
My name is Alex Casper, and I'm the Director of Advocacy for the American Lung Association. Thank you for the opportunity to provide comments. You have my written comments and have heard from many of my colleagues, so I'll just keep it brief. We strongly support this bill as a way to address tobacco use in Maryland. The Lung Association encourages states to look at evidence-based policy measures to address this epidemic, including the measure before you that would remove all flavored tobacco products from the market. The critical word here is all flavors and all products. If you leave any flavor or product on the market, users are likely to switch to that product versus quitting. Maryland, we support evidence-based cessation tools as well, which are covered in Maryland. We know you have difficult decisions before you, and we ask for a favorable report for this bill.
Thank you. I don't see any questions, so thank you for your testimony. We're now going to turn to Elizabeth Hicks, who signed up in opposition to the bill. Good evening.
Hi, I'm Elizabeth Hicks with the Consumer Choice Center. Simply put, this bill will do more harm than good if passed. Studies have shown that vaping is 95% less harmful than smoking. Adults who use flavored vaping products are 2.3 times more likely to quit combustible cigarettes, and that flavor bans push consumer towards combustible tobacco, specifically those aged 18 and under. We know that smoking-related illnesses are serious and can lead to cancer. After being around secondhand smoke most of my life, this past year I received my very own cancer diagnosis and an undergoing treatment. And I can assure you, I would not wish this on anybody. Embracing vaping as a harm reduction tool here in Maryland will help ensure that your citizens are less likely to end up in a situation similar to mine. If a flavor ban is enacted in Maryland, consumers will look towards the illicit market in order to get access to their preferred products. Additionally, unlike vape shops, the illicit market does not abide by age restrictions, therefore making it much easier for youth to acquire these products illegally. This unintended consequence would only exacerbate the problem Maryland is trying to fix, making this particular bill unviable and achieving its desired outcomes. I'll close with, I know this bill is well-intentioned, but it's important to embrace smart, science-based policies. And in that vein, I urge you to issue an unfavorable report. Thank you.
Thank you for your testimony and for waiting. Our final witness in the virtual space and on this bill, Dennis Hull, who signed up in opposition. Good evening.
Madam Chair, members of the committee, we are also committed to a data-driven approach, and the scientific evidence is overwhelming. Flavored vapor products are safe, they're effective, and they do save lives. Not only are they 95% safer than cigarettes that we know to be deadly, but they are the most effective way to quit smoking and stopping this deadly habit. And flavors are obviously a very important part of incentivizing these smokers to make the switch. Doctors in England now prescribe flavored vapes for this very purpose. And I'll also point out that there is no youth vaping epidemic. This is a myth based on anecdotes and manipulated data. There's been no increase in nicotine dependency among youths, and the CDC has found only 3.1% of teenagers use e-cigarettes on a daily basis. Our kids are simply not addicted. However, the lives of very real people literally depend on your rejection of this bill. If a majority of smokers in Maryland alone switch to vapes, we're talking about more than 130,000 lives that could be saved. We should give them every incentive to make the switch. We've included a fact sheet and our sources along with our written testimony. I urge you to read those and to firmly reject Senate Bill 259.
Thank you very much. I don't see any questions, so we thank you for your testimony. Thank you for staying. And colleagues, that concludes the hearing on Senate Bill 259. It includes our hearings for today, but not our work for the day. We are going to take a 5-minute break followed by a voting session. Thank you all for joining us. Have a good evening.